Before others join, let me tell you that FDPPI, the Foundation of Data Protection Professionals in India, has around 200 members. Most of them are CISOs, CTOs, and lawyers, of course. There are a number of lawyers. And we have a small chapter in Chennai. Mr. Dorai Kannayan is there, Mr. Sridhar is there, Balu is there. They are all active members. Krish is there. Then Govind, Vaidi. So we have a number of active members in Chennai, which happens to be, as I told you, almost my second home, because at the critical time when Information Technology Act developed in India, I was a resident of Chennai, and I used to work very closely with the law enforcement. Balu represents that law enforcement, setting up the cybercrime police station. I think I first met him in the National Police Academy. For example, we conducted a 3-day training on cyber crimes to the DSPs. Okay. Since then, I have been involved in a number of activities of the cybercrime police station in Chennai. In a way, we try to establish that the police also can crack cyber crimes. In fact, the first cyber crime which went into conviction, that Suhas Katti case, happened in Chennai, and Balu was the investigating officer. The first civil case in which liability was fixed under Information Technology Act, that was the Uma Shankar ICICI Bank case, also happened in Chennai. So Chennai has been the first to many things. Okay, I have been happy to be part of those things, and this particular conference also is a first of its own kind. We did have a short program in Bangalore, but not to this extent. And we are trying to actually focus here the compliance view of Data Protection Act. As most of you are aware, India has been trying to get this act for decades now. In fact, in 2006, one of the bills called Personal Data Protection Bill 2006 was presented in the Parliament along with the Information Technology Act Amendment Bill 2006. Okay, that ITA Amendment Act 2006 became 2008 and it got passed. But everybody forgot about this Personal Data Protection Bill of 2006. So when we are talking of 2022, DPA 2021 or 22, we are actually having a history of legislations from that day. And every time government wants to come up with a legislation, there is always the problem of balancing the requirements of the industry on the one hand, privacy activists on the other hand, and the government itself. We heard Mr. Ravichandran talking about the huge amount of data which is in the hands of the Income Tax Department. Of course, you also saw that when he was talking of his participation in data protection activities since 2000, we are talking of not personal data protection, actually the overall data protection. In fact, the distinction between this personal plus non-personal data and personal data came only after the privacy became an important aspect. That is why even today, cyber security and personal data security, the distance is very difficult to imagine. In fact, that's why JPC, Joint Parliamentary Committee, ultimately decided we will call this Data Protection Act instead of Personal Data Protection Act. Actually, they took an easy way out to merge the two. But from compliance point of view, it creates a lot more complications, because today if you want to say that Data Protection Act we will continue to call it as DPA 2021 because that is the name in the bill. When it is actually passed, it will become DPA 2022, hopefully, if it doesn't go to 23. Okay, so I will try to call it as DPA 2021 for the sake of understanding. So this DPA 2021, government says, earlier it was called PDPB, Personal Data Protection Bill. So focus was on personal data. Now, title has been changed. And in the applicability clause, they said this act shall apply to non-personal data also, including anonymized personal data. Okay. And suddenly everybody became confused. What happens to Information Technology Act? Information Technology Act is anyway today a data protection act in terms of both personal and non-personal data. That if any contravention of Information Technology Act is there, we have both the civil liabilities as well as the criminal liabilities. So it is a data protection act. People don't realize that India already has a data protection act since the year 2000. So this act is now called Data Protection Act. Now we need to actually see where do we draw the boundaries between this Data Protection Act, which is principally a personal data protection act with one or two sections added for non-personal data, versus Information Technology Act, which is principally for, let us say, non-personal data. After this, we have to consider it like that. But you cannot say that ITA 2000 is not applicable for personal data. So it will continue to have impact, particularly when it comes to criminal offenses, because Data Protection Act DPA 2021 will mostly focus on compliance. Okay, before a data breach happens, what an organization should do in terms of compliance, and what is the penalty if they don't have suitable measures. That will be the focus of DPA 2021. After the data breach happens, ITA 2000 also will wake up, because the certain director is there and criminal offenses are there. Somebody may go to a criminal court, police will come in, and corporates are more afraid of being in jail for 2 or 3 years rather than 100 crores fine. 100 crores fine my company will pay. But if I have to go to jail even for 1 day, I will have a problem. That is the Bazi.com case. Avinash Bajaj fought for 8-10 years with Supreme Court to avoid the criminal liability. Nobody was worried about any civil liability at that point of time, because it will kill the career of a professional. So Information Technology Act will continue to be relevant even after DPA 2021 comes, though we need to find out the difference between the two. In fact, this is a challenge. In fact, this is a legal challenge for compliance people. Where does ITA compliance end? Where does DPA 2021 begin? Or how do they both combine? In fact, that is why our framework, which we are going to discuss in detail later on, Data Protection Compliance Standard of India. Earlier we used to call it as PDPSI, Personal Data Protection Standard of India. Now after this title change for this act, I said we should call it as Data Protection Standard of India, because this act itself says it is applicable to some parts of non-personal data, so I have to bring in that. So we have got a DPS-CSI, that is Data Protection Compliance Standard of India, which is inclusive of ITA 2000 compliance. So when some organization goes through the DPS-CSI framework, you can say that they should be compliant to not only DPA 2021, but also to ITA 2000, because otherwise the compliance is not complete. Okay, so that is the change which this new Data Protection Act has brought in. And as I was telling, from 2006, then this this Aadhaar judgment came. In fact, I think Ravichandran was also mentioning that linking of Aadhaar to property transactions, when it was proposed, that was the biggest trigger point for this privacy people to say that there is something wrong as far as Aadhaar usage is concerned. That is why the Supreme Court case was triggered. And then most of you are aware how it gave room to this particular act. So 2006 one bill was there, it got relegated. 2018, the Sri Krishna Committee report was there, its version. Then 2019, now we are standing at DPA 2021. Every time when the bill is presented, there is opposition. There is some companies who will always be not happy. So, people will quote surveillance, Telegraph Act, and somehow government loses its momentum and postpones the implementation. That is what is happening for a long time. So what I am trying to say is, all these objections will continue to be there. Okay, government having more powers than what is necessary, or companies not being properly prevented from collecting personal data. These two complaints will remain. Privacy activists will never be satisfied with any law, whether it is GDPR or anything else, and they will continue to have their complaints. In fact, the day GDPR was made effective, 25th May 2018, cases were filed against Facebook and Google, and it took 2-3 years. Then Privacy Shield itself was dropped. So it will continue to be there. And in India, we are always fighting against the government. We say surveillance Raj or something like that. It will be there. But we in the corporate sector, I feel we should steer clear of this. Let us understand and accept that there will be no unanimity. Okay, just as in the parliament, opposition and the ruling party there will be no consensus. That's why JPC also there was no consensus, there was dissenting notes. And it is not unnatural, it will always be there for various reasons. But we in the industry should not be distracted with these complaints, and we should look at compliance. Now, okay, ultimately let us say with one magic, government passes it through. In fact, we all know that if the government really wants to pass it, they can pass it even now. Okay. If it passes, then we will not be able to say, hide behind section 35 not good, or 33, 34 data localization is not acceptable. Those become irrelevant. You have to immediately look at what needs to be complied with. That is why FDPPI, we are bringing the focus on the compliance view of DPA 2021. I am not bothered about any other view. Then we will make some progress. It is like you say sometimes, low-hanging fruits, you have to catch that first. Okay. So, I would like to urge the entire industry to stop complaining and start our journey towards compliance. I call it as a journey because compliance is not an overnight possibility for any company, however good we are. If we start today to make all our, say, 1,000 employees, 500 employees, or even 10 employees to understand the privacy and assimilate that culture, it will take time. Okay. So then the question of having technology tools, policies, it is a time-consuming affair. Some of you must have worked with large organizations. Even 6 months is not sufficient for a GDPR compliance, let us say, activity. And PDPA compliance is bigger than GDPR, because GDPR is only personal data, and only personal data coming from EU region. Here, I am saying personal data, non-personal data is mixed up. So compliance to this DPA 2021 is more complicated. So therefore, I need more time, more than 6 months perhaps. So if the government gives me 2 years, entire 2 years will be required for me to actually put up the things. So we need to build a culture in the industry that let us not be distracted by the compliance. Media will continue to write about this. They will say that this law will never come, and if it comes, startups will get affected, our index of ease of doing business will get affected. So many things media will write, and it is their business to write. We in the industry should not be diverted. Let us participate in the discussion if possible, but at the same time quietly undertake compliance measures. So I would like companies to start their journey towards compliance, which also means that we as professionals who are auditors, who have to actually help these companies, we have to start our journey earlier. Because if a company today calls you and says, what can I do for DPA 2021 compliance, you cannot start reading it today. Even before the CEO of the company reads about this, at least 3 to 6 months back, you should have read it. Then only you will be able to answer that phone call. So as auditors and professionals, you need to have even more, control over this act. So that is the reason why I want people to look at compliance, and we shall assume that, yes, this act is inevitable. It will come, if not today, next 3 months, whatever it is. Let us start our compliance. Some compliances, of course, will come later. For example, registration and other things will come later. Another aspect I want the companies to realize is that let us not have the complacency that until the act comes, no damage will occur to the company. Okay? People will normally say that, okay, let the act come. Today nobody can come and ask me. It may be true in the case of Information Technology Act, where unless you prove the cause of action and say that one XYZ has suffered a damage, then only he can go either to the adjudicator or to the court. Okay. Whereas this law is not like that. Even if there is no data breach, even if nobody has suffered a damage, compliance is still required. Okay. Until the act comes, perhaps you can say that damage will come only when there is a non-compliance recorded or cause of action arises. After that, even if there is no data breach, there may be a couple of crores of fines. That is the kind of situation we are coming to it. So that we should start working now, try to learn, we will make mistakes, and probably by the time it starts hurting really, then we will be better prepared. In some countries, when data protection law was introduced, they gave time for implementation, 1 year or 2 years. Then after that, they said the penalties will not be imposed for another 6 months or 1 year. So they gave different time slots for implementation and then imposition of penalty. India also may do that. We are not expecting that there will be 100 crore fine on day one. Okay, but you may get a letter from the DPA saying that, show cause why I should not impose 100 crores fine on you. That is sufficient to shake up the organization, because you have to find the defense for actually going into that compliance activity. As you have seen in the last 1 year, there have been many court cases, one in Madras, one in Odisha, and in Delhi. In 3 court cases, and recently also in Bombay. Okay, 4 cases, courts have quoted right to forget is a right to privacy. Okay, in our law, where is that law? As of now, it is not there. But they are quoting from GDPR, they are quoting even from PDP bill. In fact, the Odisha court quoted sections of the Personal Data Protection Bill 2019, which most of you say it is only a bill, why should we worry about it? It is not even the DPA 2021, which is JPC approved version of PDPB. Which means courts have started looking at the environment. What is the industry expected to do in India and outside? And they are using it in their judgments and using it for giving decisions. Today it may not be a decision to impose penalty, it is only a decision to do certain things, directions. Okay? But if a court can recognize sections of a bill which has not yet become law and incorporate it in its judgment, then some innovative judge may say that why can't we impose a fine? Because PDPB or DPA says 4%. So for this non-compliance, I will order you a fine. Okay. In fact, after TRA, this thing and others have come, the penalty levels have increased to crores. In IPC and others, we were only looking at thousands. In fact, IDA 2000 increased it to lakhs. Only now we are talking of crores. Now we will be moving into hundreds of crores. So in a judgment, courts may come up with the penalty recognition also. So worldwide it is a practice to impose hundreds of crores for such kind of violations. Because you have this GDPR example, 887 million US dollars fine for Amazon. Why? Not because, say, 10 million data was leaked or something like that, but because the court felt that the compliance is not good. So it may leak. Okay, so prospectively, expecting that if you don't tighten up your security, you may cause hundreds of lakhs of data leakage. The Luxembourg Supervisory Authority has said, we will fine you 887 million US dollars, equivalent in euros. Okay. So some court may say, globally it is a practice to charge thousands of crores of fines. Why can't we put 100 crores to this X company which does not have anything, it has caused a leak or something like that. So companies should be ready for that kind of a situation in India. Okay. So now the question for companies is, what should I do then? Okay. I am not a privacy activist. I am not a Prashant Bhushan. I am not worried about some XYZ individual. In fact, I am concerned to see that why people are bringing this human rights into my boardroom. Okay. I am a commercial entity. I want to make money. And now you are quoting some human rights kind of an issue called right to privacy and say that you have to comply with it, otherwise I will put you 100 crores fine. Companies are concerned. So I am not worried about really protecting the privacy of individuals, though we may talk about it. In a press conference, I may say, I have got corporate social responsibility, I want to protect the privacy of a very Indian individual. But strictly speaking, we want to do our business. And do it in such a manner that we don't break any law. So our focus is, I want to be compliant, so that I will not face this 4% penalty, to be frank with you. Okay. Privacy by design, security by design, they are all part of my compliance by design. Okay. I suppose I am honest in talking like that. So if in a public forum we may say that, no, I want to protect the privacy of everybody. You know, that I as a CEO or a board, I am only interested in seeing that my company does not face any penalty. If you say for not facing the penalty you require privacy by design, I will do privacy by design. But if you simply say you have to do privacy by design because Indian Constitution recognizes right to privacy as a fundamental right, I will say there are so many rights which I am violating, why I should concern only about this. Is it not? So that is why we are using the terminology compliance by design, which is inclusive of privacy by design. Privacy by design is inclusive of security by design, at least as it refers to personal data protection. So when we say compliance by design, we are saying that government has brought out a law and say that if you don't comply, 4% penalty is there. I want to therefore comply. That is compliance by design. Design does not restrict me to the technology aspects. It is not that I have to call only the CTO and say, please do this. The entire business, the vice president marketing, the CEO, they are the first persons who should be aware of what is required for compliance. Before you go into a trade negotiation and sign some contract, you should know that when you sign this contract, this is the data protection related consequences which will be there. Whatever I am quoting is maybe pre-DPA 2021. By the time I start implementing, there will be DPA 2021 in India, my costs will increase. So that consciousness should be there in the business person. That is why the management people should be the first to actually absorb the general requirement of data protection law, how it affects business, and then translate it into the compliance requirements of writing policies, which can be done by a compliance officer or a lawyer. Technology, a CTO can do, but the decision to be compliant lies with the board. That is the reason why Indian law says a data protection officer should be a key managerial person. KMP. A KMP under the corporate law is a person, the other persons in the group are CEO, CFO, the independent director, company secretary. These are the kinds of designations which fit into KMP definition. Now the DPO also is put in that group, which essentially recognizes that the activity of a DPO is at the business level, at the top, say, level in which you have to make policies. It is not about privacy policy. Privacy policy can be written by some third level, fourth level employee, but the policy to write a privacy policy should be taken by the board. In fact, in many of the Information Technology Act cases also, see, when we actually, Mr. Rajendran is well aware of this, when we took this Uma Shankar's case, one of the respondents in that which I added was Mr. K.V. Kamath, chairperson of ICICI Bank and BRICS thing, big man, no doubt about it. But we added him as a respondent. Why? It was the responsibility of the bank's board to actually have a policy for information security if they have failed vicarious liability under Section 85. So that way, I say management has the prime responsibility. So having this in the MMA is ideal for that reason. I want CEOs to recognize. Let us not blame a CISO or somebody to say you did not have the security, because he might have tried. Many times the second level people also, however senior they are, they will try, but they will not get the board support in terms of finances. CFO will say, I don't have money. What will you do? Okay, then you should ask the CFO, then at least take cyber insurance. You take for 500 crores or 1,000 crores, then I am happy. I will do whatever I want. You have a cyber insurance for 1,000 crores, then it's okay. Then he will start thinking, oh, what will be the cost of 1,000 crores cyber insurance? Can we reduce it to 200 crores? Then you say you are coming down to our mitigation policy. Now, if the risk of cyber insurance requirement has to come down from 1,000 crores to 200 crores, then these are the things you have to do. Now, the cost you are saving in terms of premium, 0.5% or 0.25% of 1,000 crores, you please set it aside for DPO salary and information security and other things. That is how you have to bring the other KMPs into our compliance kind of a thing. That is what we are highlighting when we say compliance by design is our focus. Now, this act itself, I am taking a little longer time here because we are going to have panel discussions. We are going to have a panel discussion on law and then technology, then the professional opportunities for data protection officers and auditors, and then the compliance frameworks. But to really participate in those discussions, I feel that all of you should be aware of certain basic things. That's why I'm taking some time. Now, this particular DPA 2021 within itself has a section called Section 50, which says different industry segments, if they want to develop codes of practice as applicable to them for compliance, I am willing to consider, that is, Data Protection Authority is willing to consider that and accredit. You don't have to be bound by an ISO 27701 only or some other framework only. The law says that if you feel that you are an industry segment like an SME or MSME, you will not be able to implement ISO 27701 along with 27001, etc., which will be expensive. Then the law says, don't worry, come back to me, give me a proposal that this is the compliance I am going to do, and this compliance meets the requirements of your law. So give me the option to use that as a code of practice. If actually the government is telling the industry, develop some self-regulatory practices and bring it to me, I will approve it if it is good. So that is there in Section 50 of this particular act. And this was also there in Information Technology Act and other things. Only thing is we never look at law. We think law is made only by the government, and either we oppose it and be non-compliant and face the consequences, or we keep blaming the government. But government sometimes gives us an option that you are an association, you please come together and develop a acceptable code of practice and then come back to me. I am willing to approve that. So there is that provision. In fact, that is where FDPPI is now focusing. We have developed this general umbrella code of practice, which we have called as the Data Protection Standard of India, Compliance Standard of India, and it is good enough as a general framework. But compliance have to be customized. See, what is good for Infosys cannot be something which can be implemented by some smaller company. What is good for health industry may not be sufficient for fintech companies. So depending upon or even educational institution, or even MMA. Now MMA also has to be data protection compliant, Ramesh, is it not? There is no exemption for NGOs or government organization. IT department also has to be there. Now, can you have a single framework for different sectors? It is not feasible. If you think of that, then every time when the complaint goes to the data protection authority, then we will start discussing with the data protection authority, sir, you have asked me to do these things, but this is not relevant to me. This is not relevant to me. So you are pushing this discussion to a case by case discussion rather than working earlier and creating a framework. This is for banks. Even in the banks, SBI and ICICI Bank, HDFC Bank, let them follow this. I am only a Repco bank. I am only a cooperative bank. How can I put things which SBI can put in? I need a simplified framework, not opposing the principles of privacy, but within that principles of privacy, I want some way by which my thinking actually is taken into account. This sectoral development of codes of practice is what FDPPI is trying to some may encourage. Of course, we have developed our framework. I am saying that even this framework, I don't say it should be imposed on everybody. But within this, we have got 50 implementation specifications. We are willing to say that out of this, something is not applicable to this, something is not applicable to this. But for example, we have included in our framework, which we will discuss in the last session, some concepts like data valuation. That is, the amount of data which an organization holds should be converted into rupee value and brought into the balance sheet is one of our recommendations. But at the same time, I know it is not that easy. There are so many issues. So if an SME says, sir, I can't do this, as an auditor, I will not say I will give you 0 for your audit. I will consider that for your context, maybe we will say that this is a different, it's not required. This is what I want the Data Protection Authority to say when they approve a code of practice. And they say code of practice for a small entity. You know, the Act also has got something called small entity. Okay. But small entity is really, it is not an exemption at all. We will discuss that later. If you are using computers, it is difficult to classify as small entity. Only manual processing, you will become small entity. So a very small entity have to be compliant with 99 sections of this the Data Protection Act. It is a big challenge. So if we can create a SME framework and then get it approved, probably data valuation will not be there. So that is the kind of customization at sectoral level which we are talking of. Hotels, all hotels, we may have a particular hospitality industry if you want, which may combine hotels as well as, let us say, the OYOs and others, and even the hospitals, or each segment separately. We want to have codes of practice for each individual segment. It is feasible, it is provided in the Act, but industry should respond. If industry wants to keep quiet and when the Act is brought in, only start complaining, that will not be a proper approach. And FDPPI is trying to suggest to industries that our job is not to complain. So many people may think I am trying to support the government when I say this. I am not trying to say that supporting the government. I am saying law is made. If I don't like the law, I have to go to the parliament and fight and change the law. That is a different this thing. If I cannot do that, if the law becomes acceptable, if this road in front of you or this thing is made one way, I cannot say I am unhappy and I will drive the opposite way. If I want, I can have to go and find the commissioner and say, this is not required, you please change it. But once it is made, I cannot drive against it and refuse to pay fine, like people do in tolls. No, we don't like toll payment, but we can't fight it there. So, likewise, this law, before it comes, industry should respond. So, we are trying to develop this self-regulatory practices, and we are looking at interested corporate people who can be members, corporate members of FDPPI. We want to develop these codes of practice, and in a way, within that sector, that company will take the leadership. It will become an association leader. There may be a separate association, but for data protection compliance, you become a forum. Don't call it as an association, don't complicate it with a society, trust, and all these things. A Section 8 company, we don't require that. A forum of, say, 10 people in the industry, say hotels in Chennai, okay. Let them frame a framework. Then let us see how it is accepted by the Hotels Association, and then later on we will take it to the DPA. This is the kind of concept which we are trying to do. I don't think so far any other NGOs have tried this kind of a thing. As many things we do are first things, okay. This is also one of the first things, okay. But before we work on this code of practice, obviously we should know what is the law. So the essence of what we are going to discuss is because of that. But at the end of this, one of the requirements I have is for industry captains to come forward and work with us and start developing this. Now, that is the reason why I am not unhappy with the government postponing it. The more they postpone, they are giving more time for us to do some preparatory work. That is how I look at it. So, with this objective, if you look at the Act, which we are going to discuss in detail in the different sections, I would like to say that this particular Act which we are discussing, the essence lies like any other Act. That is, the objective of this Act is to protect the privacy of individuals. The law applies to some kind of data, so we should know which kind of data it is applicable. And then it prescribes some actions, which is the data processing requirements, and then compliance requirements by default. There are penalties, and penalties may go up to 4% of the global turnover. There is also one section which talks of criminal penalties, which extends to individuals, corporate executives. So the CEO, board of directors, there can be vicarious responsibilities. This is the essence of Data Protection Act 2021. Okay. Immediately following this, we have a session on the legal aspects. So some of the other things, I will take it up in the panel discussion where Rohan and Geeta will also be there. We will discuss. I have got more points, but instead of discussing it here straight away, we will take it up in the panel. Then we will get into the technology aspects. Now, we as lawyers will be saying that all this is there in law, you have to do it. Now, the next question is it feasible? Many people will say, no, this is not possible. The persons who made law, they don't know technology, so they have rights, anything they want. So, it is our responsibility to also find solutions which technology people can implement. So, that is the next session. Then we will discuss the important aspect after lunch, okay, that is the data protection officer and data protection auditor, two very important professions which are being generated by this Act. Data protection officer is an employee, so people who are working in organizations should look at their promotion to being a DPO. DPO is at the KMP level, so it is beyond your CTO, CISO, CCO's kind of a level. Okay, directly you are touching the board. Okay, that is a career opportunity. Then as a data auditor, you are talking of an entrepreneurial activity. See, the Act says that every significant data fiduciary should have a mandatory data audit by an independent data auditor. once in a year. And it recommends concurrent auditing, which means that this auditor doesn't come only once in a year. You have to develop something called concurrent auditing, which means that at least month-wise, there will be somebody who is asking, please send me a report. That is concurrent audit, I will sign it off. So there is a continuous oversight into the operations of a significant data fiduciary by these independent data auditors. And the government of India may prescribe an examination, so many things. We don't know what will be the criteria for data auditors. DPA has to accredit. What we are doing is we are already conducting our DPO training and other things and preparing the people to take the examination. Like in the patent, you have got a patent examiner kind of a situation where the government conducts an examination and accredits patent officers. Before that, IIT conducts a training for such people. Likewise, we are conducting training for professionals from what we think is necessary to be a data auditor. And then when the government comes with their own credentials, if they fix an examination, you should be able to pass that examination without a problem is our thought process. So these career opportunities we will discuss in section in panel 3. And last panel, we will come to more practical terms of what framework shall we use. And what is that you are talking of data protection compliance standard of India? How does it compare with ISO 27701, maybe PCI DSS, maybe something else? So that discussion we will do it in the last session. So this is our plan. I will stop here. Before we start the panel, if there are any questions, you please let me know. Otherwise, we will start a panel which will have Geeta Jayaraman, GRC expert, and Rohan George. Yeah. Pardon? In fact, JPC wanted to avoid this turnover-based thing. I don't know whether you are aware. From the PDPB 2019, when JPC gave the first version of this thing, they said in India we don't have penalties based on turnover in other laws. Whatever law, we don't base it on turnover, whether it's IPC or other things. So they said we will not have turnover-based this thing. If necessary, we will have 100 crores. If necessary, 200 crores, doesn't matter. But this was not accepted by the industry. In the sense, some people said, government is becoming lenient. GDPR says 4%, you don't want to give 4%, so you are trying to be favorite with the industry. So this was an objection raised. Then the JPC said, okay, let it be there. It is your headache. Okay, so, but 4% really was the standard set by GDPR. There is no doubt about that. And that is what actually stirred all of us to think that how will we face a 4% this thing for a company? Now I gave you the examples. It is not only in the paper. Amazon has been asked to pay $887 million. Please convert to rupees, somebody who is familiar with the dollar rate. However big is that company, do you provision in your profit and loss account for payment of $1 billion US? You cannot. And Facebook has provided for about $330 million US as a provision. Now CFOs will have to start thinking how much of provision I want to have in my balance sheet. If you don't do it, if you are a listed company, I will say clause 49, you are violating. You know, clause 49, you have to give a report in the balance sheet. Okay, SEBI person was here. I will say that you have not provided for even 10 crores, whereas the data you are handling, if there is a data breach, you may face 200 crores penalty. So you are under provisioning the estimated loss. So CFO and CEO are violating clause 49 of the listing requirements. I will delist your share. I'm just saying that these are the possibilities, yeah?
But in India, there is always one big comfort factor. See, GDP the non-compliance, the cases will be solved in a matter of few months or a few years. In India, there's a big litigation about cases now. Cases will drag on to about in detail or move. By the time CFO, CEO, CXO, everybody would have gone, somebody else would have been there, and the act itself would have got different shapes.
No, that is
This
complacency.
is the biggest comfort factor on which most of the corporates in India actually thrive. I mean, I'm not hurting the sentiments of very big corporates here. I'm just expressing my views.
I say that India also will improve. Say we didn't have GDPR, we are thinking of DPA. So like that, we didn't have a fast court system. Even adjudication took years, and even appellate tribunal took years. Fine, but things may change.
Even the adjudicated system itself was almost a non-starter in India.
Correct.
Almost a non-starter. With so much difficulty, with people like you and people like me having filed so many cases, it took about 4 or 5 years even for the IT secretary to take it seriously.
But let us hope things will change.
Even for appointment of a simple thing like CISO, though Gopalkrishna Committee of RBI stated it sometime in 2011, April 26th, I think, April end 2011, it took almost 7-8 years for most of the banks to realize that there must be a CISO, I mean, in the rank of a general manager or say ED something.
Yeah.
And by the time it came, it has become so diluted. So one of the junior officers in major banks have been nominated as, designated as CISO.
We will have an advocate here in the panel. We will ask him what is that we have to do not to delay this.
Sure.
Yeah,
No, excuse me.
I also legally looking forward to it.
There's been a change in the way in which we are looking at all these things.
Yeah.
Especially these big ticket penalties which are coming up, they are given priority nowadays. It's not like what you are talking, number one. Number two, immediately as soon as something like this happens, there is it is appearing in the press, as a result of which there is a lot of negative publicity
damage.
which is there,
True.
which means that I am hit by a reputation risk.
Yeah, reputation
I
risk.
cannot afford this reputation risk, and this reputation risk cannot be quantified and brought into my balance sheet as a contingent liability, as he was trying to say, and all that. I mean, it's not as easy as it. Let us not henceforth say that.
No, not like that. Things are actually changing for the better. I only meant
legal systems are taking a lot of time and all those things. That slowly.
And the days are, not gone. It is going, I would say.
Very fast, very fast, very rapid.
Hopefully, yes. Hopefully.
No, it is there. Say there is an adjudicator, there will be a appellate tribunal, Supreme Court. That will be the path here. So it will reach Supreme Court immediately after the tribunal. So delays which occur in the High Court level may not be there. People will still go with a writ. Even if the High Court is not there, they will go with a writ. That is different. Mr. Rohan, please come, please take your seat. Geeta, please. Yeah. So there is an appellate tribunal. But even that may not work is what he is telling. I agree because we have all experience. Please come, take your seat, Rohan. Geeta.
Okay, sir.
So I agree there is an issue. Yeah.
Sir, you had spoken about data valuation in your
Data?
valuation and bringing it in. Can you just throw some light on that as to what is that?
And during the day, some other time I will talk about it. Maybe towards the last this thing. Okay. Some in the panel will come. Because that is one of the points which we have put as our audit requirements. No? So that's why I have to justify that. We have also created a data valuation standard of India. And we want Chartered Accountants Association to start discussing with us. Okay, we have discussed this with valuers in Bangalore. There is a Valuers Association Bangalore. I presented that. In Chennai also, if there is a Valuers Association, we will have a program for them, either physical or even virtual. Okay, it is an important concept. Worldwide discussions have started on that, and so we also need to look at it.
Sir, good morning, sir. I am Balu Swaminathan.
Yeah.
In physical world, we need no law if everyone follow self-discipline. Similarly, you also aiming for the compliance in the digital also. I accept your view. Thanks.
Thank you. I'm saying I will present the law, let the government accept it. That is the reversing this thing. That is the self-regulatory practice we are talking of. So friends, we will continue this discussion on law during this panel also. Let me briefly introduce the two guests here. Geeta Jayaraman represents both Capgemini as well as ISACA, expert in digital transformation of companies by adopting suitable technology solutions. Worked with several large technology service providers in ICT solutions, and at Capgemini's GRC practice, she has helped enterprises manage their cybersecurity and privacy risks. She is an expert Connect program and has written several blogs, so she works on communication, and she is currently serving on the board of ISACA Chennai chapter. So we are privileged to have her in our panel. And I also have with me Rohan K. George, one of our important members of FDPPI, though many of our people don't know because he's not very active in our forums and other things, but he is a very key member of FDPPI in Chennai. He heads the intellectual property practice in Samvad Partners. He has been the co-chair of the International Technology Lawyers Indian Conference for the past 5 years. He advises Indian and international clients on data protection, intermediary liability, technology contracting, content licensing. Each one of that we have to discuss, and we can discuss for hours, but we will not discuss for hours, but within an hour, okay. And he has been invited and retained by the United Nations Conference on Trade and Development to conduct training programs on technology laws for judges in Vietnam, Sri Lanka. Sri Lanka has passed a data protection law recently, Bangladesh, India, and Nepal. So he is part of many of the core team responsible for creation of cybersecurity policy in Karnataka. Okay. So we are very happy to have Rohan K. George here. So I am going to be like an anchor, okay, like Arnab Goswami. I will be standing here or sitting there throughout the day. Okay, so please bear with me. The idea is to have a coordination of multiple, say, panels into a focused objective. See, sometimes what happens in conferences, each panel will discuss something, but there will be no coordination between one panel to another panel. What we feel is that it is like reorienting the magnetic field of all these things in one direction so that the magnetic field is created. So that is how I prefer to have such conferences. So I will be present, I will be interacting with the panel members, raising questions. I will also perhaps give my views. Please bear with me. Our end objective is that all of you should have a better understanding of DPA 2021 than what you may presently have. That's the only objective. Thank you, friends. Okay, so welcome to our panel members. Let me start raising some key questions on the various aspects. Now, we have to start with the definition of privacy. Without that, we cannot say what data protection we are having. So, I would like to start with Rohan. He's the best person to start. Now, this privacy is defined as a fundamental right. Fine, fundamental right. But people will ask, what is privacy? Okay, this Puttaswamy judgment, we'll start from Puttaswamy judgment is a big origin for that. Gave some orders. The order said, right to privacy is a fundamental right under the Constitution, Article 21. Fine. So, what does it mean to me and you? That is the next question, no? And they said that MP Sharma judgment is overruled. Fine. Beyond that, what did they say? A company? They didn't say anything to the company. So, really we do not know what Supreme Court thinks about the definition of privacy. Okay, so let me check with Mr. Rohan. What would be the good definition of privacy which we, the industry people, chartered accountants, CISOs can understand? Yeah.
Thank you, sir, and thank you for beginning the session with a googly. So I'll respond by saying that the Justice Puttaswamy vs. Union of India decision attempts to define the right to privacy in a couple of places, and you have certain phrases such as the right to be let alone and such like. But I think to have a comprehensive understanding of the entire implications of the right to privacy in India right now, the decision as a whole, including the observations of the assenting judges, needs to be taken into account. Because, for instance, in order to understand what the right to privacy means for industry, it's actually Justice Sanjay Kaul's expositions in the Justice Puttaswamy decision which are most useful, because it very clearly lays out that a right to privacy is not something which can only be provided by the state. It's something which needs to be enforced against private individuals and institutions and organizations. So in that sense, it considers the right to privacy as a right which is capable of horizontal applicability, if from a constitutional perspective, and not just vertical applicability. As you may know, most of our fundamental rights are enforceable only against the state. There are certain rights which are enforceable against private institutions, individuals, and organizations. And that aspect of the Puttaswamy decision is what we should be looking at. At some point earlier when the decision came out, I think our firm made an update, and we highlighted this as an important element of the Puttaswamy decision, because by its implication, the Justice Puttaswamy decision ensures that even in the absence of an existing data protection law, the right to privacy may still be enforced against an organization or a company, because it has been recognized as such by the Puttaswamy decision as one being capable of horizontal applicability. So in other words, what does the right to privacy mean? Yes, there are a number of different aspects, of course. And in today's modern world of data privacy and the data economy we live in, I think it becomes a little clearer to us what the right to privacy means as individuals who use Facebook and and Twitter and various kinds of social media, and who also get off Facebook and Twitter and other kinds of social media. We know what privacy means to us. We know what we don't want organizations to do. We know what we don't feel comfortable sharing with government, organizations, or others, not for any other reason, just to maintain an individual sense of autonomy and self. Then the question becomes, how do we implement this in such a way that this modern data economy allows us to progress while at the same time retaining our rights as citizens? I'm not sure if I've really answered your question, sir, but I think, this is the broad implication of what I'm saying.
Yeah, Geeta, you want to add anything from your understanding of what is right to privacy from an industry perspective?
The right to privacy, as I see it, from an industry perspective, is about respecting the individual and the purpose for which they have provided the data. Too often, we collect data and we use it for multiple reasons, not really originally planned for, not originally intended. So in that sense, we are not respecting the purpose and the intent for which we have collected the data. It's more about informational privacy. It's about the software or the information of privacy more than the physical or the communication privacy and so on. So that's how I see as industry that we should be looking at privacy.
Okay. So you have brought in the distinction of physical privacy or spatial privacy, like how social distancing kind of a thing, versus the information privacy, because in the Puttaswamy judgment, actually, Judge Chandrachud made specific references to this information society is developing so fast, information is flowing at the lightning speed, etc., and also information can be duplicated, which is creating additional challenges. So because of that, we have come to a concept called information privacy. So what is the right to privacy? It is a right to be left alone. And the right to be left alone is a mental state. Say, what I feel to be left alone, you don't know. How can you make a law for 130 crores of people? Some of us are extroverts, some of us are introverts. Extroverts don't want to be left alone. They want people around. Introverts, they don't want. And sometimes people want something today and something tomorrow. So the same person has got different reasons to I mean, say that this is my right to privacy today and tomorrow it may be different. So, making a law for such a thing is a near impossibility according to me. So what we did was, we'll not worry about that state of mind of an individual. We will expect him that if you are sharing your personal information with a third party, I will give you a right of choice. When you give the information, tell the other person, I am giving you this information for this particular purpose, you can use it only for that purpose, don't use it for some other purpose. That is my right of choice I am exercising. You follow that, then my privacy is protected, I will say. So it was reduced, this right to be left alone was reduced for practical purposes as a right of choice to communicate the information privacy requirements so that the data processor who is collecting and processing will follow that. Now, in fact, recently we have started discussing another concept called mental privacy. Okay, actually mental privacy is not what I just said, that is state of mind. We are talking of neuro rights. That is, today technology people, you know, they are crazy. They want to actually do brain hacking. Okay, that is, they want to actually be able to make changes in the way you think. Of course, I come from advertising industry. I know the entire advertising industry is make opinions. No, that's why we advertise. Okay, we change opinions. Okay, that is through some transparent way. I give you an advertisement. If you agree, you change your view. But today, people are using subtle ways of influencing people through technology means. Like, if there is an electromagnetic probe which can directly interact with my brain waves and make me think certain things, that is very dangerous, you can say. We are into various implants now. Today, implants are going to be there in heart and this thing that will recognize what the body is doing. Same way, there can be an implant which tries to understand the brain waves, because the research says that if you are thinking negative, your brain will be like this. If you are thinking positive, something will be there. So a lot of things are going on. Now already laws are getting made outside about how to bring this neuro rights into the right to privacy. But one thing I observe in DPA 2021, the JPC modification, okay, they introduced one additional clause in the definition of harm. There is a definition of harm, okay. In the definition of harm, I don't know why they introduced, but I am trying to legitimize that. They say psychological changes to be brought, which causes impairment of autonomy of the individual, is a harm. Harms of various kinds are there. That is, if you suffer a loss of job, if you suffer reputation loss, they are all harms under the privacy. Okay. Likewise, one of the harms they added in the latest version, that is FDPPI 2019 versus 2021, was one of the harm defined is that the psychological intrusion which impairs the judgment of the individual. So I say that our DPA 21 is ready for neuro rights already. You are talking of Norway or something like that. We have our laws. That is how many times in Information Technology Act I have said that Information Technology Act is ready for quantum computing for various reasons. Likewise, here you have that this thing, I suppose, in the definition clause. No, okay, in the definition clause it is there. Definition of harm. You just see here. It's very interesting that without perhaps knowing the implications, somebody thought of adding that item number I or something like last but one. You can read out.
I'll read the initial part. Harm includes, and then in that list, item number 11, psychological manipulation which impairs the autonomy of the individual, or such other harm as may be prescribed. Yeah.
Yeah. So any attempt to psychologically change the behavior of an individual through any electronic means is considered as a harm. So our privacy rights protects that. So that's the expansion of this information privacy. Yeah. Yeah.
I have one observation that most targeted marketing agencies are probably already within the scope of this definition of.
Yeah. That's why I told you I come from the advertising industry. I've spent more than 11 years in advertising industry. This is what we were doing. We will try to change the perception. No? Okay. Also for voting. Okay. So that is our Cambridge Analytica kind of this thing. So we have to tomorrow discuss whether we can ban that. Is it feasible? Anyway, I just pointed out that definition of privacy itself, we have some gray areas. Now the second aspect in terms of law is, data protection law normally recognizes certain things called lawful basis of processing, okay, which we also call as data processing principles. 1, 2, 3, 4. Personal data can be. Before we go into this, I will make one mention. Though this act talks of non-personal data being part of this act, there is only 2 sections in which non-personal data has been mentioned. One is the data breach. If there is a data breach of non-personal data, it has to be reported, that's all. Now what you should do after data breach, this act at present doesn't say anything. Maybe certain director will still give his instructions. There is another casual mention of non-personal data under section 93, I think, which says that government can take some action to collect non-personal anonymized data for certain specific purposes. Beyond that, everything which is there in this Data Protection Act is Personal Data Protection Act. So even if I don't mention, I think we will remember that. You want to add anything to that? Yeah, please.
So on the front of non-personal data, I felt I had an observation about the current Joint Parliamentary Committee report, whereas the previous drafts have all tended to focus very directly on the issue of data protection. There were 2 issues which came out in this report which don't have a direct bearing on the conventional framework of personal data protection, at least. One is, as you mentioned, the NPD framework, non-personal data framework, which was actually expanded on in the Chris Gopalakrishnan committee report, which is a very interesting tie-in. And the second is the whole discussion on whether platforms are intermediaries or not. So it's an observation more than anything else, and not directly focused on data protection, that I would say that there is a larger policy aim to create a unified sort of liability regime for both intermediaries as well as for the collection of non-personal data, which is coming through in the JPC report, though not, in my opinion, directly focused on the issue of data protection at all.
Okay, so we are into this classification of personal data and non-personal data. I will ask Geeta to perhaps expand on that. See, we actually today bifurcate, classify information as personal data, sensitive personal data, critical personal data, and non-personal data. Your thoughts on the legal implications of this? And anything else you want to reflect on what he said?
Right, I just wanted to add to what Rohan said in terms of the importance that the government is giving for managing data, and they really see data as an asset. The recent policy paper that's going to come up on data governance, which is data usability and sharing, particularly considering the 300 lakh crores that Mr. Ravichandran spoke about, how the data is going to be used, how it can be shared, and in what form and manner. So obviously the government is seeing a lot of importance on the wealth of data that it is sitting on, and the personal as well as the non-personal data that it is sitting on. So we are going to see a lot of legislation, hopefully, but at least discussion and deliberations on these topics, which will help pave the way for how we'll go. And it is possible that we may see some revisions in the current Data Protection Act to Data Protection Bill as of now, Data Protection deliberations, which impinges on what the data governance will be and what the framework for that will be. So that's one directional trend that we see the government heading towards, and certainly as private sector we will also be following suit. That's one thing. Now coming to your question on personal data, non-personal sensitive. So the definition of personal data, sensitive personal data, like you said, came right from our income Information Technology Act 2008 and the amendment that came with it. So there was a clear distinction of what would be sensitive personal data and the additional level of protection that it needed. Now the scope of this to be expanding to non-personal data and to make it a data protection act brings within its ambit all the anonymized data, the pseudonymized data, pseudonymized data allows you to retrofit back or to get back the original data. And the need to bring all of that also within the ambit of the data protection and all the measures that come with it, the rights of data principles that they can exercise. So in a broader sense, data protection is important because it is very difficult to pinpoint to say what would be a personal data. Once you put a personal or a piece of data in a context, it becomes personal. But take it out of context, then it just becomes data. So expanding that forum to include a lot more within its ambit will, one, empower data principals to be able to exercise their rights and to see how the data will be used and protected.
Yeah, I think she was referring to this Gopalakrishna committee, that's what you are also referring. Now, see, while this act was talking about data protection, the government formed this Gopalakrishna committee for ascertaining how do we monetize non-personal data. So, Gopalakrishna committee worked on, say, non-personal data. Of course, for that they included anonymized personal data as one of the criteria and then suggested how do companies monetize non-personal data. That was the data governance aspect of that Gopalakrishna working group. So while this JPC was looking at this, suddenly people said there is one more committee, they have given their own report, they have suggested one more regulator. That was what was hurting these people. There was Data Protection Authority for personal data, and if there is going to be a Data Protection Authority for non-personal data, there will be two secretaries who will be fighting for the position perhaps. So there was a thought that why do we need two different regulators? We will merge that regulators into one. But the objective of data protection law was protection of the privacy, whereas the objective of Gopalakrishnan committee report was how do companies make money out of data. The two were totally different. Like we say that a CISO has got a conflict with DPO, these two regulators will have a conflict. We should have managed it differently rather than merging it. But today it has been stated that there will be a single authority. I don't know how the Data Protection Authority of India for personal data will have a system of monetization for data governance and will say you can sell personal data under these conditions A, B, C, D, E. That will be totally alien to the basic objective of this. So probably they may not work much on that. It will remain on paper. And probably there will have to be one more regulator. Maybe he will be under this regulator, doesn't matter, we have no objection, but there has to be a separate regulatory mechanism for monetization of non-personal data. Personal data monetization doesn't happen because it is not supposed to be marketed, except of course under the explicit consent. If you look at CCPA kind of a thing, there is an understanding that a personal data also can be sold, provided the person understands and gives his consent. But it's a very limited extent. Okay. Whereas non-personal data, I don't have to really ask for permission for anybody to make money out of it. If at all anybody can question, that is the government, like the sovereign rights. Government may say like mining rights and other things. It is government's data, you cannot mine and sell without my permission. That is what Gopalakrishna committee report has recognized, that government can declare certain data as sovereign data and then bring in kind of a regulation. So we don't know how this monetization of non-personal data will be handled by this Data Protection Authority under Personal Data Protection Act. That will be a grey area which we will have to see sometime later on. But that is a point which has been brought about. Yeah, please.
So sorry, we're sidetracking again. I'm sidetracking into the Chris Gopalakrishnan committee report. But one observation I'd like to highlight in that is, as much as it is about framework for monetization of private data, the framework more than anything else speaks of creating an eminent domain regime of acquisition of non-personal data from private organizations. That is the actual primary focus, in my opinion, of the non-personal data framework. It creates a logic and a reasoning. The result being that from a policy perspective, the government is well incentivized to promote this into law and to create a regulatory scheme. So I'm only flagging that it is not only about monetization, it's very important to note it's also about an eminent domain regime, an acquisition regime for non-personal data by the government or other government entities.
Okay. We will discuss about anonymization and other things in the technology session. We will now go to this legal basis of processing. Indian Act, we know, has given a lot of prominence to consent as one of the legal basis, whereas GDPR lists some 5-6 items and say any one of these can be a legal basis. So I would like to ask Geeta about what is your view on India adopting consent as a mandatory basis for processing, except some exemptions are there, consent exemptions are there, we will discuss it separately. But this making consent the lone mandatory basis, what is your view on that?
That they have made consent as the primary basis, and like you said, in subsequent clauses, employment, okay, there are some exceptions to this. And incidentally, they have also brought in the other legal basis, just like we have in GDPR in 14 or 13, I don't know, 13 is state, maybe 14 or some such exemptions. So the way I see this progressing is consent, if they've given so much of importance to consent, it is with the intention that they really want the ownership to be with the data principal, to be able to take the call that this is required, not required, I agree, disagree. In my personal opinion, given the level of awareness of our general public, that may not be the best way to go, because while they said consent should be free, fair, capable of being withdrawn, and without any detriment to the service that is being provided, that's going to be a huge challenge. Of course, to that end, they're trying to bring in this concept of consent manager, which is to some extent to alleviate these concerns. But if you consider the teeming masses that we have that produce or that generate the data, it's going to be a humongous task to be basing all our activities on a consent-based system. I have a feeling that as we go through the implementation of this, we will gravitate towards using one of those legitimate interests. That legitimate was recently added by JPC. So that legitimate interest, just as we see it most often used in the context of GDPR, being the primary driver for collecting and processing the personal data.
Yeah. Of course, we will have questions from the audience also. You may be just noting down your thoughts. Okay. Maybe immediately after the next session, next question, we will have a few questions. So then we will continue so that there will be more participation. Let me complete this consent, this thing. I will get Rohan's view. Say that the basic objective of this law is to protect privacy, which means protecting the right of choice. Then consent is the only way right of choice can be expressed. Anything else can come under exemption. Of course, there can be exemptions of various kinds. So consent has according to me, a place. Now, as a leading professional in law, I would like to ask Rohan, now consent is a contract. It has to meet the standards of Indian Contract Act also, that also has been mentioned. So, making it mandatory, is it in tune with the objective of the law? Is what I want Rohan to comment on.
So, truth of the matter is, if we look, one useful thing to look at in the GDPR and other legislation which have been handling cases from a precedent perspective is to understand what what defenses are applicable in what situations and how they've been dealt with by other authorities. And if you see the majority of decisions, whether before data protection authorities or in the courts under the GDPR, legitimate interest is very often the primary defense used by most companies in order to protect the processing of data. And I would say as a fundamental principle, it is important and essential that you create legitimate interest exception, because that is the foundation on which industry is going to be able to do a lot of processing. I'm not saying this because I'm a matter of prediction. I'm saying this because if you look through the defenses in most case law involving the GDPR, you will see that that is observation of actual fact as of right now. So the fact that we have a weaker protection for reasonable purposes, as ma'am, we were talking about section 14 of the data protection bill, the main problem is that the newest edition now makes it a notwithstanding section 11. In that the reasonable purposes exemption provided for under section 14 is now subject to the consent exemption, consent requirement under section 11, which actually makes it kind of very weak in that sense. It is going to be one of the main points of judicial conflict, of tribunal or judicial conflict if this goes forward in this particular shape, because not because I'm a direct member of the industry. Of course, I have enough clients who have seen in these situations, but from pure observation of past decisions under the GDPR, that is going to be an essential requirement for industry to proceed with the effective processing of data. And when that is weakened, you're only going to create opportunities for disputes and conflict.
Okay, when we are talking of consent, we are referring to informed consent. Okay, that is the data principal. Here we call him as a data principal, not the data subject, because we are calling the data controller as the data fiduciary. We are giving him certain duties, trustee duties to the data fiduciary. So which means that even if the consent is weak, a trustee is supposed to go over and above that and do what is beneficial to the data principal. So if you extend the data fiduciary concept, perhaps you will absorb some of the weaknesses in the consent this thing. Particularly the weakness in consent mechanism would be the technical aspects, like whether a click wrap contract will be good enough for legal things and so on. But informed consent is necessary, which means that a notice has to be given with appropriate details, and then consent has to be obtained, and that consent has to be kept on record. In fact, that is what we are going to discuss in the technology section, how to keep this consent tagging. So this is one aspect of consent which is there. But this consent manager there is no need for one consent manager for India. There can be hundreds of consent managers. So each group of people can create a consent manager for their group on whom they have a trust, and they create a repository of personal data with that consent manager, and that consent manager will deal with all the data fiduciaries and release consent on behalf of the data subject is what is envisaged here. Those of you who are aware of the mighty Ministry of Information Technology Act's framework called DIPA, that is Data Empowerment Protection Framework, there also the government is talking of a term called consent manager. Now the consent manager under DIPA framework is different from the consent manager under the Data Protection Act, because under the DIPA framework, the consent manager is an intermediary, like in Information Technology Act. He is a technology intermediary. He will allow the consent to flow, and there is no visibility to the consent manager to whose data is flowing and what data is flowing. It is only a ISP kind of a service. Whereas the consent manager envisaged under Data Protection Act is a data fiduciary. He has got full visibility whose data I am collecting, whose data I am passing on. So there is a difference between the two. So this data consent manager, who is a registered data fiduciary, he is a data fiduciary and he has to be accredited by the Data Protection Authority for that business. Now after that, if he is able to manage the trust of his clients, that is what this act thinks will overcome the problems of language, problems of less education of our data subjects. They will not understand the reasons why one app is asking for, say, SMS permission. I don't know why it's asking for SMS permission. If I don't give it, then I will not be able to download, so I simply say yes. So it is difficult for them to fathom the details of these permissions, but a consent manager can do. So I will check with my consent manager and say, should I download this app? That consent manager will tell me that you can download this app, and whatever information they want, you don't give it, I will give it. We will have an API or something like that. If you want to subscribe to app A, the request will go from app A for information to the consent manager, and the consent manager will release whatever is relevant. Consent manager is supposed to be more intelligent than me, so perhaps some control will be there. This is what is envisaged in the Data Protection Act. How it will be practically implemented, our technology people will have to tell me how to create a system for that. But this visibility to data, which happens in the data consent manager here, and no visibility in the DIPA framework, is a very important point which we have to take note. This actually distinguishes, in my opinion, concept of privacy itself. Privacy 1.0, privacy 2.0, if you want to have. I say that currently, wherever GDPR, everything says, a data which is seen by a human being is an infringement. You need consent, etc. Data seen by a machine, is it infringement? That is, if there is a CCTV. Now CCTV knows that Nagendra was present here. Is it an infringement of his privacy? That question depends on whether this machine, software, hardware, has the intelligence to find out that so and so with facial recognition was present in a particular this thing, and so on. Now in privacy law, should we say that if a machine knows, it should not be equated to human, because data has got no meaning except in the context of a human being interpreting the data. For the CCTV camera, this is not a picture, this is just zeros and ones. Okay? Only when that zeros and ones is put through certain software, it becomes an image, and then AI will match that facial image with some software, and then ultimately in the third or fourth process, it comes to know one Mr. Nagendra has been present. That 4 processes, should it be considered as privacy exposures or not, is a discussion we can have. For example, I create a software. It is the picture it takes, but I will not show it to any human being. Okay? But this software itself will analyze, and then only if there is a suspicious movement of some crowd person or something like that, that image alone the software will capture and give it to the police or somebody, and then he will take a view. In that case, for all those people whose images were not passed on for human supervision, there is no privacy invasion. It's a thought process. So that is one type of defining privacy. Actually, today everything is privacy invasion. So privacy 1.0 concept is whether a picture is taken by a human, seen by a human or by a camera, it is a collection of personal data. So you need consent. Whereas in the next concept is, I will delineate this and say only if this personal data is going to be read by a human being, consent is required, otherwise consent is not required. And if it is based on a suspicion, there is exemption, law enforcement exemption is there. So because of the suspicious movement, I am trying to see who is that person, then that comes under exemption of consent. Therefore, if I have got a CCTV system which law enforcement is using, as long as all the images are not going to a constable sitting somewhere who can misuse it, I can say that privacy is still protected. That is a concept which we are saying it is privacy 2.0 which has to emerge. At present it is not so. GDPR people say CCTV, if it is facing the street, then you are infringing on the privacy. Okay. Now we will move to one more Any questions up to this? Yes, lot of questions will be there. At least few questions we will take. Yeah.
So this consent manager that you are talking about, so this should it be for an organization specific or?
No, not necessarily. It's a service in itself. Say, for example, FDPPI can be a consent manager. It can provide service to public. Like that, it is not specific to this thing, but I can make one company my client. For example, Zomato is there. I will say all Zomato people, whenever you want to apply or download, the person will not directly give the data to Zomato. Zomato will pass it on like a pseudo identity, like your virtual Aadhaar kind of a thing. If you are a member of my, I am the consent manager, you are a member, I would have given you a proxy ID. So I will tell Zomato that if you are trying to download, you ask for the Navi ID or something like that. And when you give that ID, then the API will ask me whether I should give consent. I will give only a consent as is required. For Zomato, I only need to give your location. I don't have to give your whole life history. So, I will only give, this client wants you to supply some idli dosa to such and such a location. Okay, what is required there? Location. And payment, if it has to be required, then only payment related information is required. So, I can do pseudonymization at my level and control what information is given or what information is not given. That is the service I am giving as a consent manager to you and you. For Zomato, for something else, something else. So I can have on the one side list of user clients. Or different people are there. That is one corporate clients. On the other side, I have got the individual clients. You are all members of the system. These people are members of my system. Now, will they recognize me? That depends on, you are telling that company that I will not give you my personal ID, I will only give my pseudo ID. When that pressure builds up, they will have to come to me, become a member of this consent manager, and only my members will be getting this thing. That kind of a system will have to develop. Not one consent manager, hundreds of consent managers could be there. It will solve the problem of consent fatigue and understanding what permissions are relevant, what permissions are not relevant. Which I and you may be finding it difficult to decide. But if I am a consent manager business, I will have 100 people working on thousands of apps, and I will have whitelisted apps, blacklisted apps, or say controlled apps. I will say these apps you can take provided in a conditional this thing. That is a system which can be thought of. Yeah.
So I have. So, sir, you gave an example of CCTVs, correct? Now, event like this, now it's getting recorded, getting live streamed, and also there are a lot of photos being taken. You know, so I myself part of industry forums where we do a lot of events. Now, what will be the kind of mechanisms when we start organizing from a...
In the registration form, sometimes we put a footnote. Okay, this will be done. Okay. Otherwise, it is part of the deemed consent. Now, I am not asking you what is your name. Okay. Video will show somebody asked this question. But who is that person? See, data becomes personal only when the activity data, that is, a person asking a question is an activity. Unless I address you, hello Vaidi, what is this question? Then I am identifying you. Okay. Now, that has to be worked under either a deemed consent or legitimate interest. Okay. If you are attending a conference where supposed to be live cast, it is going to YouTube, your face is there worldwide right now. So, now, were you not aware of it? I don't know. I am assuming that you are aware of it. At best, what I can do is at the registration, this thing, I can put up a note that this is being webcast or something like that. That is the only thing we can do. And we are not talking of, now the question is sensitive personal information and non-sensitive. Okay. Sensitive personal information requires explicit consent. If it is not sensitive, deemed consent is okay. But what is sensitive? In India, sensitive personal information includes caste, tribe. Okay, if I say Vaidyanath Iyer, I won't reveal any your caste. So name itself is sensitive in India. So I actually don't agree with saying that caste and tribe, political opinion should be part of that. They are actually our profile building things. But unfortunately in India it is part of the sensitive information. So that there is a problem. Have I taken explicit consent from you? May not be. I have only put up a notice there. It is a ordinary consent. Okay. Beyond this, I have to say that you have to exercise your rights. Before entering, tell the person, no, my face should be not shown. Then camera should have some, say, blind zones. Like smoker's zone, we have to create a blind camera zone. And those people should sit only there. Okay, yeah, please.
Sir, you've raised a very good question that way. I wanted to address this because this question of yours goes to the heart of what all of us are going to have to deal with in the light of a new data protection regime. That doesn't mean we shouldn't have such a regime in place, but now we have to understand. It's a good question because in the context of this particular gathering over here, if we were to extrapolate it on the basis of the Data Protection Bill 2021 and the definition of personal data, which relates to any kind of characteristic relating to a natural person, whether identifiable or not, or capable of being identified, then yes, the collection of your image by this CCTV camera is formally within the scope of this bill. And then all the obligations which attach to a data fiduciary would attach to this organization as well. So what is the solution? It's not to make everybody sit and fill out forms before they attend each conference. But that is where we have to develop what you call a privacy by design philosophy. It's not about creating documentation which legal professionals can tell you is on board. It's not, that is not something which is capable of being envisaged in the context of something like this. Then you need to create practical solutions. Perhaps an announcement needs to be made in advance. We have a legitimate reason to record this particular conference. We are live streaming it. For all those who are attending, perhaps you should be aware in advance that we will be recording this conference. Anyone who is attending, who is coming in late, maybe have seen a notification put up to that effect. So to that extent, your question is relevant because yes, so many new obligations come into place as a result of a bill like this. But at the same time, because we are human beings who have to go about our daily activities, we will find practical ways of coming out of these obligations. And the reality is the only way we will find those is if we start thinking about them now and addressing them in that way now. That is why I think compliance needs to begin now in order to understand how to comply even if it's 2 years from now.
In fact, my question... My question was just almost supplemental to what he had in mind. I wanted to ask just this question. I faced a similar question in one of the seminars, especially on the question of privacy. Privacy is relative. What is privacy to A may not be privacy to B. And even to A, what is privacy today may not be privacy 10 years from now. Because celebrity may consider his being photographed in a public place to be an invasion into his privacy today. But after 10 years, when he loses the market, he would like to be photographed, and the photographers may not be interested in photographing him at that time. Suppose a girl from a village comes and walks on the busy streets of Anna Salai, right? And suppose the girl is being photographed by a person not known to her. She has got three options. One is she would like to pose for the photographer. Suppose she is coming to Chennai with an intention of becoming a celebrity, acting in a TV serial or something like that. She would welcome it. Second is, if she is joining any interview, she'll just be neutral, insensitive. She'll be busy in her way, not caring for who is photographing. Third is, if she is really a shy, quiet, introvert girl from a village background, she would object to the person. Now the person has got only one option available, one defense available to him is that you are walking in a public place, I got every right to photograph whoever is walking in a busy street of Anna Salai. Does she have the right to say that you are targeting me as a subject and I got every right to object to your photographing me? Because the question of privacy is I mean, the line of distinction
Sir,
is quite thin. Even Puttaswamy's judgment, even Chandrachud, actually he touched upon the privacy only 2-3 places, I think, if I remember right, only 2 or 3 places. Privacy has not been defined. Not defining, but classifying it as a fundamental right, I think Supreme Court has left open a big question there without defining, but of course classifying it. Right?
So, your question, is it directed to that specific instance which you are asking about, or are you asking from a larger perspective? Because the specific instance which you're talking about, there is to some extent an exception under the Data Protection Bill, which provides an exemption for manual processing by individuals for personal purposes. Now, the moment that that data is not going to be kept personal, let's say, for example, I am a hobbyist who likes to collect images of people on the street, and for my own personal interest, I'm doing so. Maybe I am exempt under the DPB. But let's say I put up a blog where I call it Humans of Chennai, and I start putting up images of people. Then, yes, there is scope that I am potentially violating someone's data privacy, because I am not doing this for my own personal purposes. The exceptions which are provided for are not provided for. And even though I'm an individual, by making this data available to the public, by publishing it, so to speak, I am potentially violating. And therefore, as Mr. Vijay Shankar very clearly pointed out, the important thing is not to be concerned about the state of mind of a person now, 10 years from now, or 10 years in the past. It is just to focus on whether consent was given, whether it was continuing to be there, and whether it was removed. So an individual may provide consent now. I may ask somebody, may I take a picture of you, and may I publish it on my blog, and they may say yes, but maybe 3 days later on they feel that they are embarrassed by all the negative attention, and they may want to withdraw that consent. So there is a mechanism which is built into place to address this. We just, honestly speaking, don't know how it will play out until, like, this is like a game of chess where all the pieces are on the board. No one has started playing yet, That is the main challenge. Only when you start playing will you understand how these things really operate in terms of playing out. All the provisions are there for the situation you've described. How they will play out is something we are not yet certain about.
I'd like to add one more thing, right?
Yeah,
So many...
Yeah, please.
in many shops, they have this disclaimer, this shop is under surveillance. So then obviously you are informed, and you cannot claim, if you're so privacy shy, then you don't go into that shop, or you go check out for shops that don't have cameras all over the place. But the other point where I think our privacy is rampantly violated is where, with this new requirement to have CCTV cameras all over the place, of course, as a crime prevention, crime detection measure, every street you walk on, you are captured on at least 5 different cameras. Apartment complexes, Chennai Corporation and its various wings that have put up poles and cameras all over the place. And I think that is where we are taking a very lax attitude. There have been several cases in the GDPR judgment which says that you cannot keep manning public places where you are capturing people walking by. That could potentially lead to an issue for us as we keep collecting these images as we go along. The point that Sir raised about 2.0, where we say, oh, it's not human visible, it is machine visible and things like that, is as yet, in the future state.
Thank you. Somebody from this side. I think I will have to turn my chair here, otherwise no questions will come from this side.
Hello. Yeah.
Yeah, from here.
Yeah, I have a question. When it comes to penalty, okay, for some years ago there was a compromise of the Aadhaar database. I don't know if you recall, Geo, it was directed at Geo actually. And there was one website called Magica PK which had, published all the Aadhaar details. And they claimed that it was taken from Geo's database. And many service providers, they use the Aadhaar database. Now my question is, okay, you have a penalty in place, they pay a penalty, whatever, through litigation, whatever process. But how does it absolve me? Suppose I am affected. How does it absolve me? My data has already been compromised. I mean, the damage has been done. So me as an individual, now between Geo and the authorities who are going to penalize, there is settlement. But it's my data which is being compromised. So what is the relief I get?
No, actually, in the penalties, Indian data protection law provides for compensation which can be claimed by the data principal directly. Apart from the fine which the data protection authority may put on Geo or something like that, you can claim your own compensation provided you can convince the court that you have suffered a damage on account of this. So when you claim compensation, you will have to prove that you have suffered a damage, but the provision is there, section 662, and provision 65 is the procedure for that. Okay, your first application will be to the data fiduciary, objecting it, and ask for compensation. If he doesn't give, go to the adjudicator, and if he doesn't give, you can directly go to the appellate tribunal and then to Supreme Court. So that entire scheme is available. Every data fiduciary is supposed to have a grievance redressal mechanism. If he is not having a proper grievance redressal mechanism, that is sufficient to fine him. Okay. Now that grievance redressal mechanism will be part of the privacy by design policy. So the data protection authority can question an organization what grievance redressal policy they are having by looking at the PBD policy, which has to be certified by DPA. You know that Indian data protection law requires you to prepare something called privacy by design policy, like a prospectus in a public issue. You have to sign and submit it to the data protection authority. He will certify that. So that should contain your grievance redressal policy. If I am the data protection authority, if you don't have a grievance redressal policy, I will reject your PBD policy. And if I reject your PBD policy, you will not be able to register if you are a significant data fiduciary, which means that you cannot carry on your data processing activity. So there the control is available with the DPA. So compensation can be claimed through the normal grievance redressal process. Okay? Yeah. Yeah.
It is going to help the business community, because what is happening is, like, for example, now if you are talking about Facebook, Amazon, they live and thrive on data. Now if you are entangling them or any business for that, these are all compliance issue, correct? Because again, it's going to increase the cost of running the business and operation. And any compliance, it's like over a period of, as you mentioned, it's a journey on its own. If that is the case, how a Facebook or an Amazon or Flipkart, or now Tata also has come up with an umbrella app. So the main purpose of these things is to collect more data and to analyze the DNA of the customer and the behavioral pattern, and as you mentioned also psychologically, how to win them. So if that is the case, how the business model is going to evolve?
There is no prohibition on collection of data. There is only a requirement of consent, and in some cases explicit consent. So if you are a Facebook, get the explicit consent and do it. That's all.
Correct, but the question here is like consent, it cannot be like perpetuity. It is having a time and the purpose.
Agreed.
So if these two things are there, as a business, when I collect also, I'm going into the too much of compliance part of it. So the main purpose of collecting the data itself, it's getting defeated.
If it is a single purpose consent, consent is over after the purpose is over. If you say multi-purpose this thing, then it will be period-based consent, and that will have to be renewed at least once a year, because Information Technology Act says that you have to renew certain consents once in a year. Here we only say quality should be maintained. Now what do we mean by quality? Your address given 5 years back is not a quality information now, so I have to renew. You may be employed in some company yesterday, and today you are in a different company, so I have to periodically renew the consent along with the information which you have given for consent. That is a requirement. Normally, this 1 year is not mentioned in Data Protection Act, but I am saying minimum at yearly intervals, you have to renew the consent. As a compliance man, I am trying to say, I'm drawing that 1 year from the Information Technology Act, this thing. Rohan, you want to add anything? Yeah.
So I think your question is basically about whether from a policy perspective itself, a data protection law is good for industry to exist, basically, for industries which are currently actively collecting data and processing data.
As you mentioned, no, it's a data is now new oil.
New oil,
So
correct.
New oil, yeah, that phrase is now an old one, but it's true. It's still a very important phrase. Because the thing is that, yes, you are right, data protection regime will put constraints on industry in operating. But I'll give you an observation from whatever policy engagements I have observed in emerging technologies. That is the area I tend to focus on. So you'll recall when Uber first came into the picture as a transportation services provider, they held forth that all of the people who drive for Uber are freelancers who have no obligation whatsoever to Uber. They were carving out a space out for themselves which did not involve regulation. That is what they were trying to do. They were trying to project themselves that they do not require regulation. And therefore, from the regulatory pendulum perspective, Uber was unregulated. What is the result of that? At some point, a person was sexually assaulted by a driver in an Uber. At some point, drivers were facing terrible human rights conditions, basically as a result of driving for Uber. That point, the government took notice and basically banned Uber in certain cities. So they went from a state where there was zero regulation to 100% regulation. 100% regulation is prohibition, basically. There is a spectrum of regulation which goes from completely unregulated to banned. If the data industry is not capable, or that is the industry, means any industry which is a focus on data, then they could also face a situation which goes from the 0 to 100. Okay, and when the 0 to 100 happens, for the wrong industry, in the wrong place, the wrong time, it means closure, shutdown. Okay, so from a larger policy perspective, when there are actual implications, negative implications from the processing of an individual's data, and when those can result in unregulated or can result in extreme situations for the company, because in the absence of a law like this, which gives you a clarity on what to do and how to do it, then you are only waiting for a moderately informed, a disaster in the making. Absolutely. So in that situation, we are better off having a law of this nature which gives industries clarity on how to operate and a way to communicate with the government on that clarity. This law is technically a medium for communication between industry and government because it gives us a framework in which to discuss. That is better than having a completely unregulated space where at the wrong moment something can happen and the whole industry is shut down because of a negative situation.
Thank you.
Thank you.
One more clarification, because now we are in the shared economy and the cloud computing. So now majority of our data is sitting in the cloud. And as a client, even if I sign off with any software vendor, then if there is any breach or leak of info, so then there are multiple points are there. So it's very difficult to even interpret where the breach has happened. So if this is the case, then as she mentioned, if a customer or if a stakeholder is having an issue, then who's responsible for it?
Data fiduciary has to have a contract with the data processor. So the responsibility has to be shifted to the data processor, next data processor, and so on. So if you don't do it, then you will have to face the consequences. It is difficult, yes, it is difficult, but if you want to protect privacy, this is required. So law says that data fiduciary is primarily responsible and he has to ensure contractually that data processor also follows this compliance, and if the data processor subcontracts it further, the same chain should continue. So cloud, just because Amazon is the cloud operator, I am the user, they don't get big strength. I am the data fiduciary and he is the data processor. So he has to sign the contract which I want him to do. See, normally our problem is we think these companies are so big that it is like a tail wagging the dog. They tell what we are going to do. We have to change that concept. We have to tell him that you are the data processor, you are giving me the cloud service, but I am the person who is managing the data. I am responsible for data protection. So I am giving you these instructions. If you don't want to do that, then face the indemnity, whatever indemnity and other things is there. Any liability which comes to you, you pass it on to.
Thank you.
Okay, we will continue to discuss this in the technology session also. So let us close this session. Thank Rohan and Geeta.
Yeah.
Throughout the day, we will be discussing around this topic. So don't think that we will be skipping some of the questions which are in my mind. I have myself skipped a number of questions which I had. I am going to take it up in subsequent thing. I request both Rohan and Geeta to be present here so that anytime we want in the afternoon or something, we will draw on their expertise. I don't know whether you have planned for that, but okay. So thank you, both of you. We will keep in touch and develop this further. Okay, thank you. Yeah, please.
So my firm has prepared a few primers. Has prepared a primer on the current version of the data protection bill. I have a few copies, so I will make them available for whoever would like to take a copy. I don't have, unfortunately, as many as for this gathering. It's been a while since I've seen a good group of people of this nature for a conference, but I'll keep this available. Thank you.
You send a soft copy to FDPPI, we will try to put it separately. Thank you very much. Yeah. So on behalf of MMA and FDPPI, I will provide the mementos to our esteemed speakers. Okay, and I will invite Nagendra Javda. So friends, we will continue with the next session, which is on the challenges to technology. So we have discussed some aspects of the legal issues. Maybe we'll add more issues as we go along. But let us see how do technology people try to resolve these challenges. Okay. For discussing this, I have with me Dr. Mahesh Kalyan Raman, a very senior information security professional, presently working with HP. He is also associated with the SACA and a professionally certified CISSP, CISA, CISM. He has worked in Cognizant, Tata Communications. He is also associated in the academics as a visiting faculty, and he is in the advisory committee of MSc Cyber Forensics, which was one of the programs we started way back in the first few things. Myself and Ramasubramaniam were also involved in that. Okay. He is a person of eminence who has been invited even by Interpol for conferences. So we have a very experienced professional to discuss various aspects of technology. I also have with me Nagendra Javagal, who is a founding director of FDPPI. He is a governance professional, has worked in a number of IT organizations, and presently he is a freelance consultant and of course closely associated with FDPPI activities. I also have Suhasini. Actually, Mr. Venkatramani Suresh of Conics was supposed to be here. He was here actually in the morning, but some timing problem was there. And so on his behalf, she is an engineer from that company which is into healthcare management. So healthcare has its own issues. So we would like to draw from her experience some of the technical challenges which we face and how they have tried to address those issues. So with all these three gentlemen and ladies, we will try to have a discussion on how does DPA 2021 look for a security person. Now we should start with our discussion as a continuation. In the earlier session, we used the terms anonymization, pseudonymization loosely. Now we would like to get a little more insight into anonymization, pseudonymization and de-identification. Why we need to do this is one of the sections of this Data Protection Act says that re-identification of de-identified information is a punishable crime with 3 years of imprisonment. So we need to know what is identification, what is de-identification, what is pseudonymization, what is anonymization. Okay, so this is one of the first things which a security person has to know, because the moment the CEO asks him how to mitigate the risk, the first thought which should come to him is, all your personal data, you don't require all your employees to know it with identity. Let us de-identify it at the gateway and then work on that. So for that reason, I want to discuss, and we will start with Dr. Mahesh himself, about anonymization. See, for example, when this anonymization was proposed first in the PDPB, it was very clear that personal data which is anonymized is non-personal data. So non-personal data clearly includes anonymized personal data. But somewhere people got a idea, anonymization is not a perfect technology. In fact, I had a discussion with the JPC, and in that, one of the main points which even our current finance MOS Rajiv Chandrasekhar was asking was about this anonymization. I spent a lot of time of my interaction with JPC on trying to put through my thought to say what is anonymization, because somebody was asking, should we have a consent for anonymization? When you take consent for collecting personal data, the question is, for anonymization, should you take a consent? Or should anonymization be the right of the organization to monetize it? You have a personal data. If you anonymize it properly, there is no privacy risk. So you should be allowed to monetize it. It was the thought process which was prevalent. but somebody got an idea that anonymization is not a perfect technology. Even if you anonymize it, there will be a big data company which will de-anonymize it, and therefore we should not make de-anonymized personal data as free from consent. This is one of the thought process. So let us look at, and even this Gopalakrishna committee report which we said, they were very clear that there are various technologies of anonymization. It is for the Data Protection Authority of India to define a standard of anonymization, and if the anonymization is below that standard, then they will be responsible for de-anonymization by a third party. If it meets the standard and still somebody de-anonymizes it, it is like the cyber crimes. See, now we say encryption. You use whatever encryption standard you want. Somebody will be able to decrypt that. Law cannot say that you cannot encrypt it. See, most of the Data Protection Authority, legislations say breach of an encrypted data is not considered a breach which is punishable. The reason is encryption subject to a certain standard is the best the company can do. So beyond that, if a criminal is sitting and using all the technology and breaking that, you cannot make me responsible for that, is the logic. So anonymization is also like that. So I want to know from Dr. Mahesh, what is the reliability of the anonymization techniques, whether it is possible for the Data Protection Authority to fix a high standard of anonymization, beyond which, if somebody de-anonymizes it, we will call him a criminal and punish it. It should not happen during the normal data processing activity. But if somebody focuses on that, our crime laws will handle. So to that extent, what is the threshold of the acceptability of anonymity according to you?
Thank you, sir. First of all, thank you very much for making me present in this Augustus crowd. So let us take a step back and see where did this apply exactly. One is data at store, which is stored at that point, And second is, in the present world, cloud is prevalent everywhere. And integration of applications, integrations of infrastructure is also prevalent. So if you get into an organization and try to find out if there is a standalone application which is going to process a sensitive data, it will be very difficult to find out. There will be a lot of integrations upstream and downstream happening. Data will be moving beyond the borders, network borders of the organization, as well as the geographical borders of the country where the organization operates from. So if you ask me, are organizations prepared to inventory the integrations? Still it is in a very nascent stage. That's my first concern, which practically last 1 year I'm talking in every opportunity possible. While we have the concept of CNDB, that is Configuration Management Database, which captures the change happens in the infrastructure, but it doesn't have the capacity to inventory the integrations upstream, downstream, which is happening in the applications or the infrastructure. The reason why I'm saying this is today to process, I would say, critical data, we would have third-party applications also involved. Those third-party applications will be hosted in some cloud which is beyond your borders. So how would DPA will apply to those environments? As long as the data is within our control, within our borders, you have every right to do that, or you have every means and ways to do that. But if it is going to go beyond your borders, what is the scope of applicability for that? Number one. Number two, we were talking about, sorry, I missed this statement. Okay, so this is one of the key concern for me when
cross-border transfer, when it happens, how do we control? Yes,
okay.
we'll discuss.
And you mentioned about passing on the responsibility to the downward data processors. Yeah. But the biggies like Amazon's or Microsoft's say that this is my standard agreement. If you want to use it, you come to me, otherwise don't come to me.
Yeah.
So how will DPA will enforce the biggies? Boss, if you want to do business in India, you have to follow Indian DPA.
Yeah.
Second concern. Third is, the cloud platform can be used as an infrastructure to host the data. I will contract the cloud underlying platform and use my own application hosted on the cloud, put my personal data wherever I'm collecting with consent or without consent into that platform. And if the platform fails for me,
Yeah.
where is the accountability?
Okay. We'll come back to the questions. Nagendra, you have got any thoughts on
Yes,
that?
sir. Continuing the Dr. Mahesh comments, we have seen some challenges that, there is a kind of inadequate knowledge about total IT environment which collects or which process or which stores the entire data. The reason is being something is running on the legacy infrastructure, something is running on the in-premises infrastructure, something is on hybrid, something is on customer side. So because of all this complexity, it makes kind of a very challenging for someone to understand how the data flows between various entities, various businesses. That itself is a very challenging nowadays because of this kind of a disintegrated or kind of a different way of networks or the infrastructures. They are totally in a kind of their own environment. So that is being a very great challenge to identify the data flow between two entities. That's a great challenge. That way, since we have to comply with multiple regulations, when something is at the national level, something at the state level, or something at the sectorial level, it becomes very, very challenging to understand what data flows where, what exact data process, which system or which application, which network. It's very, very challenging. Unless we get to know a bit of clarity on that, it becomes very challenging to handle this privacy compliance programs.
Okay, we know the challenges, but we would like to look at the solutions. Okay, now one of the things which you said is this cloud operators. They are big. Now how do I tell my Amazon or Facebook what to do? I have the option not to use their service. That is one aspect. But technology provides you with one, the pseudonymization, another encryption. Now my question to technology people is, if you want to deposit personal data with Amazon cloud, Amazon doesn't want to know the real identity of the personal data. Even if you are putting personal data there, you can very well pseudonymize it before it goes to the Amazon cloud. And when it comes back and you want to process, you can bring it back, de-pseudonymize it and use it. Which is, if the cloud is used only for storage, not for processing. Now, if you want to use the applications also on the cloud, then you are taking the risk on that application provider as the processor. Okay. Now, again, there also you can process a personal data entirely on pseudonymized basis. Say whatever you want to say, you want to do a process of in the health of this thing, we have got the name, we have got the age, we have got the gender, we have got the let us say ailment, cancer or something like that. You are processing it and to find out, let us say, how many men under the age of so and so are likely to be affected by cancer or whatever is. That's a simple processing. Now, the process doesn't ask you whether you should have the names of people correctly. Ganesh, Ramesh, Suresh or something like that. You can always pseudonymize it and put it there. So the risk is mitigated. Of course, you can say that somebody will take that and then analyze it and try to find out that Ganesh is not Ganesh, Ganesh is Suresh. Then he is investing money and time and effort on re-identifying the de-identified information, and he will be subject to the section 83 of the Act, 3 years imprisonment. So big data companies cannot steal the data from there, re-identify and misuse it. From my point, I want to put up a pseudonymization gateway before the data exits from me. If it's only storage, I can use the encryption itself. I will not give the key to Amazon, I will keep the key with me. If I want to process, I will use pseudonymization. Is a thought. Now I would like the technology people here to reflect whether putting a pseudonymization gateway for data flowing out of my organization into a processing area which is not entirely under my control would be a reasonable risk mitigation strategy. Okay. So,
That's the reason in my first comment I mentioned understanding the IT environment, IT risk exists there, that is makes most important here. Based on that, you can employ the necessary tools and the system and application there.
Okay. Now, Mahesh.
So as you were earlier covering, privacy by design should capture this. What is the criticality of the data to the organization, which defines whether to have the pseudonymization gateway before the data goes out of my organization's network, before it reaches any third party.
Yeah.
The other point which we need to ponder also is, if I don't have a gateway internally, I'm going to depend upon a third party gateway.
Okay.
That's a risk organization has to consider.
Now it is like the consent manager kind of an intermediary. You trust another intermediary to do some specialized activity, and maybe he will have better access to technology, but still he is your data processor.
Correct.
If there is a breach at his end, you have the consequences.
Correct.
Suhasini, I would like to ask you one thing. Health industry is one where this de-identification has been in vogue since the HIPAA times. Okay, because HIPAA defined identifiers, 18 identifiers, and said, if you remove these identifiers, we will call it as de-identified information. And when the High-Tech Act came, they also specifically said, loss of encrypted data, encrypted PHI, need not be considered as data breach and reported. So, de-identification and encryption were specifically recognized in the health sector under HIPAA. Now, as a processor who is involved in some of these things in the industry, do you think you are able to use these kind of technologies?
To a very large extent. So basically, what happens is, as you might know, that the recent Ayushman Bharat digital mission, right? It's implemented in India. It started to implement in India, with a lot of processes in place as to how to sort of identify, basically give a unique health ID to each of the citizens in India, like an Aadhaar, right? So we are actually generating a health ID for each of them. So with this health ID, it's actually easier to sort of identify a person without having to give so many fields out to the third party. So, and there are a lot of interoperability standards also which are in place, right? Like how the FHIR systems, because I have to talk to another healthcare provider, because the citizen that comes to me might go to another hospital, another clinic for getting all the other services done. And I would also need his data back to me from the other, either from with the consent of that particular user or from the clinic that he is going to. So with all of these in place, I think protecting data would be far more easier, given that there are a lot of standardization happening as to what fields we are getting captured, we are capturing versus in the entire health ecosystem. If there's a standard that's applied, then this particular protection of data is going to be fairly easier.
See, our privacy by design system, the first question which people will ask is, are you using anonymization or pseudonymization? So every organization which is into privacy will have to first decide whether my processing is compatible with some kind of pseudonymization or de-identification. Of course, de-identification means removing the identifiable factors, and maybe you will have a mapping with a consolidated proxy ID. Processing may get affected if you remove some data. So de-identification will not help in many instances. Okay, it may help in the case of disclosures. But if data has to be processed, pseudonymization is a better way, because if there is a field which has got only alphabets, you can replace it with alphabets. A field with numericals, you can replace with numericals. So your processing does not get affected, but you will have a proxy for column 1, proxy for column 2, proxy for column 3. Instead of one proxy, you will have multiple proxies. Once you have that mapping table, you can use your legacy processing system with the pseudonymized data, where the gateway converts the identified column 1, column 2, column 3 data into pseudonymized column 1, column 2, column 3 data. Now, I have suggested actually one of our own FDPPI members to develop a system like this, because I don't have such systems easily. Now, here we have got industry people. I want to know, do you have a solution in the market for this kind of pseudonymization gateway? My thought process is that pseudonymization gateway, incoming data I will pseudonymize and give it to my processors. Outgoing data I will pseudonymize and send it to my subcontractors. And whenever it is required to be disclosed back to my client, I will de-pseudonymize it, because I cannot give the processed data based on pseudonymized data to back to this. Anybody is having any experience of any particular tool which can do this from the industry? Anybody? If you say no also, I am happy. Okay. Yeah. Pardon? Database itself provides this column-wise pseudonymization. Now you have to actually capture that mapping and store it, and that mapping will have to be secured by giving, say, the control to more than one person or something like that within the organization, and that mapping data should be encrypted. So if the database itself provides it, you want to use it, but maybe some customization may be required for doing it. Any other specific tool they go in?
Credit card companies. There are 4 or 5 credit card companies. There's an Indian company also. Lot of India. All these companies have got their own algorithm to mask through encryption methods, and there are several millions of data they are handling, and they are also coming under the act called Credit Information Companies Regulation Act 2005, which is probably one of the forerunners of Data Protection Act itself, whatever that is coming up now.
Okay.
Okay, so that is an example for...
Fine. So we are saying that some kind of solutions are available, so it is for the technology peoples to actually explore those things. And from the legal side, we are going to complain that you are processing personal data, and if you don't secure it, I will put 4% fine or penalty or something like that. That is a threat. But that threat can be met if you are able to invest in technology, is what I want to say. If companies don't want to invest in technology, or pseudonymization or encryption, and then say 4% penalty is very high, I think they should blame themselves. So please advise your clients, if you are an auditor, that we will not accept if you say that it is not possible or it's not commercially feasible. Say, when some companies say security, we will be implementing only to the extent which is commercially feasible. There is no commercial feasibility in security. Okay? Either you are willing to take that responsibility. This terminology is there in bank, these things, because I have quoted this a number of times in the ICICI Bank in the court. Say, bank is saying in part of their terms and conditions, we will implement commercially feasible security, which means that you will do it if it is profitable to you, otherwise you will dump it. We can't work on that basis. It's commercially acceptable or something like that, which is, there's a best standard which you must have. So that kind of standard pseudonymization techniques must be used, and this is the first question an auditor should ask a company before you go into privacy by design, rest of the things. If they say 100 things I have got, If they don't want to use pseudonymization or this, they have to have a logic for that. Legitimate interest that I cannot use this in my process, therefore I want to take that risk. And then I will absorb that risk or something like that. So this is one aspect. Now, the other technology challenge which I foresee is at the very basic level. Now, how do you classify personal data, particularly if you are an existing company which is having legacy data? Okay. Now, is there a good personal data discovery tool or methodology with which you can be confident that I will run this tool across my databases? I am confident that I will be able to identify all the personal data which is there in my company and which comes under the regulation. Yeah, Mahesh?
Yeah. See, first thing is in classification, there should be identified owners for every data sets.
Identified owners.
Okay. Because many of the organizations, they might be successful in discovering the data, but at the end of the day, if you want to classify the data, the owners has to step in to see the criticality of the data. But there would be data sets which would be completely orphaned. We have come across this in the past. So which means could be the data will be critical in nature, but wanting of owners, the data probably may not be rightly classified, and hence it may not be provided the right protection mechanism. That is also an risk in the industry, which is still nascent, getting matured. Second thing, you have a process which clearly defines what is your classification criteria, what levels you have, what kind of data which fall under each of the classification criteria, aligning to probably the regulations and the law of the land, etc. So once you bring these two, the owners should step in and bring in mapping the data which they own and then classify it. Only then you will be able to assign appropriate protective mechanism, otherwise it will be an overkill.
Now, is the criteria for classification customizable according to the Indian law, or would you like to use what is there for a GDPR or something like that and adopt it here?
If the data is going to be generated in India falling under the ambit of the various regulations available like IT Act or DPA, etc., probably we have to align with those classification criteria.
Yeah.
But if you are going to get a data which is beyond the scope of these regulations, say for example, if my data will not fall under any of the regulations, but is it prudent enough to classify one of the, say, critical or sensitivity personal, it's going to be overkill for me. So which means the data owner should be sensitive enough to identify the criticality of the data falling under which buckets.
Now, when you say data owner, are you talking of the company as a whole, or you are talking of the individual process owners?
Within the company also there could be certain data owners.
Multiple process
Correct.
Owners.
Correct.
Okay, so that is now you spoke about sensitive personal information. Now, personal information under Indian law may be different from personal information under, say, CCPA. And at least even if there is no difference in the personal information, sensitive personal information definitely differs from one law to another law. Critical also may change. Now, how do we configure a standard tool which today may be available for GDPR processing kind of a thing? How do we make use of that in the Indian context, where out of my data store, first of all I want to classify some data as GDPR data, some data as DPA data, some data as PDPA Singapore data. First of all, at that level I have to make a classification. Then I have to get into personal sensitive critical under Indian data, personal special data under GDPR, maybe some other categories which are there. So we are talking of first level law-wise classification, second level this personal sensitive kind of thing. Then we are coming to the consent tagging, whether consent is available, whether I have picked it up from the public data, etc. Do we have tools which does this kind of an activity?
See, actually, within an organization, we can't have a very large subset of difference of opinion within the classification levels. Probably what we have to do is, based on the nature of data, what we collect, aligning to various regulations, we have to commonalize it. And how close we are commonalizing it is going to ease us in our way of operations. And there are tools which can help you with your level. You can define your levels, but application of that levels within the data rests with the data owners.
Okay. Now, of course, I'm asking questions so that your answers will
Sure.
perhaps educate everybody else. Now, when we are using this commonality feature and apply certain compliance to one set of data, are we likely to be non-compliant with another data? For example, if I don't distinguish the EU data and Indian data and classify it and put it in separate bins and apply the data protection laws differently, if I apply GDPR on Indian data or Indian law on GDPR data, am I likely to be caught with some non-compliance?
That is what I said in the beginning. First, we need to identify the scope of data aligning to the various regulations.
Okay. Yeah.
And then we need to bring in those classification levels, then try to commonalize it without impacting the regulatory compliance requirements.
Rajendran, you have got something to say on this? No? No. 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 I'm saying this is a complex thing. If I go to a company, this is a first situation. See, every company says I work globally. Data will come from the entire globe. Okay. Now, when I say you have to be compliant with Indian law, the question is, why should I be compliant with Indian law for EU data or reverse? They say go for GDPR compliance. Now, why should you go for GDPR compliance for my Indian data? My Indian data, GDPR application is 0. So you are compliant without doing anything.
See, in fact, if you take the SAS 70 complaints or HIPAA complaints, in fact, I am not competent to talk about those things in presence of a great man like Vittal Raj, but still I can venture to talk. If you strictly comply with those things, certain things, you may not be able to do business in India at all. Isn't it, Vittal Raj? Sometimes there may be some line of, distinction we may have to tread very carefully.
No, I'm only trying to say that in technology architecture, you have to see that data is put into different things, and Indian law also recognizes that exemption can be given to your data center if it is processing data of foreign nationals. Section
Outside
37,
the scope of DPA.
Section 37, you can get exemption. Vittal Raj has got something to say.
If I may add from similar experience, one of the organization on corporate governance laws. What they do is they map all the regulations, choose the most stringent of the regulations within each domain. Like Mahesh said, so what happens is of course you have the most compliant, whether particular law says or not. But you tag each of these control aspects to that particular element of law. So for example, if you filter based on the tag, let us say what all is required for compliance with the reporting under Indian law. So it will pick up all those items and populate it for you. So that is one approach I have seen.
Yeah.
That's the reason I say I'd recommend there is something called data strategy, which will primarily tag to these different kind of data elements, right from which regulation is from accountable, what are the risks exist there, what are the different rights and the principles. That way it makes easy for us to understand what are the data aligned to which regulation and which country and so on. So.
Yeah, please. Correct. That is as far as the claiming of any compensation, other things is there, that will come. Now, I am talking of an organization. Now, I am collecting data from California, I have to be CCPA compliant to that data. If I am collecting the data from Singapore, I have to be compliant with that. So, multiple jurisdictions actually are impinged on the Indian data processors. We can't avoid that. Now the question is what Vittal Raj said, one strategy is to choose whichever is stringent and then apply. Assume that because it is the most stringent, everywhere we are compliant. As and when the Data Protection Authority sends me a notice, I will reply based on that. The other option which Mr. Ramesh can perhaps confirm is, in our data protection compliance standard, we say that tagging of this relevant data protection law is a part of classification. When we classify the data, first thing is you put a tag. It is Indian DPA compliant or something like that. Ramesh,
Absolutely.
Yeah.
So what we are trying to do is that at the time of entry, right, wherein we're trying to analyze which
Yeah.
is the regulation applicable,
Yeah.
and what kind of the regulation talks about the criteria for each one, and the tagging is done at
Yeah.
a very, very entry level. So it helps us.
So we'll elaborate on
Yes.
this in the afternoon.
Yeah, absolutely.
But maybe it will technologically be a little more complicated. But this is what I want technology people to think. That is, there is no point in being GDPR compliant to Indian law or DPA compliant to GDPR law. Am I correct? Am I making sense? Yeah, Krish?
One comment is, with the tools that we are talking, there are tools in the market where it identifies personal data by regulation. So what they do is they build algorithms by regulation, and they build modules in the own technology. So one company can provide a solution for CCPA, GDPR, and probably for India also they can evaluate.
Yeah.
So it will identify. It's all based on AI and ML algorithms, which is running in the background, by which it identifies. Probably what happens is, today people might be identifying it manually, but over a period of time it needs to be like at least 80 to 90% of the personal data, leave about sensitive or non-sensitive. That depends on, as Dr. Magesh said, lies with the data owner. Who owns the data have to confirm. But the system will blindly identify based on the algorithms and give it to you.
Yeah.
And you decide, the human have to finally decide whether it is a PI or not.
Now coming to this algorithm, there are two things. One, we are talking of our regulation, which talks of algorithmic transparency. That is, you will have to actually some way disclose how your algorithm is processing the personal data. Okay, that is a requirement. So you will be required to do BIOS audit or processing audit of an algorithm. In fact, why I am mentioning this is it's a great opportunity for technology people who are conversant with privacy laws. You can develop a consultancy for analyzing algorithms and giving some kind of an assurance that this is compliant to privacy laws. Now, so that is a great business opportunity. I want the technology people to ensure that they do it. And second is algorithms, okay. For example, Indian sensitive personal data includes people with political opinion, religious opinion, and as I told you, religious identity, which in India, mostly it is embedded within name. If I take any tool which is being used in EU or something for GDPR, that is not configured to identify one Ramachandra Iyer with Rama Gowda or something like that as different sensitive personal information. For them, it is just a name. So everywhere, and some foreign countries, they take trade union information as sensitive. Now, India doesn't consider trade union as sensitive. So therefore, these algorithms will not be capable of providing a clear identification of sensitive personal data. If we depend on that, we are likely to make mistakes.
That's what I said. It will identify probably 20 to 80% of the PI, but it won't eliminate the.
No, if it makes a wrong this thing, then it's a problem. If it escalates it to human, it's okay. So that is why perhaps technology will have to see that it should escalate it to human evaluation, which should be done, escalated, is what technology configuration people will have to do.
So that is why nowadays, if you get into a lot of data-oriented tool sets, it gives suggestions to the operator. Based on your need, it pops up the suggestion. Finally, it's up to the operator to decide whether the suggestion given is true and fair or it is null and void wherein we need to manually.
So we
dig
need a
it.
hybrid model
Yeah.
of using technology with human intervention at the appropriate time.
Unless tools get matured, where you see the probability of tool recommendation is close to 99 to 100%, there should be a manual intervention.
Yeah, go in.
Go in here, sir. Most of the challenges what we have been discussing now and converging on tool from a technology perspective, they have been tried at least many companies, but the credit information again, harping on that, they did a phenomenal job. A company in India did a phenomenal job of adapting the homophones method. The homophones method is the one by which that it rather identifies data and puts it to box. Okay, this is, you said, for example, if there is a Nagarajan, Nagaraj Rao, Nagaraj Chetty, etc., that so many names are there, The homophones available in the world are mostly, they can only pick up and identify names in the West. The homophones that was brought here, they bought also spending a few $1 million to customize and all. They finally threw it because customization was not possible. How will you customize from A to Z? Customization, so you need to have a base on which you can customize. But the entire thing was became a waste, and they spent more than 3 years to develop Indian homophones. And they used etymology techniques. They used anthropologists. They used people who got to do with Kundalini Putra. Okay, so many people were brought into traditions and science. Everything was there. For 3 years they did a research. There was a separate person who was employed as a consultant, paid huge money, and he did it. And today, most of the Indian companies, credit card companies, think of it, how many crores of data are there with credit card information companies. So right now, they are able to do that. Earlier, people used to get even messages like, you need to pay this much, whereas they've got nothing to do with that. It is because of the mistake. And the mistake was horrendous. And most of them are corrected. And today we have a 90% efficiency with this homophones method based tools. There are at least 3-4 tools available with the companies in India.
No, I'm glad to know that there are solutions available for the Indian context, but this is what opportunities come up. When a law comes in, it is not only restrictive. The law actually gives us an opportunity to do something. Yeah, Manjula, you got something to say? Somebody, yeah, please.
During the GDPR days itself, like we have done this, one is like identifying the data owner and the data owner saying that, okay, these are my sensitive columns. This is the top-down approach. And then we have done the bottom-up approach also. That is, taking the data dictionary, studying the data dictionary about all the sensitive columns, then identifying a table that has the sensitive information, and then going up, like trying to find out which are programs that handle the sensitive columns, and then taking to the application level. So this is, for successful thing, we should have both the approach, that is top-down approach as well as bottom-up approach.
Yeah, ideally this should be part of your database design itself. Either in a database or in the application level, you should be having some sort of the configuration where you can select, configure accordingly, then make a decision. That should be the right approach then.
Yeah, this is for the structured data. Of course, there is a problem. There are unstructured data that also many organizations will have.
Yeah.
Still, there will always be a challenge. That is, you may have to run some tools to find out like where all these kind of packets are there. And then you have to do the encryption.
Now, as far as unstructured data is concerned, we have tried to address it in our standard in a different way. Let us come to that later on. Before we break for lunch, I think we'll take one more issue. Yeah. Please. Yeah.
When you started this particular panel, you were saying that when data is reasonably encrypted and there is a breach, right? The organization may not be penalized if there is a data breach and somebody re-identifies the individual. My question is, this particular statement that you made shouldn't put an organization into a lull that encryption alone will absolve
Let me clarify that. Encryption, I spoke in the case of HIPAA. That is, HIPAA High Tech Act has made a mention of that. Now, what is the standard of encryption which is acceptable? That is for the HIPAA regulator to inform. In the Indian context, in the first version of this, the Data Protection Authority was supposed to talk about, here we are talking of anonymization, okay. The Data Protection Authority was to set a standard anonymization, okay. And if you have completed that standard anonymization and then there is de-anonymization, you will not be perhaps held responsible, that person will be punished for criminal activity. But if the DPA has given some standard of anonymization, but you have failed to anonymize to that extent and you have used a weaker anonymization technique. Like in encryption, you have got these keys and other things. Here, anonymization, I don't know how to distinguish different levels. Let us say a weaker anonymization than what is given as a standard, then your liability will have to be fixed. So that is what I am talking of in the context of anonymization. So there has to be a standard. DPA is the person who has to give the standard, and when there is a dispute, the dispute will have to determine whether the anonymization standard used by you is higher or equal to the standard prescribed by the regulator or weaker. Based on that, the liability may be fixed. Yeah.
Even if an organization, let's say that the regulation comes in where they tell organizations what strength of encryption they should enforce, it should not lull the organization into skimming on other necessary controls. There is that challenge also.
No, it's okay. But if you are using adequate level of security of anonymization or in storage encryption, other things actually become irrelevant. No, you are talking of
but
sense
most
of
breaches, no sir, occur because
if
there are inadequate controls.
If there is a breach of encrypted data, okay, where is the harm? You have to ask the question to the authority. Prove me that there is a harm to the data subject, then I will pay you the compensation. If no harm has occurred, if you can prove that no harm has occurred, the probability of your being penalized will be less. Now, whether it will be zero liability like in the banks or limited liability, that depends on the standard of encryption for stored data, anonymization for other purposes. Yeah, Mahesh, you want to say something?
Adding to you, we have to see whether the encryption algorithm used is also breached or only the encrypted data is breached. If
So
as
suppose
long as
you are putting the key along with this thing in the same server, and if there is a hacking, that happens, no? And most of the cases of data breach, what has happened, the operator uses the same password for his GitHub account as well as for this encryption. That is negligence. So then encryption will not save you. You remember that is one of the data breaches. The operators were having GitHub accounts, same password was being used for the cloud this thing. So somebody stole that password and then used it in the...
there would be a password library also.
That is negligence. No, that is almost equivalent to an encryption. No, even our medical system, what is that? Dr. Path, there also the same kind of a thing is there. So that is negligence. So please look at it as a totality. See, if you have encrypted using 1024 key, but you have kept the key here, this is fine.
That's
That's
they expect you to have a reasonable security practices all around it, including the encryption.
Last thought for the technology team. Law says something called sandbox. Okay. Now, many of the startup companies or the objections which have been raised, they say that you are introducing this data protection law because of which I have got a problem in my activity. But the law has recognized sandbox system, apart from the exemption I said. What is the sandbox system? How can it be operated? Some thoughts?
Sandbox is nothing but a set of test labs where you can test your products, not exposed to your production network. It's completely isolated from your production network. How you do the isolation could be physical or could be logical. So, but we have to ensure that there is no data movement between these two environments. As long as it is a controlled environment, sandboxes. Normally, the testing happens in the controlled environment, which is also called as the sandbox environment.
So, this is an opportunity. So, when critics say that this data protection law is anti-startups, please remember that there is a 3-year time which is given for sandbox here. That is, initially you have to present it as a project to the Data Protection Authority, and if they approve, permission will be given 1 year. So totally for 3 years, a company can use the test bed of the sandbox, which will be somewhat under the control of the Data Protection Authority, in the sense that he should be satisfied with whatever controls you are having. How you satisfy, we have to see, and that itself is a business opportunity. Just as today there are data center managers, there will be sandbox managers. HP can start a sandbox management system or
Could
something.
be a good opportunity for a role.
Based on that, are there. I am only trying to say that this Data Protection Act has taken into account the needs of business, the requirements of the government, and the privacy protection, and tried to balance the requirement of all the three. It will not be 100% satisfactory to any of them, we can't help it, but we have to say that reasonably each section will be satisfied, and that is why we are about what newspapers write about section 35 or something like that. We will work on the compliance. I think we will have to break for lunch now. So let me thank Dr.
Thank you.
Gaudal and then
Thank you all.
Suhasini. I know I have not given all of them sufficient time, but that is something which I have to put up with. Okay? Thank you. We will break for lunch, and then afternoon session we will continue.
Come, madam. Yeah, you come. Vacation is with me. Again, right? Come. Yeah, you join. You have to join. Come, come. Yeah, you want a group picture? Thanks, sir. Guys, for lunch, and we'll again get back here by 2 o'clock. Am I correct? Yeah. 2 o'clock.
I request my panel members to please come over. Mr. Ramesh Venkatraman, Mr. Vittal Raj, Mr. Nagendra. See, we were not having these things. We were only having the virtual this thing. No, so I used to open computers and other these things. Here, basically, you could have this information. Why is it? So friends, we will start this session with the introductions. By that time, I suppose others can also join. So this session is very important from the point of view of understanding what kind of professional opportunities are being created by this law. And to discuss this, I personally look at two specific areas. One is as a DPO, what are the opportunities which will be for employees of an organization, and secondly for independent data auditors, which is an entrepreneurial kind of activity. So some of us are happy to be employees, some of us want to be our own bosses. For both, new opportunities are getting created. So we will discuss that. And to discuss this, we have with me Mr. Vittal Raj, who is a very well-known person in Chennai, a professional who is associated with ISACA for a long time, a chartered accountant, and also he is known as a trainer in CISA kind of training program. So he is one of those persons who is able to actually pass on the knowledge to another set of people, because there are a number of people who know but may not be able to transfer the knowledge. So there are only a few people who can do that. Vittal Raj belongs to that category. He has been conducting trainings on various aspects and is associated with clients worldwide, associated with cyber security, privacy, enterprise risk management, and so on. He is, of course, certified in a number of areas. There's no point in reading it because now he has gone beyond certification. He has to create his own certification. He is the founder and senior partner of Kumar and Raj Chartered Accountants, and leads the strategic risk assurance services practice. So he has been associated with other organizations like ICAI and ISACA International, ICWAI, and other areas. And he is a member of the RBI's Standing Committee for Cyber Security and IT Examination, member of IRDA Information Security Group. So a man of wealth of information, experience, and a very humble person who is very well known to the community. I have already introduced Nagendra as our founding director, and now I have the other director, Ramesh Venkatraman, who has over 30 years of experience in software systems engineering field. He is also very passionate in training, coaching, apart from audits. Okay. And he has been working on several standards, ISO standards and others, so he's got wide experience in that area. So in the next session also, he will be there to discuss our module of data protection standard also. Okay. He has worked in several organizations, including Cognizant, Siemens, Aptec, etc. Presently, he is associate, he's a portfolio manager, works in Carl Zeiss and holds responsibility for QMS and ISMS. So, a man of excellent experience. So, we will listen to his views also on this aspect. Okay. So, to start with, let us try to identify how this Data Protection Act generates some opportunities. For example, the first thing which comes to our mind is DPO. Okay. So, this act also says that significant data fiduciaries, that is data fiduciaries who may be classified as significant data fiduciaries based on either their turnover, sensitivity of data which they are likely to process, volume of data they are likely to process. Remember, turnover is also there in financial terms, volume is also there in terms of number of data sets. So there will be some criteria based on which the Data Protection Authority will state who are going to be called significant data fiduciaries. The moment an organization is a significant data fiduciary, they need to mandatorily appoint a data protection officer who has to be, as we understand the law presently, an employee of the organization located in India. In GDPR, there is a provision which says that a DPO can be an external consultant. Here, there is no specific mention of that. So, what we are saying is that DPO must be designated out of the employees so that there is accountability. So that if something goes wrong, there is an employee who is responsible. But obviously, the responsibility of DPO is so huge that it is very difficult for many organizations, particularly SMEs, to find an appropriate person within their organization to really hold this responsibility. So, such organizations may still engage the services of an external DPO consultancy firm, which means that that business is still open to you. You can still have that kind of an activity, but there has to be a designated DPO in an organization. Now, in larger organizations, there could be a group data protection officer, you may call him as chief data protection officer, regional data protection officer. Like that, you may have to create multiple people who can actually have the responsibilities for managing that that DPO requirements, functions, whatever the Act says. So, how many significant data fiduciaries could be there in India? We don't know, but quite a large number of people will be there. Because this significant data fiduciary does not mean only Twitter, Facebook kind of this thing, or even IT companies. Even manufacturing companies can become significant data fiduciaries because one, they may have a large employee base, because employee data is also personal data. Then they may have a lot of client base, particularly companies which have got a retail business, which could be even a hotel, which can be a mall. Say, look at malls today. Every day, thousands of people are coming into the mall. Their data is getting recorded in CCTVs and other things. So, a mall is also a category of data fiduciary who will definitely be a significant data fiduciary if it is of a reasonable size. Okay. So, there will be a number of significant data fiduciaries. All of them will be looking to appoint DPOs. Banks will be looking to appoint DPOs. Insurance companies will be appointing DPOs. So, there is a huge employment opportunity there. Second place is the Act says that significant data fiduciaries should do manual data audit from an external data auditor. And it recommends, JPC recommends that concurrent auditing, whatever it means. Okay, I would like to get explanation from Vital Raj kind of people, what we mean by concurrent auditing in a data audit situation. What I understand is that there will be continuous business. Okay, that's what first thing which comes to our mind. Throughout the year, an organization need to keep watching the data related requirements so that it is like a continuous audit. Okay, which means that external audit firms also will be fully engaged with one company throughout the year, and once in a year there will be a massive work. So this is an opportunity which every one of us would like to make use of. And of course, data auditors, the Data Protection Authority will give the credentials, and then they will accredit. The independent data auditors may be accredited by the Data Protection Authority. What criteria they will fix and other things, we will wait and see. But all the people who are today into some kind of auditing, maybe financial auditing or some information security auditing, if they have the flair for auditing, which is going to the details and then examining the activity of an organization, documenting it. See, some of the consultants are not happy with auditing purpose. If you ask my advice, I will give advice, that is easy. But you ask me to go through your documentation and point out mistakes, that is something which only real auditors have the eye for that. So there will be different kinds of people. If you are interested in that kind of an activity, you must understand what kind of skills are required and other things. So this is one of the things which we would like to discuss. And let us see what is the perception of persons like Vital Raj on these employment opportunities that may be generated if this law comes into being in the next 1 month, 2 months or something like that, both in this DPO category as well as in the data auditor category. Mr. Vital Raj.
Good afternoon to everyone. Thank you, Mr. Navin, for having me on the panel. As I see, we are discussing about a child which is going to be delivered any time, but we don't know when it is going to be delivered. But we know everything about the child before it is born. So there is a beauty about this child. So what I am going to say is obviously significant amount of extrapolation, which we would think from the experience of what GDPR Europe is happening and what is happening with regard to the other dimensions in our own economy is where my views are based on. So obviously there is that element of error and whatever. The first thing which I see is there is going to be an advisory big business which is going to come in. Whether it is applicable to me, how much is applicable to me, will I be coming under the exemption category or not? So these kind of questions are going to be extremely troubling. So I think that is going to be the first part once the act comes into place. Will be a huge, I think, opportunity that would come up is my sense. I'm sure, obviously lawyers, but this requires a combination of people who understand technology, operations, the functional aspects of that particular vertical, and as well as, of course, the law, because only these combinations somebody can advise what is eligible, what you're supposed to do, etc., etc. The second thing would be, since it talks about significant responsibilities for the significant data fiduciary. So we see that, I'm sorry, my reading of the act may not be so comprehensive, but what I understand, the DPA itself is going to come up with some guidelines on what all they should be doing and what are the checks and balances they need to do, etc., etc. So if we look at those, there will be need for a governance framework. Let us take significant data fiduciary. My sense, because we still don't know what is the volume criteria, what is the turnover criteria, etc. yet, which is yet to be specified. But I'm sure every bank, every large financial institution is going to come under the ambit of a significant data fiduciary, which is, I think, expected naturally. So when we start looking at this, the first thing would be they are already on several other compliance requirements, standards, etc. So you would expect such organizations to have an ISO 27001 standard. They will be compliant with RBI guidelines on cybersecurity and various aspects. Now, with all this, they need a framework within which to fit this new component, because this is kind of, if you look at the DPA compliance, it's a kind of carved out of various aspects, operational, other functional, technical, so it's kind of carved out. So, but it discusses on all the most sensitive assets of the organization, which is data. So, the first and foremost thing would be need for a framework, who, what, and when it should be done. So, all this need to be, there is need to be a framework. So, for setting up a framework, there is certainly going to be experts who are required to kind of, make sure they understand the nuances. And as I said, it requires a combination of various domains of knowledge to really advise an organization on that. The third thing is, what are you trying to protect? Most organizations don't even know where their data is. So, and leave alone the aspect that much of the data is shared left and right with their vendors or partners, as they call it, and you don't know what is your, because obviously we don't have watertight agreements with any of these, except in very few regulated sectors. But if you really look at even banking today, they are struggling because by the time you think you have answered those questions, they change the questions. That's the whole problem with banking, because that's the way it is moving. Because the technology is such, I join hands with the fintech. Fintechs after some time start dictating a large bank, because this is the way you should do business. But they also have a point because they are able to use technologies to create a market, which otherwise is not available to them. So I think when we start looking at all this, unless and until the data inventory is in place, there is no talking about anything on data compliance. So the first thing was, it's easily said than done. How do you get a data inventory in place? Like there was a point which raised also with regard to the metadata and how you would come up with the data dictionaries. Half the organizations don't have any system of data dictionary, mapping or anything of that sort. Besides, there's a combination of SaaS models plus, APIs running right across the entire system. So unless and until you're able to take stock of this entire thing, so data discovery would be the first aspect which is going to be a huge business, because I'm sure there are a couple of tools now in the market, but I think there will be certainly much more space for many tools. So I think IT on that front is going to be huge business as such when it comes to data products. The third aspect, if you look, is data management. The entire life cycle, right from the day you acquire or you create, go through every stepping of that process, right till you dispose of, retention period, etc. Everything needs to be managed. This is not practicably possible thinking that, okay, we will have a ticketing system and do that. It has to be a completely automated system integrated with their application architecture, which means my imagination when I looked at, the various current state of the large enterprises, they would need to re-engineer their ERP or CBS architecture. That's the only way that's going to happen. Either you retrofit something on that or you do whatever you want, but then you still need something, because unless and until you're able to do that, there is no discovery that's going to happen. The third aspect, if you really look at, is the operations aspect, day-to-day running, and there is a record of activities which is required to be maintained by a significant data fiduciary. Again, it is easily said than done. You cannot say, okay, there will be one guy sitting and recording what is happening. It's practically impossible. So you will rather put in a system which would independently, with its independence in the system, make sure that the record keeping as per the compliance requirement is taken care of. That is going to be a huge requirement, because the law clearly says if you are not maintaining these records, the DPO's neck is on the table. Very, very simple. So the DPO now, when it comes to their role, to make sure all this, in fact, I was quite surprised to see, if you look at the role of the DPO, is more of advisory. Of the 6 or all elements, it talks about advisory, making sure it doesn't say you operate. It doesn't say you implement. So that is a very interesting aspect. So which means he is more of a compliance officer. And he will be obviously reporting to the chief compliance officer of the organization. But the knowledge that this person would need to have would be significant. In fact, just looking at some discussion on cultural information. In fact, for example, we are discussing about Zomato in the morning. I want to have a curd rice. I order curd rice. That fellow says, today's offer, burger. Gives me 10 rupees. My Tair Sadam costs 70 rupees. I would say, rather go in for a burger, why not try it? But as he said silently, they are changing my psychology. Now, should I raise a question on my privacy or not? Because as Zomato says even in their ad, by 2023, India will lead what we decide. Now, we are looking at national security problem here, isn't it? So so you need consultants to understand these dimensions as well. Because these are private issues, I would think. If you are trying to look at, what I am eating and change my habits, that's not on. So, I mean, I may take it differently, but then that's not on, because that's where the idea is, because you're trying to do it for commerce. So, these are going to be very different kind of, I think, involving psychiatrists or what kind of dimensions we would be getting at, but I'm unable to imagine. But I guess there'll be Because if you look at the data definition now in the new act, it includes everything under the planet. So, I mean, then you got to look at, obviously behavioral data, this kind of data, that kind of data, everything comes into place. The consent itself, as you know, you have a consent manager, we are yet to see how it's going to pan out. But the consent itself is, I would think, one fantastic bypass link, right? Because if you get consent, job is over. I hope the consent manager would be able to do. But then obviously, knowing our Indian system, there will be lobbying between the consent managers and the data fiduciaries, which is likely to happen. They will say, no, this you are doing for this purpose, that purpose, scientifically proven, this study, that study, some nonsense will happen. So the big challenge would be, somebody has to overlook this. So the DPA will have a huge role to audit these agencies, for which you need auditors. The consent manager needs to be audited, like the, excuse me, if you take the digital certificates, the certificate providers are required a separate audit, which is a pretty stringent audit. So I think that is going to happen with consent manager. I agree with what Mr. Navi said. We are going to have not one, but I am sure many consent managers, because it requires vertical knowledge. It requires a tremendous amount of positioning for you to even understand whether I can permit for this sector to be exposed or not. So I think that's going to be by itself a huge thing. I'll be happy if that comes up within those 2 years, because that's still going to take some time, is my sense. So this being there, then of course the DPO's role, the continuous training that the DPOs to undergo. We are talking about significant data fiduciaries. Let us take the Tata group. You've got multiple business lines which are operating. Now, can you imagine one DPO will have knowledge of everything? It may not be possible. So, you're looking at a department then, and it will be a back office department. So, which means you need that kind of sensitivity to that particular segment, the speed with which the data moves in that particular vertical. Excuse me. The amount of sharing that happens across. It's a pretty complex algorithm, I would think. So all this, somebody needs a huge amount of functional experience combined with compliance experience, good technology background to really understand all this. I think, today, as Mr. Rajendra said, we are struggling to find CISOs in banks. Half the banks don't have CISOs. We are struggling to find independent directors. DPO is just getting introduced. Where are we going to create that many kind of professionals? So I think Mr. Ravi has a huge role to really create those professionals, I would think. Yeah, because there is no scope. I mean, imagine, even if you give 24 months time, by the time this guy becomes adequately equipped, at least 6 months, which means then afterwards he has to execute the task. So I think it's going to be huge, and the training business is going to be big. The day the act is released, there will be demand for CISO level training, board level training, operational level training, IT department level training, data auditor training, because data auditors, as it says, if you look at the act, the bill, it talks about a kind of empanelment criteria. It says this category, this knowledge is fine, but then it says shall be subject to rules framed by the government. So which means there is going to be a panel. If there is going to be a panel, there will be requirements. If there is a requirement, there is an industry for training, right? So which is obviously likely to happen. Now, can a chartered accountant do a data audit? If the person doesn't have a technology background, what kind of data audit can you do? So it is a pretty kind of mixed bag which is going to come up. And here we are not even looking at a system audit. I know this router, how it works, I know what configuration. No, you have to have the sensitivity to decide whether this data classification is right or not. I was just telling, in Europe, we have only data classification as an expertise, which is being sold. This is a pretty complex task. For example, there was a discussion in the morning, what kind of data classification criteria will you bring about? There is no decided basis. Some says public, internal, sensitive, but what is it that should go with regard to this? Can it align with the larger organization's data classification criteria requirement? So these are difficult questions which I don't think we have answers yet on, but these will be the founding pillars. The data classification is the founding pillar for how the data is going to be processed. We talk about encryption requirements. We need encryption experts. For example, certain data like card data under PCI DSS, under RBI requirements cannot be exposed anywhere, which means you need homomorphic encryption then. So which means the data has to be within the system itself, the way it is processed has to be complete. So you need technology experts for that. Because the moment you start running encryption, the pipe starts swelling. So now what do? You have to now need technology experts to see how do you assess the size of the pipe, assess the total technology required, data retention requirements. Now in various acts, the data retention requirements are different. Plus the organization has to decide, especially in the context of data lake, how much of data I will have. Now, I have to have a consent for all this. What kind of processing I'm going to do on that? Is that processing legitimate? Even though I say I'm trying to, drive out insights. It's easy to say that, but the point is that did you obtain my consent to do that will be my question as a data principal. But all having said that, I think that's 5% of the population which even understands what is data privacy in this country. Because for me, if you go by the history of our country, if my birthday is there, you better wish me my birthday. If you go to Europe and wish a birthday, they will take it the other way around. So it's a kind of a mixed bag that we are having. So it's a huge cultural, I think, transformation that is going to happen. It is going to require data principle level awareness creation, saying why this is required for you, why it is important for you to ask these questions, and then only I think the concerned manager can slowly start really even interacting with those data principals to say, what do you want me to do? So those kind of things. I think these are just some of my thoughts. I'm just kind of, but I think maybe we'll have other views on that.
Yeah, Mr.
Yes, sir. Thank you, sir. So, continuing the same statement of Mr. Rao, I would say that, kind of a new role, it may come up kind of something called data architect or data specialist, the way we have it in software architect or software designer. So, who would probably understand the technology, business requirements, legal framework, and also different kind of data being used in the businesses. Probably this role could be between DPO and the businesses who try to bridge throughout the data life cycle, considering the different frameworks and the laws to make sure that all the rights of the law, all the principles of the law, they are in line with what is expected. Probably that could be the one. Another way he was mentioning, in order to make sure that things are in place, a sure part of it, there is obviously going to be a data auditor. Again, he is going to audit the whatever implementation by the data auditor, data specialist or the data architect. He is expecting whatever requirement are the legal and business requirements. That would be the two more opportunity I am seeing there.
Very good afternoon, all of you. And happy to be here to share my thoughts on this. Quite interesting question, right? We all have experiences in having this kind of dedicated role, starting from ISO days, where we talked about management representatives, to in 27,000 we are talking about Chief Information Security Officers. We are talking about in business continuity management, BCM coordinators or BCM managers, right? I think this law or the data privacy itself is going to bring out new dimensions to the industry, starting from data privacy expert, data privacy architect, and then DPO or group DPO and so on. It's quite interesting if you get a chance to see, I'm sure most of you would have gone through the Personal Data Protection Act of Singapore, where if you look at their PDPSC, Personal Data Protection Commissioner of Singapore's website, quite interesting. They're talking about this role need to have two different aspects. One, to start with the data protection management, and second, on the higher side as an expert or subject matter expert, what they're talking about is data innovation. Interesting. Now, when you're talking about the first role, data protection management, it comes with the 6 competencies. Quite interesting. Understanding the different laws existing, as he talked about. He mentioned about Tata. I am referring probably from the software side, Infosys kind of organization, or Capgemini, right? Where we work across customers, across regions, across countries. Oh God. Today we are talking about 134 laws which are in place or going to be in place, like India. I was quite surprised. I was tracking all the laws. Last week in one of our Nyanavadini seminar at FDPPI, I was under the impression that the Sri Lanka, which was having the personal data protection bill like India since 2019 in the bill stage, I was mentioning it, then Navi sir corrected. No, Ramesh, hold on. Before the chaotic situation, what had happened in Sri Lanka, that in March it got released. Yeah? And they have also taken the pride to say that the first South Asian country to have this law in place. And unfortunately, we did not have that kind of pride at this stage. And what he said, before the kid is born, everything is ready. I am little bit concerned, right? The kid's name, the newborn kid's name, we started with the Personal Data Protection Bill of 2018, and it got into another name called 2019. Then we talked about Personal Data Protection Bill of 2021. And today we are talking about no personal data. It is DPA 21 or it is going to be DPA 2022. I'm hoping that the kid let it have the name called DPA 2022 soon, and this country will also have that kind of data protection law. Coming back, the kind of opportunities, as I started with, one, you need to have a kind of good knowledge on multiple laws, not only India or GDPR, etc. But having gone through in association with FDPPI, that if you are familiar with one or two laws, trust me, more and more it is going to be the kind of subset, or it's going to be a little bit tailoring, if I can say so, or customization to that particular country, right? You look at ISO 29100, the privacy framework, there are 36 personally identifiable attributes have been identified, starting with the name to email ID to gender to sex to etc. whatnot. You look at GDPR today, the personal data categorization is going to be from these 36. Or if you look at our PDPP bill, the definition of personal data is going to be from here subset. So let's not worry about 134 laws, how am I going to, but I am confident that the kind of effort what you're trying to put, we will be able to really absorb that. Second, the data protection officers obviously need to have how the cyber security incident management and taking it to the data privacy breach management, how it's going to happen. Obviously, it's going to be an extension of what we know already in 27,001 incident management probably. So we need to have a kind of categorization that how the data privacy risks are going to be or incidents are going to be tracked. The guy need to have, apart from the risk management, what we know typically, whether it's a business risk or a product risk, etc., here he need to have a good knowledge on how to identify the privacy risk. Obviously, this leads us into understanding the roles of the data protection controllers or your processors or the kind of rights what the data subject has got, right? You need to be very clear where the minor is going to be called under 16 or under 13 or under 18 or under 21. So you need to have a kind of gambit of knowledge on all these things, yeah, to understand what is the breach mechanism is going to. And obviously he need to have audits and compliance knowledge, right? And today we are talking about data audit. Let's be very clear. Data auditing sounds quite interesting. As we all know, right? 19011 guideline that which helps us to how to perform audit, etc., etc. But here, the focus is going to be on, right, the harm which could arise for the data principal or a data subject. So we need to look at from that dimension. So he need to wear a different hat altogether, in my opinion. And he need to have, what is the kind of ethics one need to follow in an organization, code of ethics with respect to data privacy. He need to have how to really look into the data what we have, harnessing it and to bring out some kind of innovation to the organizations and so on. So the DPO role, trust me, it's going to be a kind of game changer. But as he said, it's not going to come overnight. We all need to put our effort in terms of, that's why I like Mr. Navi's opening remarks. He said that we don't have to wait when the kid is going to be born, right? Let's be clear. And proactively, the section 50 of your act says code of ethics is going to be done, and we can really bring out those kind of code of ethics in place. Very happy to share it with you. Probably in the next session we are going to discuss about it. At FDPPI, we have already done the code of ethics with respect to the data protection compliance management system, right, which talks about beautifully all the 50 controls which are in line with the industry's expectations. Number 2, we are also talking about all kind of trainings which would help you, me, strengthening, empowering our knowledge base with respect to the data privacy. So I would say proactively, it's not that I am associated with the FDPPI to make this statement very confidently, but having gone through multiple frameworks within India and outside India, I can say very confidently at FDPPI, we are taking proactive steps. Yeah, thanks, sir.
Thank you. Yeah. So now if we look at the Act and see what are the expectations of the data protection officer as envisaged here. It talks of multiple responsibilities. One is, of course, advising the organization about what needs to be done. That is where the law, knowledge of what is Indian law, what is GDPR, when it comes to interpretations, how do we interpret in GDPR, what are the kinds of interpretations, whether the same thing will hold good here or something new. People like us will say we will do new interpretations. We don't have to just accept whatever has been done by somebody else. That is kind of my nature. But many other people will say that, oh, GDPR already has interpreted like this. We will try to use that. So these things will be discussed in the legal forums like adjudication and other things. So legal knowledge is required of Indian law, of laws of other countries, GDPR must, and the other Asian laws. Because when we go to the court or adjudicator and argue, one person will be saying that it is interpreted like this in GDPR, another person will say, no, that is not correct. So this knowledge is essential. And the DPO could be the person who has to guide the lawyer. You can't expect lawyers to be experts in this kind of activity. So they can help you in meeting the processes in the adjudication. In fact, adjudication most of the time is handled by the company people. Only when it goes to the appellate tribunal and Supreme Court, you need professional lawyers. Adjudication can be handled by a good DPO or the CC compliance officer. So that knowledge is required. And you have to advise the company. When do you start advising the company? When the company is accepting new business. In fact, when the business people have to start consulting the DPO and say, I am going to Europe tomorrow, I am having this discussion with this company, this is the kind of business I am likely to have, what should I do, should I accept it, not? Then DPO may advise him, you accept it only if it is like this, not like this. So that way, DPO becomes a business advisor. That is why the law talks of KMP level, okay. So advice regarding what kind of business impact will be there and what kind of privacy risks are there, that is one aspect, no law. Then there is something called data protection impact assessment. Technology people will have to prepare that, but this data protection officer has to advise the CISO about the DPIA, which means that he needs to have technology related understanding and knowledge. So that's why apart from law, he should know a good knowledge of DPIA, and sometimes DPIA may have to be taken to the data protection authority, because if there is a doubt, it is like going to the third umpire. There you have to argue in favor of your company, saying that we are not creating any harm to the data principles. So this is the process which our R&D department has found. So please permit us to use this. So there he has to step on the shoes of a CISO and get this DPIA passed. So that much of technology knowledge he has to be there. Okay, this is easily understood. Techno-legal knowledge is required. What is also important is the DPO is going to be the single point contact for grievance management, which means that these hundreds of data principals who have got their own complaints, some of them are silly complaints. As a technology person, you get irritated when they say, give me this information, that information. But this person has to have the ability to handle the masses in terms of handling the grievances. That is a separate skill. It is not, it's like a public relations officer kind of a skill. This person needs to have that patience to listen to these people and answer them. If you don't answer them properly, they will go to the adjudicator and escalate it and create more cost for you. There are many instances where they simply send an email, please confirm me whether my data is being processed. Now, to give an answer to that email, you have to spend 2 days to go through all your data store and other things. So people can create problems. If they don't like you, there are people who have, in GDPR scenario, followed for 2 years, 3 years, one mail after another mail, not satisfied with anything you reply. So it requires a lot of patience. This is public relations angle. Then grievance management. What is grievance management? It is arbitration, mediation. This kind of skills should be there to this data protection officer. And if you are going to the data protection authority, it is a skill to deal with the regulator. It is like you're going and having a discussion with a judge. It is different from having a discussion with an CEO of another company. The two are totally different. Regulator is different. This DPO is supposed to have that kind of skills also. So these are the different kinds of skills which are functionalities which is envisaged. And in that context, now I would like to throw questions to our people on what is the impact of this KMP? When the law says, when the DPO, this latest version says that DPO should be a key managerial personnel. Now in corporate law, I'm sure Vittal Raj is an expert. Now I want him to tell me, what is this KMP? What are the implications? Suppose tomorrow somebody offers you in your company, I will designate you as DPO. Now you have to ask, what is the impact of that on my career and my this thing? So, Mr. Vittal Raj, why don't you speak about this KMP aspect of this? Because this is not there in other GDPR and other things. It's exclusive to India. Yeah.
Thank you, sir. Actually, I have one starting point on that. In fact, if we looked at the responsibilities, there are more advisory. How can an advisory become a key management personnel is a fundamental question I have. Maybe, So once we have that, now the next question is, now since the Act says that this person shall be equivalent to a key management personnel, which means he is going to be officer in default for sure. There is no two doubts about it.
Yeah.
The more dangerous part is that he shall be privy to, supposed to have been privy to every sort of dimension of compliance relating to that particular area and be responsible and accountable for that. So which means that if something goes wrong, I'll send you to jail. So you'll be the person on the block. So the point really comes up is how, a key management personnel is generally in the helm of the organization. Whereas the DPO, are you going to equate him to the other CXOs? Is a fundamental question we have to ask. For example, you have a chief compliance officer. Will you have a chief compliance officer and a chief data officer, data protection officer in this case, sitting side by side? Because he is also a compliance officer. The larger compliance responsibilities are lying with the CCO. So, should he not report him to him? These are power questions, which I don't know how it will get answered. But yes, it possibly shows that the government's concern and the anxiety to make sure that they make a person equally responsible with regard to handling data, because data being the most important resource of an organization. So now organizations already are having a chief digital officer, chief information officer. What will happen to them, we don't know. So whether this will report to him, how can he become equivalent, how can a risk management professional who is the second line of defense become the first line of defense? These are questions which I don't know how it will be answered. But if we take the reading of what it is, well, first of all, where will we find these people within the organization or outside the organization? Fundamental question. Because somebody is saying, first of all, you should know all this, and ultimately anything goes wrong, your head is on the table. We will make you chief compliance officer. You will say, Udupa. Because there is no other authority that the person enjoys. Please understand this. He can only advise. He can ask questions internally. He has also the huge responsibility of directly dealing with grievances. It's not an easy job. You know call center people the way we trouble them, right? So imagine, I would ask, these are sensitive questions. What are you doing with my information? No, it is not something you'll put on the button and say, this is what I'm doing with your information. No. Last 6 months, what did you do with my information? So, I think we are yet to discover where this is going to go. But my sense would be this act itself would undergo an amendment within 1 year. Because this is going to be too much of a doing for a country like ours when already there are so much of compliance responsibilities. And this cannot happen without the entire automation structure coming into place. It is just next to impossible. Sorry sir, you asked about the concurrent audit. I forgot, I missed that. I tell you why. See, as far as I see that, why did this movement of DPA start? Mr. Navi would be a better person to do that. If you looked at it, India was not having a data protection law. Therefore, the West countries would not partner with India for certain aspects. This became the first GATT related issue. So what happened, they quickly came up with the ITA, but ITA did not really serve the purpose. They said, no, you need to have a Data Protection Act. So they came up with the Data Protection Act now. Now, once you get into the dynamics of that, we are actually trying to be better than GDPR. But being better than GDPR means that much amount of additional work. If you take the localization requirements, what is critical personal data, how is it different from sensitive personal data, how are you going to define all this? So it is going to take some time to define, but fortunately there is a government will define it. That's good in one way. But then there is already a definition of what is sensitive, what is private data. Then there is going to be a separate definition of sensitive personal data. Then there is going to be a separate definition of critical personal data. Critical personal data cannot leave the shores of the organization. Sensitive personal data can leave, but with copy inside. So somebody has to audit all this, no? And then report to the key management personnel saying everything is in order, so no problem. You will not have imprisonment or penalty. So this is his problem. So audit is going to be big business. But where are we going to find competent people to act as KMP position of DPOs? Auditors who are going to have a humongous job auditing. Concurrent audit cannot happen in something as traditionally it happens in banks to say there is a concurrent auditor sitting. It is a technology which has to run separately because every record, right from consent to activity processing records to everything, breach notification, everything is automated. You have to link up. Obviously, there will be independent software which is plugged into your application architecture and it will audit everything. That's the only way this concurrent audit can get done is my sense, because otherwise it is practically impossible. Do you mean to say you will obtain consent on Flipkart and say, "Nahi bhaiya, you signed," because the auditor has to see? It will be simply happening. So which means your robustness of internal controls right at every step is going to be a fundamental problem which comes under Companies Act requirement. Because that's a legal requirement. Because once this becomes law, it will become a legal requirement. So humongous kind of question marks on problems which I think would yet need to get solved. Sir, I think KMP, if I was offered, I'd say thank you so much. Sir, you missed out NAFRA, sir. So you have a whole lot of bodies. Just one point.
If I as a chartered accountant, practicing chartered accountant, want to get into this domain, I have an entirely different statutory body I am answerable to, which may or may not like this particular thing. There's definitely a clash. And what Mr. Vital said just now, compliance officer and it is what in our chartered accountancy terms we call it as make and checker concept, which is a fundamental requirement. That itself goes for a cost.
One thing is sure, sir. DPO as a virtual DPO business will be big. Because there will be a lot of organizations in between who say they can't hire a DPO.
Yeah.
So what will I do? I'll need a virtual DPO like a virtual CISO today is a big practice today. So that's bound to happen, I guess. Yeah.
I think I can answer your question. Quite interesting. It clearly says every law.
Not alone.
Finally, the management is responsible. Full stop. The top management. DPO as a role is going to be the kind of single point contact, coordinating with the agencies, data controller to processor to third parties to within the organization, conducting training, as you said, ensuring that all the controls are implemented, etc. But quite interestingly, even if you look at GDPR, categorically it says that the management is responsible, full stop, not DPO per se. So to answer you, I'm sure you can revisit your thoughts about the key management personnel now. I don't know about now what is going to say, but I'm sure that the top management, believe me, in Chennai, probably 2 years back, I was conducting a data protection impact assessment based on GDPR here in DLF, right? And haywire. I don't want to mention the name again, privacy comes into picture, right? And we are talking about privacy, I should not name the company. I was really upset, and 2 days had gone, and the kind of the turmoil what they had gone through with me, the organization here, and by the by, they were working for an EU company, So obviously the GDPR is most applicable to them. Nothing was there in place, right? The kind of I really appreciate if you can get it from my clue. anyway, I did not say so, right? I can take that. Finally, during the presentation, final presentation, audit findings, right? The CTO came because these guys went and gave that kind of feedback. I pointed out to him saying that, sir, you would be going to jail. You would be, in prison. These guys in the backside, they were saying like the great. Anyway, that is an internal problem. But I feel even in Indian law, I'm sure, right? It's going to be the top management guys. So, Vital Raj can think about, thank you very much.
If I may.
Answer your question, sir. Even in our financial auditor, we say that the top management, the board is responsible for the policies and all those things. See how many cases, in fact, for so many small things, the chartered accountant's head who is in the top of law. It's very difficult. I'm not being very pessimistic, but I'm telling you the reality.
Very quickly. I will borrow his statement, Vital Raj's statement, what he started with, right? We know in India what kind of law implementation, etc. A car accident happens, or not a car accident, a car going from Pondi to Chennai, caught during the COVID time, caught by the police, and behind the dicky full of liquor. I'm sure now you can catch who is the person. And then that lady said, I'm nothing to do with that, my car driver. Poor fellow, he was in the jail. So this is okay. In India, our DNA is like that, to pass the buck on somebody. We are talking about from the law perspective what it is insisting. I hope I'm making a point. Right?
No.
How we are going to implement it is left to you and me. Right?
Say probably the organizations have to find out how they protect their DPO. Okay, in terms of financial liability, you can very easily protect him by some kind of an insurance kind of a thing. So he will not be asked to pay. As far as the other aspect is concerned, that is the going to jail is concerned, we are talking of only one criminal offense under this DPA. Of course, if you have contravened Information Technology Act, it is different. If we confine to this particular act, re-identification of de-identified information without the consent of either the data principal or the organization which has handed over to you the de-identified information, that is the one which will have this criminal offense. So, rest of the non-compliance will only lead to financial liability, whether it will be 2%, 4% or whatever is that. And that the company should be able to provide insurance, and you are not expecting the DPO to pay from his salary. Okay. Now, this kind of vicarious liability is not new to India. We have been discussing in Information Technology Act, all these cyber crimes, we are holding the executives as vicariously responsible, provided you have either connived with the thing, then it's okay. Rest of it, you are negligent. Even here, as far as the criminal offense is concerned, like this section 85 of Information Technology Act, here also I think the same section number is there, 85. If you are negligent in implementation of whatever is that, and that is the cause of this re-identification, then only you will have criminal liability. So don't think that there are so many sections in which you will go to jail. There is only one section, and which has to be taken care of by mostly big data companies. So say, and technology people who sometimes are proud of their technical ability. You give me any encrypted this thing, I will break it. Okay. Don't get into that challenge. The breaking of encryption is criminal offense. Breaking of this re-identification is a criminal offense. You cannot become a sort of an expert by this what these people call as white hackers becoming black hackers. So many of the times, in fact, some of you are aware that when the first IRCTC fraud happened several years back, it was one CIFI employee who had proudly put it up on his website saying that I know how to break this IRCTC CAPTCHA and other things. You can book Tatkal tickets without any problem. I immediately wrote to him, please don't put it up like this, you are self-incriminating yourself, and he removed it. Fortunately, nobody filed a complaint. So technology people should know that in displaying their technical ability, they should not talk of these things. That is the only risk. as a chartered accountant, a data auditor, if you do a data audit, if you identify re-identification happening, then you point out. Okay, because that is a criminal offense. And as a chartered accountant, if you come to know of a cognizable offense, you have to inform. Even then, this is a cognizable offense which is which is considered cognizable only if a complaint is made by the data protection officer. Police cannot file a case immediately. Like in UIDAI also, Aadhaar also, only if the Aadhaar authority files a complaint, cognizance can be taken. Likewise here also, only if the data protection authority files a case, cognizance will be taken, then it is non-bailable offense. Okay, and that offense of a company extends to the executives, directors and others, provided they have been negligent. Okay, that is the only angle as far as the going to jail is concerned. Rest of it is all civil penalties. So do your best in good faith, to the best of your knowledge, you do the audit. Same way DPO also, to the best of his ability, in good faith, will discharge his duties. And beyond that, if there is a penalty imposed on the company will have to insure and pay. So that is one point I want to make, that let us not create a fear complex that DPO, let CEO think like that, you can ask for better salary. Okay, that this is the risk, okay. So, but that is the opportunity you have got, but it's a very prestigious position. Now, as Vittalraj said, yes, it will disturb the current hierarchy. The moment you make a person a DPO, he will sit with the board or like other CXOs, because this word KMP has been used in the law, automatically it will disturb. So it is now open to CISOs, CTOs. Why should they allow some external lower person to become a DPO? They themselves should take this course as what we are offering actually. CISO should be the first person to take a DPO course from FDPPI and say that, don't look anywhere else. I don't want to be CISO so far. Now you make me DPO. With my CISO knowledge, I can be a better DPO than anybody else. Otherwise, from the legal side, a compliance officer will become a DPO. He will sit above your head. There is no doubt about it. Okay. So, and the people who are in the profession of company secretaries, they can also come into this. So if you feel that there is an opportunity here, it will create disturbance. There is no doubt. It's a management issue. In fact, before you decide who is going to be designated as a DPO, just check. Otherwise, your CISO may leave.
One point on that. I think the Act says that the DPO, the CEO, MD, CFO can be designated as DPO. That also provides for that.
Yeah.
Ironically. So which means that if I have disturbance in the ranks, I would rather say, anyway I am signing on anything, one more.
See, there is an opportunity for independent directors here. A person with DPO, I mean data related knowledge, who is also an independent director, can serve both the purposes perhaps. Okay? Which one? There will be conflict. There will be conflict. He has to be redesignated. He has to leave this position and take that position. Okay. In fact, in GDPR, you know that in one case at least, when the compliance officer, chief compliance officer was given the DPO role, that was also held as conflict. Okay. So, actually, chief compliance officer is a law officer. So, he knows about law. He should, I feel that it should have been okay, but anyway, GDPR, at least one supervisory authority, must be French, I don't know, okay. They didn't accept that. So similar conflict situations will come here. Here, many companies have designated CISO come DPO. I think that is not very ideal. Yeah, Govind.
Sir, on quick questions.
1 minute, let him finish, yeah.
Organization or a data protection department.
Correct.
Will have more than one DPO. An organization like Infosys,
No, you should still have one chief DPO.
But there can be a situation where qualified professionals are recruited in say at least some 8, 10 or so in large organizations, right?
Yeah.
You know, that's the...
Yeah. It will be there. It will come because one person sitting in Chennai, if my unit is somewhere in Pune, how can I know what is happening there? So I need to have a person in Pune. But for designation wise, accountability wise, there will be one person in the company. Then there will be subordinate DPOs. Yeah.
There in fact there are a lot of practical difficulty, as Vittalraj was rightly telling. The conflict of interest between the DPO and the Chief Compliance Officer certainly is there. I can draw a parallel from the banking industry. About 12-13 years back, Vittal has been knowing it. The Reserve Bank Committee was conducting audit of various banks at the corporate level, like a long-form audit report and many other kinds of audit. There were series of compliance issues, one pertaining to the KYC norms, one pertaining to the lending norms, one pertaining to the account opening norms, and then lending, priority sector lending like. So for everything, one particular general manager, one particular DGM or somebody was responsible. Ultimately, at some point, RBI did not know whether it should write to the inspection department overall, they again passed on to the consent department. Then RBI did something very clever. I can't use the word clever. He said that every bank should have a CCO, Chief Compliance Officer. This Chief Compliance Officer would take care of all the internal compliance related rules and regulations of RBI, whether it is related to account opening or lending or priority sector lending or agriculture, whatever it is. So that this compliance officer will have a perfect rapport, hopefully, perfect rapport with the CEO, so that he does not pass the buck to the CEO and somehow coordinates among all the peer level CXOs, and ensure that the particular department complies with the rules relating to the department. Perhaps in the days to come, when this child is born, when this child grows to around, walking or some such stage, better clarity will prevail, I think, isn't it? Yeah. So at that time, something
DPO role is bigger than the compliance officer role because he has to be a compliance officer. In addition, he has to be a technology advisor. In addition, he has to be the grievance officer. So it is a bigger role. You don't have parallel as of now. See, there is no parallel to Data Protection Act, to any other act. Likewise, there will be no parallel. You have to consider this position as something unique, and we have to start understanding that. And there will be issues which will be coming up with the Companies Act now, whether he should be considered a KMP in the normal sense, like the default officer, and then no loans to be given to him. These are all other things which are associated with KMP, which are not relevant to this particular thing. So whether it will entirely be a replacement, or they have used the word KMP like an example, like such as CFO or something like that. Maybe the Data Protection Authority may have to give some kind of a clarification. You have got something to say.
I positively think this way, that because no other regulation is at least mentioned the role need to be like KMP, right? In Indian law, putting it so explicitly, I feel at this stage that newborn baby need to have a good caretaker, right? It cannot be just, and the key management personnel, as we understand, who could take a decision on spot. Obviously, the other things what you talked about, that guy need to be having knowledge, etc. It is definitely, we need to have. On a lighter side, I would say, please join FDPPI. Under Navi, you will all get trained beautifully to become a DPOs.
No, I say, if they had simply used the word senior person, it would have been sufficient. Only thing is, somebody in drafting, you used the word such as KMP, which was a mistake. Okay, they need not have used that. They could have simply said a senior management person, because we were anyway interpreting it only like that. Even earlier also we were saying that he should be in the level of the board, otherwise it will not, he will not work. Because he cannot advise a CISO unless he is on par with CISO or above CISO. So it is quite, it was understood. But in drafting... Yes. And then, if amendments do not have a market, I think many draftsmen in the market, in the Ministry of Law, will lose their job. Say, even CC... One amendment, it takes 6 months of 10-15 people working on that. Only one amendment. Okay, limited meetings and with the user departments, with the law ministry, several meetings, virtual meetings, physical meetings, all of this. All of them. And then, there is no law that there should be a CEO. Is there any law? There should be a CEO
I can have somebody who's a general manager and run the organization. But DPO is a must.
Yeah, correct.
CEO is not a
Must.
legislative compulsion. But DPO is a legislative compulsion.
So that is the premium value of the position, no?
And the only thing where I say that it is coming in future because it's a
Yes.
CEO is not a statutory function. If you appoint and then give him some responsibilities, it may become. But otherwise, it is a DPO is statutory function, whereas many of them
Even CISO and CTO is not a statutory function, no? So, only company secretary is a statutory function.
No, no, CEO. CEO is statutory.
Managing director.
Managing director is defined under law.
Managing director is defined. MD.
CEO is defined.
CXO, if I do not have a CEO and have only a managing director, can law say that I don't have a CEO in my company?
Depends upon which law you're looking at. Corporate law, if you take, for example, there are very clear definitions on, especially under SEBI. If you take corporate law, there are very clear definitions of who is responsible for what, etc. If you combine it with the SEBI requirements, the CEO is very much there. There is a certificate which is required by the CEO on various aspects of the organization. In fact, they are accountable for the internal controls of the organization. So there is a separate certification.
I'm talking about exactly. Are you talking about listed companies or you are talking about every company?
This SEBI comes under listed companies.
But think about how many companies are going to be there.
That's a point. First clarity that is required is these stringent regulations apply to significant data fiduciary, which means turnover. We have to understand what is that turnover, what is that volume of data. How will they assess volume of data processed is a question. How will I measure? Those are things which
Arnab sir, you need to moderate this forum in a much better way, sir. So only two people are asking repeated questions. People are all waiting. Thank you. Sorry if it sounded rude, but we are also waiting to ask the same.
No, please. I'm sorry, I didn't see that. That's right.
So, cloud computing, when it came before a decade, right, we were not prepared for it, and I called it as a solution for a problem most organizations did not have. Right? And auditors and professionals, both from the operation side and some from the auditor side, we have still not cracked how to audit a cloud perfect environment. Right? So my question is simple, like we have so many names that you use the example of having the child, right? Does India need this child at the first place? No. Because in an Indian parlance, you said about Zomato example, like converting everybody's mindset, right?
No, this came out of a trade negotiation to start with.
Yeah, so
as
are we as professionals lobbying that this could create a business opportunity for us with the government, so you have to introduce the DPA? Indian people do not think they need a DPA. That's
we are always incidental, sir. They make the law, we say, okay, what is in it for us? Very fundamental.
So should we be protecting the principals who are not worried about their data getting compromised?
No,
or should we be worried about the government which is lobbying for a trade act?
Yeah, that is the important question of a concern manager. I don't think concern manager there in GDPR.
No, I'm asking, I'll put it
See, I'll tell you, the population that we have, sir, inniki OTP ki vandu education no nadandru.
Correct, adha na solla varan.
Okay, we don't even have people understanding the importance of an OTP. Now, this is going to certainly take a while. This is a cultural change, that's what I said. It is not going to happen within 24 months. 24 months, you will possibly have the infrastructure in place to some extent, which also I expect could extend it. But is it necessary? We already see that number one, the digital India, especially after the pandemic, has gone somewhere. Right. You go to buy one koya padam, this fellow will say GPay. OTP. So, if that is a kind of population, don't you think privacy is important?
Population is not worried is what I am saying.
No, see, that's where education comes. That is the importance of protection of private information.
We want metaverse, we want. No, but metaverse is coming up.
அது ஒரு கும்பல் இருக்கு சார். அது ஒரு கும்பல் இருக்கு. சார்
and it fully spread over, you will have so many professionals involved in managing, designing, developing and managing metaverse. In India too. Similarly, GST is there. We've got so many GST practitioners. GST practitioners themselves did not go to the road and say, we want GST. So,
that's the point. I think that's See, what is important from a national perspective? See, protection of privacy comes under the fundamental right now. Okay, so which means, இருங்க ஒரு நிமிஷம் புரியுறது. See, எவ்வளோ பேர் சார் in this educated elite, how many of us have studied the constitution? நானும் படிக்கல, அது வேற விஷயம். So point is, it doesn't mean okay, you're not studying the constitution, therefore we'll not protect you. It is the state's responsibility to see if there is something which is against harm. That's what is defined everywhere. If you're going to be subject to harm, it is very much the state's responsibility to take the steps necessary to make sure you are protected. Otherwise, I'll say, okay, somebody kills you. You didn't know that somebody can kill you with a pistol. So I say, well, you should know. That will be the problem.
Sir, one.
Compliance relief, not compliance pressure. Compliance relief. So we as professionals, we are trying to address the market that aims to the compliance relief.
Sir, one question, sir.
Okay, now we have got another 5
Just
minutes,
one question on the concurrent audit.
No, another 5 minutes, so any other questions? Yeah.
You are talking about concurrent audit with regard to the data protection. So my question is whether, and you did mention about the technology supporting the process, otherwise it would be very, very difficult. Do you think that a blockchain is a good technology to support that kind of audit?
Academically speaking, yes.
Okay.
But இன்னும் கொஞ்சம் தூரம் இருக்கு.
Okay, thank you.
See, auditing, which also applies to concurrent auditing, means whether the company has issued notices, whether they whether they have collected the consent, all these things will have to be for each data set, which, for example, compared to last year to this year, or last period to this period, the inventory of data, how it has increased, and whether that is accountable. Maybe that is something which we may have to do it. We have to devise technology for that. Any questions from this area? Anybody else? Okay. So, yeah. But we must understand one thing, we are having something new coming up. It has to be an opportunity, okay? And there is no point in giving it away. When opportunity is flying past us, we have to grab it, okay? It applies to professionals in employment as well as professionals who are into some kind of a professional business. Then all chartered accountants will go out of business. Yeah.
Sir, once there was a head clerk and accountant in a bank. After CBS, both of them lost their jobs. That is bound to happen. Today, bank audits are not going to be coming for the auditors. That's a completely outgoing area. Now you still expect I must be going to audit. Somewhere you are living in a different age altogether. So you have to start moving with the opportunities. I think that's where but what you said is right. I'm sorry, sir. What's your question?
Do you see a industry developing for now that so many opportunities are there in this? Do you also see a industry of consent for consideration? That is, you can use my data, but pay me. Because we have heard, some, big social media companies using.
No. One minute. You are talking of monetization of consent. It is possible. That is what CCPA has already done to some extent. Okay, but it has to be. That is where consent managers will come in. Say, why do you want consent? I mean, in fact, there are dollar store in UK. We know that there is a store where you can exchange your personal data for that. Okay, so it may come, but how it will come? It will be like incentivizing the. For example, as a consent manager, now I want 1 million persons to become my member. I have to give him some kind of an incentivization for that purpose. So it is like loyalty coupons and other things which Paytm and others are giving.
That's what point saying. Your insurance company, if it tells you, if you permit us to access your personal data, there will be optimization of your insurance premium. We'll say yes or no.
Yeah.
உடனே yes போட்டுரும். 10,000 ரூபாய் குறையுது எனக்கு.
Yeah.
So how does this law going to apply for corporate privacy information? Corporates also have private informations like how they do business, right? So how is this law going to protect them?
No, that is IPR. That is not privacy. Now, as Ramesh was telling about company, that is not privacy. Okay, that is a different law. Okay, your business, information protection is trade secret, copyright protection and other things. Non-personal data. So,
that this is also going to cover non-personal information.
No, but
part of that
but
law
not,
says
I told you only data breach notification only is presently covered. Okay, not all aspects of this thing. And this comes under IPR related this thing, and trade secret, which is perhaps somewhere in that range. Okay.
I had written a small article, Mr. P&T, when GDPR started. Let us say in this hall, let's say DPA is in vogue now, it's past. When I exchange your card, you should take my consent? Or I should take your consent? How am I going to process that information? Will email anlama kodada? Shall I deem it that when I give my card, I can put it onto my Excel sheet or onto my LinkedIn?
Yeah.
So these are things which are not defined. These are going by good faith and trust. Otherwise, I have to put one annexure to this visiting card and give you, these are all the consent, please sign and give.
Okay, I think shall we break for tea now? And we have the last session on the frameworks. Yes, thank you. Thanks to Mr. Vital Raj, Nagendra and Ramesh for their this sharing of knowledge. let them make one more. So friends, so morning we started with discussing some aspects of the Act. Of course, we did not go through the entire Act. I would have actually been happy if I had been able to cover from at least an overview. We did not do that. We only gave the essential part of the Act. Then subsequently we had these three discussions. Now, what we are going to do in this session is to discuss a possible framework for addressing the requirements of compliance. In between, if you have any questions, basic questions on the Data Protection Act, I think even before we start, we can spend 5 minutes because somebody was asking about whether this act is applicable to only living persons. So such kind of things. I said yes. This law applies only to the personal data of natural persons and living persons. Okay. Now, that's why corporate data is not part of privacy. You can call it by different names, secrecy and other things, but it is not coming to privacy. Internationally, there have been discussions about the information of proprietary concerns. Now, should you consider a proprietary concern information as proprietor's information? If you look at it as a proprietor's information, there is a privacy angle. Okay. Similarly, there are issues such as the business email. Now, is a business email a personal information? Okay. In the GDPR scenario, maybe there may be different views. Singapore must be having a different view. In India, we don't have a clear answer on business email, but I personally think that an ID which can be given by the company, I don't have any control. And when I leave the organization, the company takes it away. I don't think I should call it as my property. So I consider that as actually the business property. Okay. It may contain my name there, but that is incidental. You say this is Vijay Shankar's chair. It is still chair belonging to MMA. Okay. So it doesn't become my property. Same way, business email, in my opinion, should be considered as non-personal. I don't know whether everybody will agree with that. Even the supervisory authority sometimes may not agree with it. But if there is an opportunity, I will argue like this. If there is an occasion where with a legal judicial authority I have to argue, I will definitely argue business email is not personal email. You know, there is also a case in GDPR where a person used the email, something like customer service at abccompany.com, to store his personal information and then raised an issue that this is my personal information protected by GDPR. That is not even a business email, but business email in the name of a functionality, like project manager or something like that. So GDPR, sometimes interpretations are very bizarre. I don't agree with all those things, but they are, you can say, precedents. Okay. Unfortunately, we cannot argue with that. So in India, we have to still carry out those things. Then one of the things which we missed in the earlier session was that our act talks about nomination. Okay. Was one of the rights. See, when we talk of rights of data principles, we are talking of the right to access, right to confirmation, right to portability, right to erasure, right to quality, then right to forget, right for grievance redressal, like that. In addition, this act, after the JPC, this thing, has introduced a concept called right for nomination. What do we mean by that? Nomination comes only for a deceased person. So, if the data principle has got a data with a particular organization, Facebook, Google or something like that, I can leave a message about how the organization should handle it after my death. who has to have a control. This is the simple meaning. But there are certain legal issues in that, because Information Technology Act does not recognize any say document which recognizes a right of a person after death. Similarly, consent also is a contract, we say. A contract actually doesn't survive the death of the person. Okay, so consent gets cancelled, and in Information Technology Act says that no will is possible in electronic form. So for both the reasons, this nomination is a dicey area. That is, whether legally it will stand the scrutiny of law. But as it is present now, right to nomination is considered as one of the rights which is given, and which means that you have to make arrangements for that. When you take a consent, when you give a notice and take a consent, by policy and technology, you should capture the nomination. Okay, this one more field you have to give, whether this is nominated, if so, to whom, what is the relationship, all that you will have to do. This is one aspect which you keep it in mind as an important aspect here. Then in the case of minors, there is one more issue which you have to remember, which will also affect the technology and other things. Before 3 months, you know that in the case of a minor, consent is given by the parent. Now, after the person attains majority, parental consent doesn't have a value. You cannot work on parental consent for a major, which means that at the stroke of 12 o'clock when the person turns 18, his parental consent becomes ineffective. You have to take a fresh consent. And fresh consent has to be taken only after 12:01. Okay, you take it earlier, it will be a minor's consent. If you have to take it post. So which means in your technology system or architecture, you should enable a request for consent, which will be timed after the person attains majority. The Act says 3 months before the person attains majority, you should start collecting this consent. And then finally, if you take it 2.5 months earlier, it will not be valid. That's what I'm saying. You have to ensure that even if you have taken a provisional consent, at the stroke of 12, you have to send him a confirmation and then take it. So these are some of the other aspects which we did not discuss. Beyond this, if there are any pending questions, yeah.
Since you spoke about applicability,
Mm.
you could touch on to whom it applies. I mean, whoever is doing business. I mean, like GDPR says, goods and services sold by to the European individuals. That is when that company is applicable, coming under the GDPR. Like that, for GPA, how does that apply?
No, it is similar here also. That is, say, we have to look at applicability from two angles. That is, for protection of the personal data, it applies only to natural persons. For obligations, it applies to corporates, government, partnership firms, proprietary concerns, everybody, all organizations. Now, if that company collects, distributes, or shares data in India, geographical listing, that is one applicability clause. Okay. Second is, if a company is established in India, even if their business is outside, collection of this thing is outside, because it's an Indian company, it is coming under the applicability. Now, if it's a company established outside, then if they are doing business in India, if they are collecting the personal information, then this also applies to them. But if there is a company which is having only foreigners' data, then there is a provision under section 37 that by notification, you can ask the DPA to exempt that processing from the operations of DPA so that there will be no overlap. Because if you are processing the data of EU, anyway EU data law is applicable. There is no point in two laws being made applicable. This again is something which our Indian law has recognized, other laws are not recognizing or they don't bother. They have not thought about this. Okay, so that is as far as the applicability is concerned. It applies to government organizations, NGOs, schools, colleges, where there is no appreciation of this. So say it's easy for companies actually, they can understand and then implement. Okay, we don't know whether there will be exemptions to charitable organizations. We don't know, it come. Say temples. Say now Tirupati temple has got a lot of personal data. Now what will you do? It is still applicable as of now. We don't know if there is any charitable exemptions for charitable organizations. It can come. So these are some of the things which will get settled as far as the applicability. And significant data of fiduciaries need to register, which means that non-registration can be penalized, which means that the first task which every company has to do after the act becomes a law is, am I coming under the applicability clause, and if so, am I a significant data fiduciary or not? If I am a significant data fiduciary, first of all I have to get registered, then I have to look at the DPO appointment, then the auditor appointment. These are all the things which are compliance requirements which will follow. Okay, shall we start with this session? So for this session, I have with me Mr. Rupak Nagaraj from KPMG. So you know about KPMG, so they have wide experience as far as the management consultancy as well as the audit requirements. And now when we are talking of audits, we don't know whether the big fours will start getting into data audits. And it is likely that they will have a vertical which will take care of this, because this is going to be an important area. So we are happy to have his representation here. Okay. I'm just trying to. Okay. He's associate director in KPMG. This is current designation, with more than 12.5 years of experience in various segments, including BFSI and others. He leads the cyber insurance advisory solutions. Okay, so we have been talking about cyber insurance in different contexts. As far as here, we were discussing about cyber insurance for the DPO, because we can use the word cyber because whatever liabilities come is because of cyber transactions. Okay. Then of course he is a certified privacy technologist, DSCI certified privacy lead assessor, and he's also done cyber law. Maybe he will do a FDPPI certified thing also, because say why we introduced FDPPI certificates and other things was that we are focusing on Indian law. Everybody else was focusing only on GDPR law. So we said under our module I, we will discuss Indian law. We will have a module G which will be the global law, so that both will be covered. So we are trying to bring some kind of a differentiation. There is no doubt about it. That is the value of experience. No? If somebody else has done something, I have to do something better than that. Otherwise, what is the use of my introducing a new certification program? I also have Mr. Govinda Srinivasan, who is again another experienced lead assessor and auditor in the ISO systems. He of course manages Paramount Dataware Private Limited. He also has experience in working with the government, Indian Railways, Ministry of Defense, and in Chennai area, I think he is well known for his audit activities. Ramesh is very fond of Govind Srinivasan. Okay. So we have another experienced person coming from the area of ISO and other these things which are important for us. So I invite the panel members and we'll start looking at this. See, we have looked at various problems and issues, but that is not the end of things. We have to find solutions. So technology solutions we try to find, maybe we will continue to find, but in terms of audit and other things also, we need to find a framework. See, many of the companies would like to have some guidance. Ultimately, see, every audit is an individual activity. Whatever framework you have used or anything, it means that when the auditor finds some fault, he will find a fault. You cannot say, I did an ISO certification 1 year back or 6 months back or something like that. So all audits are like that. The auditor, to the best of his abilities, gives certain guidance, but auditor will go away after finishing his audit, then it is the company which has to maintain whatever recommendations he has made. So the responsibility comes back to the companies. Many times when we ask a company about compliance, they will simply hold on certificate. This last 6 months back, we did a certificate with KPMG or something like that. We always keep telling that is fine, but this breach has happened yesterday. Now, will the 6 months back certificate will apply? It may not. So that way, companies need continuous guidance, which only can be given by the insider, that is a DPO. That is why DPO has to be responsible throughout. But when we are looking at guidance, we are looking at these frameworks, ISO audit and other these things as indicators, so that at least we know what to do. How we do it, ultimately it is left to us, but at least we should know what to do. Now we are trying to identify within the Act, what does it say? Does it say ISO 27701 is necessary or something like that? What we find here is that there is section 29 which talks about what an auditor should do. Okay, that is one guidance, that is what I am supposed to do. Then section 50 talks about code of practice. And in that, the DPA says that if associations and others come up with suggestions on codes of practice, there is a provision to approve. This was also there in GDPR, but I don't think anybody actually approached GDPR authorities to get approval of any code of practice. In India, we don't want to leave it. If nobody approaches, FDPPI will approach with our data protection compliance system. And we want to actually refine that and actually make it sectoral frameworks. That is the exercise which we have to do. So we are not going to give up by default this particular provision of section 50 and say that nobody in India has approached DPA, so whatever DPA says, that will become the law. No, we don't want to accept it like that. We will tell DPA what they should do. If possible, like in Pandi Bazaar you argue, no? So you are saying 100 rupees, I am saying 50 rupees, we will settle for 75 rupees. So like that we may be able to negotiate and bring sectoral concerns into their minds. After all, the DPA also will not know everything in the world. So we have to say that in our sector this is an issue. So please make this interpretation or change this. So that is what we are trying to do. So in this aspect now I would like our panel members to react. To what extent the current frameworks, which may be ISO 27701, which is inclusive of 27001, because 27001 is an ISMS audit, 27701 is the PIMS audit. That is the nearest. And IS 17428 is another attempt which is closer. So we are having these these things. I would like to have a reaction from you, how far they are ideal for compliance of DPA. Yeah.
Sure. Thanks, sir, and for having me here today. So I think it's a great starting point because like we've been talking about a lot of challenges with DPA and how we're going to implement it. And we need to start somewhere, and I think definitely going for an ISMS and plus PIMS is a great starting point. From a coverage standpoint, I think PIMS has also beautifully brought it. In the annexure of the PIMS, they have actually mapped it not only to GDPR, they mapped it to the code of practice within ISO itself on privacy framework, as well as 27108, which is on the cloud privacy. A lot of these aspects have been taken into consideration because there's a common question that would come up. And with regard to, from what DPA is talking about, again, I would like to go back to fundamentals because, irrespective of whatever the framework is or code of practice that is going to come in, the basics won't change. And for privacy, irrespective of the regulation, the principles will remain the same. So you take the OECD principles or the generally accepted privacy principles or GDPR or DPA for that matter, they're all common and it's very similar in nature. So that's not going to change. And that's very beautifully brought up in the PIMS, 27701 as well. There is also the BS 10012, which was, which is probably not as popular now that PIMS, this particular PIMS, even that was called PIMS because that was personal information management, this privacy information management. So that's another thing that a lot of organizations had gone in the past who were, more early adopters of data privacy, which again is more tuned towards, again, UK DPA and GDPR. But the PIMS is even more, I would say, comprehensive and takes into consideration as an extension of 27001. So, yeah, that's my initial view.
Mr. Govind, can you react to this? There is one more mic.
Well, I don't claim to be a data protection practitioner. I don't claim to be a data protection practitioner sitting before a lion and an elephant. And also here is also there another tiger. So I'm a rat trying to become a tiger. Okay, so I will take time, but I started showing my interest in FDPPI, and then I am an activist. Okay, I don the cap of an activist. Okay, so from that perspective, having said that, ISO management systems is my bread and butter, and I work in Middle East and Indian geography, and I have gone, to such countries like Costa Rica, and here up to Thailand, and in terms of in Spanish country, I need to, even for coffee, I need to speak in Spanish. And every day I used to have the dictionary and see that and go. So management systems have given me a new lease of life. I was an entrepreneur, a software development company owner earlier. So all my experience have given me opportunities to move with people of different strata, from beggar to the CEO, beggar to the minister. I've stayed in the jail also. Okay. So initially, so that, all this expanse of life and all have given me an opportunity to be a researcher permanently. I will now say that 9001 even has got plenty of requirements. It covers. If an organization is there only, certified or have implemented ISO 9001, you have plenty of controls that come up. And the idea is very objective, not subjective, objective. You have something to start with. So you need to encourage people. You have ISO 9001. Please have a look into and see how the privacy requirements can have a mapping with some of what you have done. Okay, it may not be exactly be mapping 100% apple to apple, but you have an opportunity. For example, if I say quickly the 9001 approach, the 9001 approach itself is because of the Annex SL requirements, which is the basis for ISO standards writing itself nowadays. The risk-based thinking, okay. Even risk-based thinking is also audited, and organizational knowledge. Please think of it. Please now put on the coat of privacy and then see what I am talking about. Competence, awareness, operational planning and control. Okay. Customer communication, determining the requirements for products and services, review of the requirements for products and services, design and development planning, design development inputs, design development controls, design development outputs, design development changes, control of externally provided processes. Please, convert that into even the codes of practice or the law. DPA 2021 is in the anvil. Type and extent of control, information for external providers, control of provision and service provision, identity and traceability, property belonging to customers or external providers, preservation. This much is the, the coverage. Okay, when we say to our client organization or the organization where we have worked, and if we say, we have a humongous job to do, okay, now what we will do? Okay, so even the procrastination can take place. Oh, this is a big job, we need to take time, we need to go to the board, we need to go to here and there and all. So if we say that, you have got already something to start with, I think there is a good climate of listenability we can create, I believe. As far as 27001 is concerned, not only 27001, because of the way how all the ISO standards, ISO management system standards, Type A. Type A are the standards for which you are certified for, your organization is certified for. Type B are not used. So in that, in the entire thing, class 4, from context of the organization to leadership and commitment, and 6, action to address risks and opportunities, 7, support, that comes under where, awareness, communication, competence, all that, are coming in that. And then 8, operations, under that operational planning and control. And then before that in 6 itself, action to address, and then information security objectives. And all that, and go down, and to 9, performance evaluation, under that monitoring, measurement, analysis, evaluation. All that are all, you see it from a DPA 2021 perspective to start. Okay, so the hand pump, you need to put some water where you don't have the pump, the water, it's not coming up speedily. You push some water inside, and you need to immediately start pumping. If you take another 2 minutes and then do that, the water will go down. So these, whatever that I am talking about, that you can use it as a water to push into the pump so that you can start and get some water, and after that it will stabilize. Then put anything else into the picture, more people, everything is fine. But in the XRS 27001 focused way of talking about, you have two things which we need to remember, because you are already certified for 27001 in your organization. So A.18.1.1. So far I have avoided talking about classes, numbers and all, but right now I am saying, because I am only going to talk about two controls. One is A.18.1.1. A.18 is compliance. Under that, it is a road roller. It is a road roller class. It talks about all relevant legislative requirements, contractual requirements. Please think of it. Contractual requirements also, legislative requirements also. All are covered under the A.18.1.1. That is a risk treatment control, and that completely gets sucked into in your ISMS architecture. A.18.1.4, which is a PII. It talks about your compliance with the PII. It is a risk treatment control. Obviously, you would have done the risk assessment for that. If you don't have a risk assessment in place, you cannot talk about this at all as risk treatment controls. What I'm talking about is a risk treatment controls put together, and a whole lot of things like access control. Okay, in access control, will you have personal information? When you are doing the user review, access rights, user review of access rights, will you not have a person's name? Is it barred from? I have seen 2,000 people's names in one particular locational office alone. All the names, everything is coming up. And what about HR? Okay, in HR security, under 27001, think of background screening. A whole lot of background screening information are available for with HR. Many of them are printed also. How you are going to be keeping it? Come back again to compliance, record management, that you need to preserve records. That is another control under compliance. So you have already, because let me not include more and more, you've got plenty, but you have a good amount of available controls implemented already. They are not sufficient. They are not sufficient. But the idea is, as Albert Einstein said, that the science we have is very primitive. But that's what we have now, from where we need to look into the world, future. Okay, so same thing here also. And I strongly believe, I had a cursory look into, and had attended a few knowledge sections with Ramesh. So Ramesh is my point of contact for me to become a terrorist with the FDPPI. So he always used to say, you should have been a good insurance salesman. He ended up with the FDPPI and with Carl Zeiss. And he used to say, no sir, you need to, tomorrow morning, 6 o'clock you will give me a call. So he's a messiah agent. So I am also subjecting myself to his torture, willingly, pleasurably. So my point is that the standard that FDPPI is bringing up, it is comprehensive. It is a version 1.0. It may have to go several revisions. And I find that Mr. Navi is listening. Both of us are almost same age, but I consider myself as a small Hanuman before him. Okay, because when he opens up and talks and also the sections and all, he sleeps with the sections and wakes with the sections. So for me, it will take time. Okay, for me, management systems is the is the space where I swim. He swims with and then the number of things which you have to read, and all these things give me an opportunity for me to think that the DPSCI has got DPSCI, right? DPSCI, which is the standard which is already there, which is being further developed over a period of time. 5 years from now, it may be looking very different, but we need to have a start. We cannot say that, okay, we will have an excellent one 5 years from now. We don't have anything now. So there is no meaning. So the world is always in the move, and we need to travel along with that, with whatever that we have to swim. And that is there right now. And this one can always develop, and people like me, and people like many others on whom Mr. Navi has got reliability, trust, dependency, and then consistency. Very important. Consistency. Somebody may say something, you need to do that, and all. What he is going to do himself, that is very important, because it's an organization. So I believe that DPSCI will be a better choice, and over a period of time, it can suck in many of the existing frameworks, standards, models, etc., ISO management systems are standards. ITIL is a framework. CMMI is a model. Okay, these are all the, I come from that etymology background, in the sense, naming conventions, semantics, etc. And I'm a records management professional also. ISO 15489, my company was the first one to have implemented 15489 in India, anywhere in, and we did it for the Department of Income Tax, Electronic City. Okay, so where I learned a lot. Every consulting opportunity, consultants learn a lot about business. So I also learned that. Okay, that's my quick and long reply. Thank you very much.
Yeah. Now, before I ask Ramesh to add and say how the data protection compliance standard is perhaps supplementing the ISO and other things, I would like to say that we called this as data protection compliance standard because after all that, ultimately, as I told you in the morning, we want to be compliant with this act so that this 4% risk is mitigated. I am keeping that at the top of my mind. 4% risk is a risk. Various other risk, hacking risk, that risk is different. Now I am talking of management perspective. I don't want my company to be in that risk. So that's why we called it as data protection compliance standard. And the system like ISMS or PIMS, we wanted to call it as data protection compliance management system. So what I want company to do, put in a system to be compliant with whatever is required by law. So just nomenclature, also it helps us to distinguish ourselves from all the existing standards. But if you are compliant with the law, you should be compliant with the PIMS, you should be compliant with ISMS because that is part of the law. If the lawmakers have created the law properly, they should have taken the privacy requirements. And privacy cannot be protected unless you protect the personal information from the CIA angle. So I feel that what we are doing is inclusive of other things. So maybe Ramesh is one of the persons who worked closely with me in architecting this thing. So, and he is himself an expert in ISO and other these things, so that I would like him to say a few words on our framework and why we are trying to hit directly the compliance requirement. Nothing else. We want to address only that. That is our objective. Yeah.
Very interesting topic. I'm sure that all of you will agree with me that we have multiple frameworks, multiple standards. As he introduced ISO 27001, which talks about ISMS, 27701 talks about the PIMS. We have British Standard 112. We have UK Data Protection Act, whatnot. This is from the standard perspective. And we also have different kind of frameworks, right? Starting with our DSCI, what Rupak talked about, Data Security Council of India, their framework. And we have NIST framework, which is very quite popular, right? USA, they have privacy, security, etc. Then we have multiple models, what he talked about. Now, there was an interesting question in the morning by him. I'm sorry, I'm not getting your name. Sorry? Fair enough. He said something, right? He asked a question in the afternoon. The question, I was about to answer, then I thought that I will cover over here. The question is that even his question, right? Are we ready? Are we not going to be bogged down with the kind of cost involved in terms of, as Philip Crosby said, quality is not free. And so, privacy is not going to be free. Information security protection is not going to be free. This is the bottom line statement. Organizations need to incur. Organizations need to spend money, right? Having said that, the problem today is, if I want to be a PIMS certified organization, ISO 27701, it is going to cost me because I need to first implement 27001 ISMS and 27002 the guideline, which is going to help me to implement the 114 controls of 27001. Then I need to look at 49 controls of my 27701. So we are talking about almost 163 controls. First I need to implement it, then only I am going to be certified. Now his question is there coming in. I don't have that much kind of bandwidth. Now what will I do? And as we discussed in the previous section, right? I am an organization working with the GDPR organizations, right? CCPA from US or India, obviously we need to be implementing it like that multiple kind of laws. Oh God, the question, we always say organizations will be doing only and only the audits, right? They will be into big trouble. That's where the idea of a framework which should help each one of us in this country, wherein I have a multiple kind of regulations like GDPR, CCPA, CDPA, PDPA of Singapore or PDPB of India and so on, where there is an answer. That answer is nothing but our data protection standard compliance management system, what you are talking about, from FDPPI. The section 50 of our law, right, the current bill talks about code of ethics need to be prepared. I would say that we are already ready with the kind of, capsule what the industry is needed. Now, this one is beautifully defined, taking the best practices of, including HIPAA, right? Now, where they talk about kind of, mandatory specifications and then addressable requirements, what we call. Addressable requirements are nothing but organizations can interpret and little bit, tailor it to their needs. Same concept we are bringing in here. We are going to have kind of 12 standard implementation specification, which is going to be the driving force for the organization to take the step in terms of implementing and protecting the privacy, etc. Supported by 50, implementation specifications, what we call. Quite interestingly, we have done the mapping. Be rest assured, all these 12 standard specifications and 50 implementation specifications are mapped beautifully to starting with GDPR to PDPA to 27001, 27002, 27701, etc. Right? So, in my opinion, you don't have to worry about 27001. You do not have to worry about 27701. Start implementing PDPSI. The good news is that, as Mr. Navi introduced in the morning in his open remarks, it's also going to be an open standard. That means, you and me know, right? If you wanted to buy an ISO certificate, ISO standard per se, I need to pay so and so, and then, then only I'll be able to download it, right? Here it is not so. It's an open standard. You and me can download it from the FDPPI website, and this standard is going to help you in 3 important areas. 1, for an implementation perspective. 2, towards the certification perspective. 3, to establish the measurable framework, what is expected as part of our data protection law, which is unique. Be clear, no law talks about that you need to have a data trust code, except that Indian law. Quite interesting. So, extending what Mr. Govindan talked about, 9.1 in ISO 27000, let's say, measurement, analysis, evaluation, and continual improvement, right? I am going to take that measurement and trying to build over here in my system, DPSCI, right? Please look at the data protection compliance management system, and I am sure all of us will really appreciate what kind of thought process had gone in by FDPPI to come out with this kind of a single framework. I'm sure it's going to be unique at this point of time, because the kid is not yet out, as we discussed in the previous section. We are already ready with the kind of, what it's to wear, right? Girl or boy, we will decide later. We will come to know, but we are ready with the kind of what it needs to have. So I would request each one of you to have a look at the framework, what has come out by FDPPI. Yeah. Thanks.
See, there are 3 important things which I would like to further expand, which are also, you can say, some distinguishing features here. One is, Indian law has said the data auditor, external data auditor, may have a data trust score. It's like an assessment, it's like a credit score, like the ICRA or CRISIL rating. After completion of his audit, he can give a score, okay? Now, whether this will become mandatory or not, we don't know, but it can become mandatory. And sometimes peer pressure may make it mandatory. If 10 companies are going to publish their data trust score, 11th company not publishing it may not look good. So, data trust score, as we go along, may become mandatory. The auditor anyway has to give it. Now, publishing it is left to the discretion of the company. But somewhere they make a mention that even in the notice to the data principal, you have to mention my company's data trust score is so much. This is where the consent manager system will also help. When I as a consent manager try to put 10 companies into my fold, I will ask what is your data trust score. I want to put it in your company's profile in my this thing, okay? And Data Protection Authority is also going to put it on their website. Say all significant data fiduciaries who are registering with the Data Protection Authority with their privacy by design policy will be showing the data trust score, and that becomes a public document. So public knows, okay, this company data trust score is so much, this is so much. Why is it necessary, or why is it beneficial if you think like that? See, we are all aware of this credit rating for debt instruments. If a company wants to raise money from the public, we expect them to publish a prospectus, file it with SEBI. Secondly, if it is a debt instrument, they have to take a rating. Is it not? Same concept is being used here. That is PBD policy, that is privacy by design policies. GDPR stops at saying you should have privacy by design. So you can have it as a company, it becomes an internal document. Here privacy by design has to be reduced to a policy document, and that has to be certified by the Data Protection Authority. It is like filing the prospectus with SEBI. That is, I want to raise personal data from the market, and why I am raising it, I am writing it down here. How I am going to use it, I am writing here. Like raising money, you are going to give project details, etc. in your prospectus. Same concept has been used here. And similarly, in a debt rating, debt instrument, giving the credit rating gives an indication to the investor, this is the kind of risk I am having if I invest here. Same way, the Indian law says you publish your data trust score, so public will know I am giving my data to X company whose data trust score is 60, another company is asking for information, data trust score is 30, I will not take their service. If it is a comparable service, I will take the first company. So this is the concept behind this. Now how it will actually work and other things, how we will make it work or we will reject it, that is left to the community. But the concept is, we say data is money, no? So before raising the data, we want companies to come up with what is my project of using your data. That is where the PBD policy will have to talk of the record of processing, how I am using, why I am doing, all that will come. So this is one aspect, data trust score, which has not been there in earlier frameworks, so that is a new thing which we are having. Then there is the concept of data valuation. Morning also I was talking to somebody. We feel that, in the IS also many times you come across that. The organization CFO doesn't understand how much to invest in information security. Only information security person, CISO knows that a new software has come, new control has been done, I have to invest 5 lakhs in this, 10 lakhs in this. But CFO doesn't understand. He will say, why do you require this? Last year only we upgraded our system, why do you want to do once more? So there is no visibility to the value of data which companies are protecting. Now, inventory we are talking of, but inventory doesn't come into the balance sheet. So people do not know what is the asset they are protecting. Say when in Air India last time lost some data, until that time they did not know what was the value of the data which was there. Then some hacker takes it and puts it in the dark web and says, this is the value at which I want to sell. That value the management should have known earlier, that I have got 5,000 crores of data with me. Therefore, I want to invest say 10 crores for protecting it. Without the visibility of that value, I feel the industry is losing the need to protect, how to protect it. So we felt that data valuation is a concept which we should develop and make it part of the standard. Now somebody was asking, how do we value? I think you were asking or somebody was asking, okay, how do we value? Now, we have the concept of any asset, we value it first of all at the cost of acquisition or the market value, two major things. If it is a finished goods, you value it at market value. if it is not, at least you will have the cost of acquisition. Same thing can be applied here also. And you also have a system of revaluation. Once in a year, you can actually revalue. Some assets will need to be revalued from time to time. So you can use various methods which are normally used for asset valuation here also. There is also this net present value method. So different kinds of data valuation method can be used. Chartered accountants are aware that sometimes we use multiple methods and average it out. So there is a method of valuation. When it comes to personal data, there are some very special features which need to be built into it. For example, the personal data has cost me, let's say, 100 rupees to acquire one data set. Now, after 1 year, what will happen to that? Whether it will depreciate or appreciate. Certain kinds of assets will appreciate in value, but in many cases, it will depreciate. Fixed assets will depreciate. Now, in personal data, if you have taken a consent, which is valid for 1 year, then after 1 year, that personal data should be scrapped. So its value should be depreciated to 0. But if you have taken a recurring consent, maybe you can depreciate it over 2-3 years until the data becomes useless. Okay. But if it is a single purpose consent, it has to be depreciated with single purpose. So these are all the thoughts which have to go into the data valuation. We are still at the stage of recommending this thought process to various organizations, and we have to still develop. In fact, we need to work with people like KPMG and others to actually take it to the next level. Today, as data protection people, we felt that if the company head doesn't know what is the value of data, he is not going to invest in it. Therefore, we want to bring him the visibility in the balance sheet. Even if you and I don't agree whether the value is 100 crores or 150 crores, we say that you bring it as a contra item in the balance sheet. Show that on both sides so that your profitability and other things will not get affected. We don't want to declare dividend out of this thing, but we want the management to know. So, how to value it, how to make it visible in the balance sheet, these are all issues which we are discussing with the accounting community, but we have already made it as a part of our standard. We'll ask that question to every company. Do you have a system of valuing? Do you know how much of data value you are having? Without that, what is that you are implementing as a data protection? This thing is a question which will rise. Maybe it will take several years for companies to actually answer that properly. Today, we know that they will say, no, we don't have any data valuation system. But at least we have got an inventory, because without inventory, we cannot even proceed. We know the inventory that we have got, say, 10 million data sets, out of which 6 million is personal data, 1 million is, let's say, sensitive personal data, something like that. That at least they should have. Without that, even we cannot proceed. But what is the value of that? They may say, today I cannot say anything much about it. But we will plant this thought in the corporate managements so that they will go ahead. A third element which we are trying to bring in is the distributed responsibility. That is, we have discussed in the morning also, there cannot be one DPO for a big organization. We feel that every person in the organization should be a DPO for his system. Okay. If I have given one computer, he is a work from home situation, then there is no point. A DPO cannot sit and see what is there, what is he doing at home. So we have to say every person is his own DPO, conceptually. Okay. This also addresses the issue of unstructured data which we are talking of in the morning. How do you actually get consent for unstructured data and other things? Sitting at the DPO's head, I don't know which employee is getting an email from somebody which is having a personal data or something like that, how many copies he is keeping. So I am saying that in part of our, standards or implementation specification, when we say that each person is his own DPO, we say that you have got an email, you should know that it has got personal data. It is your responsibility to hand it over to a custodian. Delete it from your system, hand it over to the custodian will take care of it. That much of responsibility we want people to have. These are some of the things which we have brought into this system. And I would like Mr. Ramesh to explain that we have about 20 implementation specifications which are exclusively security oriented. okay, which you can directly compare with what is happening in the other this thing. So maybe you can talk about what are the 20 implementation specifications. Last we will go to the governance related things. First we will look at what is familiar, technology related things, and say how it helps in this thing.
So as part of this framework, we are talking about 50 implementation specifications, which is being grouped under 5 different categories, starting with management as usual, HR, legal, IT, and DPO, right? Now the question is now under IT, technology, what all we are talking about, which is mapped to, our 27001 Annex A controls. So here we start with record of processing, okay? Obviously every organization need to maintain, right? When you wanted to prove that providing the evidence towards compliance. Then second interesting control we are talking about discovery of and consent to tagging and inventory of personal data, because this is the starting point. Even in the previous section we talked about it, right? Data inventory, data flow, data mapping. We need to have a proper idea across the organizations, across the business units, right? And consent to tagging, right? Whether we have got explicit consent, for example, for sensitive personal data or critical personal data, etc. You need to maintain it. The third one we are talking about classification of data from the compliance perspective. This is going to be the kind of, the lead factor for the implementing the entire privacy management system. The fourth control we are talking about, legacy and publicly available personal data processing. Quite interesting. Even in GDPR time, May 25th, 2018, when GDPR had come into existence, there was a big question that on 24th May, if my data is available in public domain, right, whether in any of the social platform, etc., whether GDPR is coming into picture or no, right? People were going haywire. Nobody had got the kind of right answers, right? But that just got settled down on its own, that as much as possible, try to go back, or the first time use, when you are going to use any kind of data, try to go back to them and take their consent is what we recommend from the industry perspective. And we talked about this morning, there was a question related to unstructured data. Look at it. I'm really happy that whatever we discussed since morning is already got encapsulated into this framework what we are trying to introduce to you. So how to handle the unstructured personal data? Again, you need to kind of process, you need to kind of system in place to identify, for example, email. From the email, what kind of personal data we are trying to, so you need to capture the name or to whom you are trying to address or any kind of sensitive information you are trying to share over the email, right? And we need to have a kind of system over there. And we are talking about access control. Access control covers both the physical and logical. Obviously, this is where we are going to control the data based on the classification, what I talked about earlier, and data storage and security, what kind of storage we have provided, because today the encryption is the key when you are keeping the data at your end, right? So make sure that provide the security of the data, transmission security. As we all know, the basic concept is we need to take care of 3 important factors when we are handling the data, right? Whether the data is in use, whether the data is in store, whether the data is in transit, right? So I'm talking about transmission over internet. We need to have a security. We need to have the processing security. Obviously, the people who are involved in terms of the processing operations, they need to be trained, they need to be creating awareness, they need to have the kind of ownership or the responsibility, the accountability. And obviously, the malware control, antivirus I'm talking about, even available in our 27001. System updation in terms of any kind of a patch comes in, vulnerability comes in, we need to have a system. Bring your own device policy, which is part of your 27001, right? Today we are all working from home. Huge kind of risk what we are talking about. So how are we going to have the system? Data destruction, right? We need to have the kind of formal evidence. Even today there is a big gap within the organizations when a person leaves or a person is losing the laptop or desktop. How are we going to destruct the data? We are talking about DRP and BCP, Business Continuity Plan and Disaster Recovery Plans to be in place. Incident management, of course, incident management to be interpreted here with respect to privacy breach, right? That's what I talked about in the previous session. 8.17 of your ISO 27001 need to be extended to privacy. Data centralization, where we are trying to keep what kind of access control we have. Data leak prevention. And here also, we recommend as part of our framework, we need to not just trying to gather any kind of data leak with the data leak kind of tools available, we need to identify amount of data. Again, I'm trying to go back to that data valuation what Sir talked about just now, and hardware purchase, sale and disposal, what kind of, from whom you are trying to buy, what kind of contract you have in place, are they being a recognized vendor as part of your purchasing process and so on. Application sourcing, what kind of application, whether it is, we have the same process in 27001 if I am right. Even if you're trying to download any kind of open source software, we need to have a kind of process control, right? Somebody approves it and so on. And last but not least, if you're physical security, obviously the physical and environmental security plays a vital role in taking care of providing the information security and data. So this is in a nutshell to introduce you the 20 controls what we talked about. If you really have a kind of idea about 27001, I'm sure you'll be able to map these controls back to your 114 beautifully. Yeah.
And now I would like to ask Rupak and Srinivas Govind to react to these 20 controls. Now, of course, the numbers 114 or whatever is there in technology, this thing, we are trying to compress it because there could be sub-paragraphs in that. Basically, do you think from what he read out, have we covered a major part of the information security controls is what I want you to respond.
Sure. I think this is the first time I'm hearing, so it's really great.
Yeah, I understand
Yes,
that.
it's very comprehensive, that, it's been mapped to multiple standards and frameworks like you mentioned, and it's been taken into consideration, like you mentioned about like NIST and because those are now a lot of organizations are looking at from cyber and privacy, those frameworks as well in addition to ISO, and ISO is something that they look at as a baseline. So I mean, I think that's very good to hear that we've been able to bring in all and encapsulate it into one particular framework. So
Going?
Yes, as I already told, and from the cursory look which I had a couple of looks into, the DPSI certainly encompasses many controls from 27001 and 27701 also. And finally, he ended up telling that if you know 27001 or if you have been practicing implementation, it automatically, it eases your job of graduating to the DPSCI or the DPA 2021 compliance task, compliance agenda. I uphold it, I endorse it, it's perfect, correct. There are other things like the other standards, like 27018, which is the cloud privacy. These are all things which we can always remain in an add-on position. What you have is the body, and with definitely some good substance. But as you know, this compliance is like running in a moving target. In the sense that the targets always remain moving. So 10 years before what you were doing, you cannot say, okay, I am compliant now, because entirely the landscape has changed. So I think the DPSCI also will change along with the changing landscape.
So a couple of additional points I want to make mention here. We talk of malware control. Okay, now it's also part of our this thing. In DPA 2000 now, it says that any hardware and software which is being used in the processing of personal data needs to have a security certification which will have to give assurance that there are no backdoors or malware inside that. So that is one of the controls which we are recommending. Of course, we have said generally malware control doesn't only mean I have to have an antivirus software. Even in the processes which you are using, you should hold assurance certification for various hardware and software. These are some of the details which consultants will have to develop. See, our standards and implementation specifications ultimately are top line kind of a thing, one below the other. This standard is very broad and implementation specification is one level down. But below this, the consultants we are actually creating the consultants and auditors, two categories. Consultants who will help the companies, even though this is an open standard, still some help is required. DPOs can be trained, DPOs can implement it straight away, or other consultants will have to be implementing. At that time, the templates and other things will have to be run. Many people ask us whether you give a template for this. I say consultants should develop the template so that we will have greater, expertise into this. So malware control is one. Then incident management, another interesting thing in our DPA 2021 is the incident management register may be required to be open to the data protection authority in terms of audit. So that is likely to, this is one of the interpretations we can have in the latest DPA. And when we talk of incident, we have to say that we are talking of incident related to non-compliance of Data Protection Act, which is different from your security incident. Say, in ISMS system, you are having some kind of incident management. Here, is there a likelihood of consent being missed? Is one of the incidents kind of a thing, like that. So whatever we think is privacy related, this incident management register will be slightly different from the system which you are aware of. So which means that whatever standard this thing you are having, you cannot automatically say I have an incident management system. You will have to customize it for privacy controls. Okay. Then hardware purchase and control, we are mentioning here as background control. Now that becomes part of this assurance. Okay. And I told you that this bias audit and other things will be algorithmic transparency. Now, if I am going to use an algorithm either developed by my own R&D department or from outside, I have to hold a certificate saying that the data processing which is done within the algorithm is within the provisions of the Act. So some of these refinements will be the things which we have to do. We have taken this into consideration. That is why I say it is specific to data protection compliance management, because at that time I will introduce that Indian law says this, so you have to bring it here. So this is one thing. Then this 20 controls he read out was all technology related controls. He said that we have got this management, HR, legal and this. The reason is for calculating the data trust score, what we have done is we have given weightage for different departments. See, implementation of this control is not entirely IT responsibility. See, you know that no compliance happens without the top management help. And some help has to come from HR, some help has to come from legal. So we have given responsibility centers. We have created responsibility centers. DPO holds some responsibilities. Out of 50, DPO holds 9, if I remember correct. IT has 20. So I'm not going to make DPO responsible for everything in the organization because it is not feasible. So we are trying to distribute the responsibility to different divisions, which will have different weightages for calculation of DTS. So there is some thought which has gone into this segregation of even this 50, these things. It's not just 1 to 50 kind of a thing. We have created differences. Top management, we are giving responsibility, I think 13 or 12 these things we are giving for top management. It is, they have to develop certain business policies, business associate appointment and these things. I cannot do as a DPO, I cannot do decide who is going to be my vendor. It is the top management will have to give the vendor. So I am going to say these 12 controls belongs to top management, next 9 belongs to DPO, then HR, some 4, legal, to contract management. Now what can DPO do? See, the compliance manager has to see that every contract is vetted. Now contracts are very important because cross-border transfer, we have this standard contractual clauses. In GDPR also it is there. Similar thing we are also having. In our section DPA, cross-border transfer is permitted for personal data without any restrictions. Sensitive personal data subject to keeping a copy. Critical data only in very exceptional circumstances like life danger or something like that. But there is a clause which says that the recipient of this data should not share this data with the government of that country. Okay, there is a new addition in this thing. That is, you can enter into a cross-border transfer contract like a BCR or something like that and give it. But you should put a clause that you cannot share it with your government without my permission. This is actually the same condition which GDPR has imposed us. In the Schrems 2 case, When the EU Court of Justice scrapped the Privacy Shield, the reasons why they did not consider Privacy Shield was acceptable was, one was that the intelligence agency like the FBI can ask for information which is under process, there is no control. If somebody asks, if you are a processor of European data sitting in USA, EU court says that if FBI asks, you will anyway allow that surveillance. Therefore, I am not happy with this. But even in India also, now therefore what this European Data Board said, you enter into a standard contractual clause in which you bind the data importer that he will not share the data with his government, which is an infeasible agreement. See, you cannot resist a CRPC notice or a government notice under Section 69 of Information Technology Act and say, no, I am bound by my privacy standard contractual arrangement, I will not share it with you. This is what GDPR wanted. So Indian government has given a tit-for-tat reply in this data protection latest version, saying that we also will have a same this thing, that the data recipient to whom Indian data is transferred should not share the data with the government, of course without the permission. If you want that permission, you ask the permission with the Data Protection Authority, they will provide. So control of contracts is a very specialized job. It is not just an SLA talking about functionality. It has to take into account these things. Therefore, it is part of the data protection requirements. So an ordinary legal person who doesn't understand the Data Protection Authority cannot manage the contracts in a data-centric organization. So we have therefore said that legal department also has got data protection responsibility. You have to check every contract and assure DPO. See, DPO will only ask the contract person, this legal authority, you please check the contract. I am not a legal expert like you, but you have to give me assurance that it is in compliance with Section 33, 34 of the Indian Data Protection Act. So that is something which we have built in as a legal responsibility. So similarly, HR responsibility, say employee privacy is an important aspect. Say all said and done, privacy applies to employees also. There are various consent exemptions for employees for recruitment purpose, for evaluation of performance. Now, HR people should know where I should get consent, where consent is exempted. I want them to take the responsibility, not the DPO. So, therefore, we have said that some responsibilities is with the HR also. So, this way, in an organization, this framework expects multiple departments to take the responsibilities. That is at the divisional level. In addition, I am saying for unstructured data and other things, I am expecting every individual in their employment contract, we will be asking them that in respect of unstructured data and all, it is your responsibility to bring it to the notice of the data protection officer. We will create structuring the technology. There will be a data custodian, like an internal data controller, and unstructured data should immediately be passed on to him. It should not remain in my email account. You might have sent the email to me, I have to immediately pass it on. So that kind of things which, I don't know, maybe because we are practitioners of data protection, we are thinking of all these things. So we hope as it further develops, we will be able to refine it further. And that is where I am looking at the sectoral partnerships we are talking of, okay. That is a particular sectoral company, if it is interested, we want to sit with them and say out of these 50, when we develop templates, the templates will be specific to that sector. So we will try to develop that, and we will be perhaps having a more focused, say, guidelines, so that, see, we are all said and done, we are creating it at the top level, we will drill it down to the respective these things. Now that is where I need people like Rupak or Srinivas. Let us start looking at this kind of finer developments. Then our effort as FDPPI talking about law is so stringent, you will go to jail, other things, that is one part. But we are actually trying to find solutions. This is the way you have to, perhaps you can think of. And we are not saying that this is the only way. We said that we'll start with something. See, it is always easier to correct things rather than create the first draft in any policy or anything like that. So we have tried to do the first draft. People like Govind and others can always help us in refining it further and make it inclusive of the other known this thing. We have been only a little, you can say, taken liberty in calling it as a data protection compliance standard of India. Okay, that's the only arrogance which we have perhaps taken a little. The idea is that we are so fond of doing something for India. And therefore we wanted to have that particular this thing. Other than that, we are not saying that this is the only standard, okay. Doesn't matter. ICAI started like that, if I remember correct. ICAI started as a private organization and government took over. Now they want to decentralize, that is different. So in fact, if you look at FDPPI objectives, we are very clear that everything is in the interest of the nation. It's added, okay. We want ethical professionals, kind of a thing. So it is inherent. In fact, people like us have come from a certain background. We are Atmanirbhar. It is Atmanirbhar only. So we have done that. But other than that, we want this to be a unified system. Why I am saying unified system is, I am looking at the Indian companies, multiple data protection regulations. We want one unified system, and classification will take care of the multiple laws. That is what we are trying to do. Our classification system is also not simply having 4 categories, critical, secure or something like that. As I was telling in the morning, our classification first starts with the scope, that is which law it applies. And then we come to personal, sensitive personal, critical personal, and other things. So that way our classifications, and also employees, minors, these are all part of our classification system. So we have identified about 16 classifications, okay. So everywhere the data set immediately gets tagged with a particular classification, so that if you are having a system where you can recall something, it becomes easy. And we are also talking about this data centralization. Tagging is also important because we are talking of right to forget, right to erase. Now if a party wants me to erase all his data, I should know where all the data is lying. So in tagging, we want to give some kind of an identification, so that eraser means one button, it should be able to erase everywhere. So you're talking of cloud security and other these things, which is part of the data processor security. In our system, we look at cloud as a data processor. However big, as I told you, Amazon is my data processor. I am the boss as far as that is concerned. I am the data fiduciary, he is the data processor. So we will work on a contract. So most of the cloud control will have to come under defining that. Of course, whether we will be able to audit cloud, this thing is difficult, but at least, say, you know, Amazon has got for HIPAA, they have got a HIPAA separate storage. So if you ask them, they will give you. The only thing is they will say that this will cost more. Tomorrow, Amazon has to create a DPEA compliant storage, like HIPAA storage. We have to force them to do it, which will also mean data localization. They have to put it in India, at least a copy. So what we say, we are only asking for a copy to be kept in India. So they can have a storage wherever they want, but copy to be stored in India. These are some of the finer things which we have built into this framework. Otherwise, it should incorporate all other features. That's why we call it as essence of the essential, but still distant by far. It will include everything which is there in the framework of 27701, which is the immediate framework which we have taken. 17428 system also was similar to this only. We will try to incorporate that, but we will go a little bit ahead, like this data evaluation, DTS score, and distributed responsibility. These are not there in other frameworks. We will try to incorporate that. And we will add this algorithmic transparency and security certification. So there are 6-7 different elements which are not there in other frameworks, but otherwise all the frameworks are there. That is how we have constructed. We have created a system of certification auditors, like your lead auditors who have undergone our DPO training. In the DPO training, people who get a cutoff, above a certain cutoff mark, we are saying that you are eligible for auditors. Rest of the people will be consultants, kind of a thing. We have also created certification bodies. In fact, Dr. Mahalakshmi is one of the persons whose company is a certification body. And we are saying that certification body has to engage the services of one of our auditors as a lead auditor to conduct the audit. And we have a system whereby the audit certificate will be sent to FDPPI. And we are trying to incorporate one more thing, that is, we are getting a feedback from the auditee organization. Okay? Without that feedback, I am not going to register the certificate. Why? Because if there is a difference of opinion between the auditor and the auditee company, we don't want the auditor to take the company to say some kind of blackmail the company, or the reverse way. So we are saying that the company will also send me a feedback how the audit went and other these things, and auditor will also send me this thing. If there is a difference, we will try to have a third audit, a separate audit if it is required. So we want to create a system where the client also is satisfied, okay, and the auditor will be able to do his duty. So this is a whole system which we have created, not yet fully implemented, I can say, but couple of things which I and Ramesh have done, we have used it in the audit process. But as we go ahead, we want to create a group of auditors at every place. Chennai should be one of the places where people like Govind should take the lead. But we want to create this whole ecosystem. Atmanirbhar, let others be there, we will also be there. Okay. Then tomorrow, when it's for the client to decide. For SMEs and MSMEs who cannot afford the larger these things, at least we want to hold their hands. That is the objective. I would like the audit community to help us in this. Now we will close it here and have some questions. Whatever is left out on any of these aspects, if you have got any questions, please raise it now. Your feedback also is welcome. Yeah.
Good evening, sir. My name is Sudarshan. I head the solution engineering for a company called Cloudflare, if you've heard of it. It's the likes of Akamai. So I think from our side, our organization headquartered in San Francisco, we've already started working on DPA because we have local presence here. We serve a lot of banks and stockbroking and digital Bitcoin enterprises, a lot of organizations in India. So DPA is something where we will be the data processor for them, and we've already started looking at how can we help the data fiduciaries actually comply and what is our role in it. So from our side, from our organization, any collaboration on the data processor side of it, we are willing to collaborate. In fact, I was actually looking at it. I would probably even take the online course one of yours to actually start with, and I'm based in Chennai, so any collaboration, I've actually sent the LinkedIn invite to both of you. Any collaboration that is required from our side, and specifically as data processor like Cloudflare, Akamai, and the others of the world, I don't know how willing they would be, but we are willing to come onto the table and start collaborating with you and look and even go to the regulator also to kind of explain them in detail of what we actually do, how the data is actually getting stored, what is the requirement that is needed, and I heading the solution engineering, I can take it back to our engineering team and say, okay, this is what we want as part of data localization. This is what we need to do and comply to actually be in compliance with DPA. So just volunteering and
Thank you.
yeah.
As far as the course is concerned, presently we are having this online course, and then we are trying to create a hybrid model where there is a streaming video available so that it is available on tap, and we will have mentoring sessions on weekends or something like that, so that any doubts and other things which you would have otherwise directly discussed can be handled. We are prepared to conduct a separate course if there are sufficient number of people. So since this was convenient for us, what we did was we have recorded sessions which you can go through several times if you want, okay? And then once in 15 days or once one module is over, you will have an interactive session in which you can raise whatever questions are there, and we will try to answer, so that best of both worlds can be done. But again, that is online. If you want to have physical these things, we want training partners. In Chennai, we want a training partner who can do a physical this thing, because for every training, me or Ramesh cannot come. Ramesh is now, of course, is also engaged in the company. So it will be difficult to conduct, but we are looking at training partners who will be using our material. Maybe initially, people like us will come in the first session, perhaps we will spend time. But second course or something like that, you should be able to take care of. We'll have a training for trainers kind of a situation. We will try to do that. Otherwise, it is presently available on tap. Yeah. Any other questions, either FDPPI or on the subject? Another thing I want to mention is, please don't have complacency that this act will come later. It's part of ITA 2000. In fact, section 43 capital A of ITA 2000 is going to be replaced with this 99 sections of this. So it's a seamless continuation of Information Technology Act. You should look at it like that. So even some of you are consultants to other companies. So please tell them that don't think that the law is not there, wait for this thing. It is deemed as due diligence under Information Technology Act. Okay, and those who are in media business, that is social medias, you should look at yourself as a social media platform. And what the government is telling is that you should have a system whereby you give an opportunity to people to self-identify, like Twitter verification, and you should display it in your messaging this thing. Suppose you are having a messaging app or something like that, okay, WhatsApp kind of a thing, you should be able to implement that verification of the app owner and then identify. Okay, and there is an interplay between this and ITA 2000 in terms of data retention. ITA 2000 has got a minimum data retention of 6 months for most of the things. If there is an app and you register today, tomorrow you delete that app, you have to still hold that for 6 months. Now, in terms of Data Protection Act, we say that purpose is over, whether you should delete it. You should remember that you are answerable both to ITA 2000 and DPA. So therefore, you should not forget that in data retention particularly, Information Technology Act has got certain minimum data retention for 6 months for many of the things. So even though your data protection purpose is over, under the legitimate interest of meeting the legal requirements of Information Technology Act, you have to maintain for 6 months. This is where implementation of DPA compliance will require an understanding of ITA 2000 compliance also. So our new format of data protection compliance standard will have both compliance to ITA 2000 and this built together. Yeah, anything else?
Some of our customers told it's like 6 months. Is that realistic? Or
no, actually the DPC has, the Joint Parliamentary Committee has suggested that there will be a total of 2 years' time, out of which, say once the act has to be passed in the Parliament, then it has to be approved by the President, which will normally take a week to 10 days. Then it becomes a law. Then within 3 months, the government has to set up the data protection authority. They have to identify the people who have to be in the board. Next 3 months they have given for the data protection authority to set up its office and so on. So 6 months. After from 6 to 9 months, registrations will be done. So after that, about 1 year, they have given the timeline that all the provisions will become applicable. But real implementation, they may give up to 2 years of time.
2024 and later.
Yeah, 24 hours is what this GDPR gave. Here, because we are already discussing this for a long time, 1 year should be reasonably good enough. Only the penalties they can defer. My recommendation for the government is, don't start imposing penalty from day one. You implement the act, give notices or warnings, but don't put 100 crores, 10 crores, 5 crores, whatever is that, until 2 years end or something like that. That's what they may try. They may give sufficient time for that. Of course, our education on this is a continuous process. In fact, in FDPPI, we conduct weekly webinars. Okay, we call it as Jnanavardhini programs. In fact, this is also a Jnanavardhini program only from us. We might have collected delegate fees and other things to meet the cost, but basically we want knowledge to be dispersed. This weekly programs of Jnanavardhini is online on Zoom platform. Presently, every Wednesday, 7 to 8, we are conducting that. That is one of the benefits of people who become members of FDPPI. Even if you are not a full-fledged member, we do send invitations to that, because we want this community of people who are aware of Data Protection Act to grow. Out of that, some people will become actual members, pay money. We have got supporting members. Supporting members are the persons who will do collaborative projects on profit sharing basis. Now I said you can be a training partner. If you are a training partner, it is business for you, and FDPPI is an NGO, but still we are willing to enter into a contract with you that you run the program, there is a sharing of revenue. That is an option which we have given to supporting members. We have got this corporate membership, where one corporate member, our membership and all are, in terms of money, it is pittance. Okay, we are not pitching at high level. Corporate member, we are saying 18,000 rupees. I am going to give 3 individual membership equivalent, so that individual members also will get the...
Sir, not 18.
18.
Oh, yeah.
18,000. Okay, out which will register 3 persons as representatives of the company who will be eligible for these personal services, and we are going to give whatever services we are giving at a very concessional rate to that corporate member. So basically we are a down-to-earth organization. Some people don't like it, but I have been an ex-banker from the commercial, old banking, that's a nationalized banking kind of a scenario. We still think customer service is the best kind of a thing. We are not fully commercialized. But anyway, this is how you can all contribute to this. This is a movement of the data protection professionals. Please write it down in your this thing. This is of the people. Where is Rajendran? I don't know. This is the quotation which I gave for SIC at one point of time, Cyber Society of India, of the people, by the people. Like that, here it is of the data protection professionals for the data protection community. Okay. So we want to do as much as possible to this community. Even before the Data Protection Authority comes, when the Data Protection Authority comes, perhaps we will be trying to get accreditation and other things. If that gives us some extra benefits, we will see. So what we are doing now is actually prior to this. In fact, every member of our organization who has become a member in the early stages with 5,000 rupees life, membership, he has got trainings and other things worth 20,000 rupees or something like that. So we have actually paid back the membership through the training fees. Only new persons have come, they have paid for the training. That is how it rolls on. We will be happy if that situation continues. Okay. Yeah.
Between me and these two people, there is always a competition in the sense, that may get born. They are from Bangalore, and I always think that Chennai happened to be the pioneer in many of the IT, activities, IT business, IT profession and all. And we should prove now that, in this area also, this is a big number today, to be very frank. It's a big number today. And that it's not easy everywhere, it is not possible to bring in this many number of interested people, and at 5 o'clock being present even now, really 60% of the people present now. The credit goes to Chennai. I am a proud Chennaiite, so please, uphold Chennai's, ability to take part in these kind of noble missions, because this is what Atmanirbhar all about. In the sense, that we can write so many examinations, etc. But the money that is collected by FDPPI remains in India. Nothing, no, in the sense, insult on any organization, but we need to prove. We are now members of so many organizations. We work for many other organizations that have got their headquarters elsewhere, etc. But FDPPI is an Indian organization. This is an Indian initiative, and we are all Indians. And Chennai has to prove that it has the power to, it has the potential to power FDPPI to greater heights. And for that, one thing is that membership, and number two is that attending these examinations along with me when I am going to write, you also will write, because I am into the business and I need to travel, I need to do a lot of handle, but I will be writing along with some of you. So we can also meet, and then we will not be competing with the training service provider, but we can always meet and have over a cup of tea, we can have a discussion and on specific issues, whatever that is happening, we can do that. And we can also attend to that Gyan Mardini together in a single venue, we can attend that. All that, we can be little innovative, and this one is a rising opportunity in that we should not miss. Information security is not a law so far. IT, you've got a law, but information security in its entirety is not a law. But data privacy is going to be a law. Data protection is going to be a law. So, which side of the bread is better, thick? How big is the burger? Please see, and then grab your burger, be happy. Okay, and then participate in the FDPPI activities. In Chennai, we can do something, and whenever possible, they also can come and engineer further innovation, growth, etc. And we will prove that we are second to none from Chennai. Thank you.
Thank you. And I should definitely thank Captain Vijay Kumar. When we proposed it, he quickly said we will use our auditorium, because without that, we would not have made the further progress. Once he assured that, okay, we will make it a joint program, then we proceeded further. We need that kind of open-hearted support.
Madras Management Association's way of conducting really thrilled me in the sense, that they suck in them in other agenda also and make it as a kind of a black hole. Suck in other agenda wherever. So I thank my colleague Manjula, but for her I would not have come prepared so much. Hopping up here and there. She stayed with me and said, nothing doing, you are with me, and I'm going to be running you through. And yesterday, day before yesterday and all, she sat with me, we had a brainstorm. Okay, so I come from a small company, okay, Paramount Dataware, and I'm an activist for FDPPI, which means that, palanquin bearers.
And I should thank Vaidi also for bringing Isaka participation, which was very, very helpful. Sridhar and Balu is there. Of course, they are my friends, and they think SAISI is my own organization. So, I'm the founder trustee of SAISI. So, it's a cooperative effort of all these people which makes such events a success. We hope we will have more occasions like that. Thank you. Yeah.
Just stay for a moment. We'll have a national anthem. This is such a good event. We should end with the national anthem. Thank you, ladies and gentlemen. Thank you, Mr. Navi. I think big round of applause to Mr. Navi. I got a tremendous energy that shows the passion. That is what made us collaborate with Navi. Whenever Navi says you want to do something, we just say yes. Because very rarely you get a passionate person who really drives home such a beautiful thing. Thank you so much. And to end, can I have the national anthem, please, for the evening? Yeah. Thank you, ladies and gentlemen. Stay safe. Keep wearing your mask. Till we meet again. Bye-bye.